Court officer, madam. Court officer, madam. Hello, court officer, madam. ಹೇಳಿ ಸರ್ ವಾಯ್ಸ್ ಬರ್ತಿರ್ಲಿಲ್ಲ ಕೇಳಿದೆ ಥ್ಯಾಂಕ್ ಯು
ಬರ್ತಾ ಇದೆ
ಥ್ಯಾಂಕ್ ಯು ಸರ್ ಥ್ಯಾಂಕ್ ಯು
ಏನಕ್ಕಪ್ಪ 230
without giving executive permission, to share that regular should be there is obligation to the village.
ಯಾರು which panchayat ಯಾರು ನೋಡಿ yes Mr.
Petition what had happened was 2021 we got a we were constructed. Who will not sites away? They will not made a claim saying that part of it is there. File is civil suit. That will not initially they filed as civil court. Then it got transferred to the commercial. In the commercial court, not specific order, no status court. IA will hear the IA. IA will not is being heard. In the meanwhile, they would not building has come up to about the 800 151. Corporation they go over corporation says stop on further construction. Because 151.
Mr. Pawan Kumar, you can serve it on Mr. Pawan Kumar. Get instructions. Tuesday, give it. Tuesday it will come, give it. Only for afternoon you mentioned.
My lord, I'm filing a memo for withdrawal, serial number 24, list 1. After last hearing, I had a thorough discussion with my client and found that he had left out on telling me a few things. At this point, I'm extremely embarrassed and apologetic to have taken up this honorable court's time. And I beg your lordship to allow me to withdraw this petition with liberty to file a new one if required, my lord.
The act of getting details from your client itself is an act. Anyway, it's being withdrawn. 24. Counsel for the petitioner has filed a memo for withdrawal dated 14/9/2023 signed by the counsel for the petitioner. He submits that she has been authorized on behalf of the petitioner to withdraw the above petition. Accepting the said memo and submission of the learned counsel, petition is dismissed as withdrawn. Pending IA stands dismissed.
Number 5, serial number 29.
30. Next page.
Number 6, serial number 33 to 39.
You have informed the petitioner?
Yes, sir.
When will you file it? There are a lot of this 2 weeks coming up. A lot of objections to be filed in the last week. Are you preparing them?
Yes, sir.
You should be preparing them, not senior. We'll see. Drafted by Counsel for respond number 2 seeks for and is granted 2 weeks time. Need to file a statement of objection. Objections, if any, to be filed on or before 4th October, relist on 11th October. Take objections. 36, counsel for respond number 1 and 2 seeks for and is granted 10 days time to file the statement of objection. Objections, if any, by 3rd October, relist on 6th October.
Page number 7, serial number 40 to 45.
I will inform 44. Why do you want time? Counsel for the petitioner seeks and is granted 2 weeks time to obtain instruction. A week's time to obtain instruction, make a submission. Relist on 26 already 130 matters of this. 26. ನೀವು ಯಾರಿಗೆ ಮಾಡಿದ್ದೀರಾ? 45, the request of the counsel for the petitioner released on 6th October.
Page number 8, serial number 46 to 48.
Serial number 47. Petition argued some more time is required for research work. I got 2 or 3 judgments. More required. Efforts is required in that. Because this honorable court judgment only is there with respect to the cancellation of state litigation. But with respect to the Unam Abolition Village Officers Abolition Act, I need some more research.
47, learned counsel for the petitioner submits that
I already informed others.
seeks for 2 more weeks time to conduct research, get ready and make a submission. Released on 6th October. It is made clear that no further agenda to be granted. Interim order earlier granted is extended till next year.
Page number 9, serial number 49 to 57.
56, my lord.
Consent to the 1 week, only 1 week.
Chief officers transferred, madam. Chief officers, at least 10.
All chief officers have been transferred. 50. At the request of learned counsel for respond number 4. Counsel for respond number 4 seeks for and is granted 2 weeks time finally to obtain instruction, make a submission. If submissions or objections are not filed by 4th of September, the same will be taken as not filed, released on 6th, the 4th of October.
Serial 56, my lord.
Yes,
I am for the respondent. Other side, ಹೇಳಿದೀನಿ ಸ್ವಾಮಿ 2 weeks accommodation ಮಾಡಿದ್ರೆ objections file ಮಾಡ್ತೇನೆ.
Objection file ಮಾಡಬೇಕು.
House objection ready. ಅಲ್ಲ ಡಾಕ್ಯುಮೆಂಟ್ ಅವ್ರು ಕೊಟ್ಟಿದ್ದಾರೆ, ನಾನು objections ಹಾಕ್ತೇನೆ ಸ್ವಾಮಿ. ನಾನು objections ಹಾಕ್ತೇನೆ. ಅದು ಬೇರೆ subsequent filing petition ಹಾಕಿದ್ದಾರೆ ಹಂಗಾಗಿ.
Counsel for respond number 1, 2, 3 seeks for and is granted 2 weeks time to file a statement of objection. Objections pending by 5th October, released on 10th October.
Publish, my lord.
Learned counsel for respond number 1 and 2 seeks for and is granted 2 weeks time to file a statement of objection by 5th, released on 10th.
Serial number 45.
ಅವ್ರಿಗೆ inform ಮಾಡಿ. 29.
Page number 10, serial number 58, 55.
Serial number 60, Manoj.
Yes,
2 weeks, Manoj.
have you informed?
Yeah, I informed the other side.
60 as a request of counsel for the petitioner, released on 6th October.
Interim order may be extended.
Interim order earlier granted is extended next.
My lord, serial number 64, my lord.
Yes,
Objections are really intimate made in 2 weeks accommodation. Some objections ready the file martin.
before counsel for respond number 1 and 2 seats for is granted 2 weeks time, 5th, 10th.
16.
Hmm.
Inform the particular allocation of then the e-Khata, writing, so that we getting another. What's been adjusted for 2 weeks.
E-Khata second.
Modification plan there.
Counsel for, you applied now.
E-Khata not certified, I'm getting another one. That I submit.
Counsel for the petitioner, seats fund is granted 4 weeks time, relist on 26th October. Interim order earlier granted is extended.
Serial number 64, my lord, that's already indicated in wanted by.
64 you will get adjourn aitala. 10th.
Case number 11, serial number 66 to 74.
Hmm. Respond number? HL Pradeep Kumar. Inform Mr. Narasimhan. Will Allah, have you informed? We'll grant you time without information we want.
Serial number 71, my lords.
Yes.
Well, in the connected matter, my lord, I have instructions, my lord. I pay for 2 weeks time, my lord, in the 2023 matters, my lord. 2 weeks time, my lord.
Informed everybody.
I inform Mr. Jaikar Shetty, my lord. Well, he's not every time asking, my lord. I mean, in the connected matter 2023, he has supplied the copy. He has got objection, my lord. I will get instructions, my lord. I'll file additional documents also. 2 weeks time. Next time, I assure that, well, I will not take time.
At the request of Shri S.K. Acharya, relist on 26th October, it is made clear that no further adjournment would be granted.
Please, my lords.
Have we informed the respondent? 69 at the request of counsel for the petition relist on 29th.
Case number 12, serial number 75 to 80.
I've informed the restaurant.
77 at the request of counsel for the petitioner relist on 5th October.
For these purposes, serial number 1.
I apologize, my
Prayer B, prayer C.
prayers. I'm heading memo to that.
This case, 16. But
Last time B ಅಂತ ಕೇಳಿದ್ರು annexure B ಅಂತ annexure B ಅಲ್ಲ annexure C ಅಂತ ಇದೆ.
graves.
ಹಾ.
Prayers.
Liberty to challenge the order passed by respondent number 4 at annexure at prayer C.
Yes.
ಅದು reply and request. So you won't B ಇಲ್ಲ ಅಂದ್ರೆ C ಏನಾಗುತ್ತೆ?
ಅಂದ್ರೆ ನಾನು representation ಕೊಟ್ಟಿದ್ದೀನಿ. ಆ representation ಅವ್ರು consider ಮಾಡ್ಬೇಕು.
Once there is a order passed against you,
Yes.
can they consider your representation?
That order has to be challenged by me, there is a separate petition. Allon petition, Indian petition ಆಗ್ಬೋದು ಆಗತ್ತೆ ಅಂತ ಅದಕ್ಕೆ ನಾನು ಇದ್ರದ್ದು I am seeking the liberty to.
You are going to file a fresh petition challenging, seeking for prayer B.
No, madam, because the notice has been issued, it has become influential by which you are passing the order.
After this,
After this, but, after the interim order, they are violated and this petition becomes influential.
so there is a fresh notice issued after 13/7.
No, madam, it is a fresh order has been passed,
When
that is on 28/7/2023. I have to challenge that order, madam, but regarding this prayer, madam, it is in this
if there
petition.
is an order passed, can they consider your representation? After the order is passed, it virtually judicial jurisdiction.
Earlier I have filed this representation, madam. Meanwhile, they are issued notice, madam, then that is the reason I have given the explanation along with this prayer.
along with this Annexure C representation to consider my case for
Mr.
5 years.
Shetty, now there is an order which has been passed on 28/7.
Correct.
Once an order is passed, they are functus officio.
That is right.
We cannot direct them to consider a representation submitted post the order.
But my lord, in this is my lord filed earlier, but my prayers before this honorable court, my lord, for consideration of this.
All that is over with this 28/7, it merges with 28/7.
But my lord, the problem is, my lord, if I withdraw this petition pertaining to this also.
Hmm.
In that petition, my lord, what happens? They have already passed orders against me by granting the toilet maintenance in favor of the respond number 4 in the, the petitioner in the other matter.
What is Annexure R?
Annexure R.
Page number?
That is page number 77.
So, based on the credit and the complaint by the also
So this letter dated 27/6/23
Yes,
has been considered by you when you passed the order date 28/7/23.
Petitions of notice and connection APC for presentation after completion of this period. So we have passed the considered order along with his proceedings also. Right?
Then we can
my lord, here, if I withdraw,
challenge 28/7.
I'll challenge my lord, but my
Let you challenge my order. So,
But we cannot allow you, direct them to consider representation given
My-
prior to it.
I understand, my lord. My prayer is, in that,
proceedings.
that order, my lord, that order is, I'll challenge that order, my lord. If I don't, because my lord, the ground for challenging that order itself is this consideration, my lord.
Non-consideration.
Non-consideration.
You blame that.
When, my lord, if that petition,
So if we direct them, then you won't have that.
my lord, I'll withdraw it, my lord, because only, my lord, my prayer is, my lord, it is only seeking liberty.
We cannot grant that, Mr. Shetty. Once an order is passed, we cannot grant.
My lord,
The matter is posted for being spoken to. Shri Vijay Shetty, learned counsel appearing for the petitioner, would submit that in the memo filed earlier on 8/9/2023, by inadvertence, prayer B was asked for reconsideration by the respondents. Hence, a new memo has been filed dated 15/9/2023, seeking for withdrawal of the above petition, as also seeking for permission to challenge the order date 28/7/2023, which has been passed subsequent to the filing of the writ petition WP 16219 of 2023. In the said memo, a direction is also sought to respondents to consider prayer C being a representation dated 28/6/2023 at Annexure R. The I have the considered opinion that relief seeking for consideration of the representation dated 28/7/2020, 27/6/2023 cannot be granted, since a subsequent order has been passed on 28/7/2023. And as such, a consideration of representation submitted prior to the order being passed cannot be ordered by this court, since the said authority is rendered functus officio. If the representation dated 27/6/2023 is not considered, that would be a ground for challenge of the order dated 28/7/2023, and no direction could be issued at this stage. Faced with the above situation, Shri Shetty submits that he would withdraw the above petition with liberty to challenge the order dated 28/7/2023. Reserving such liberty, the petition stands dismissed.
One submission. If I file that read petition, Maharaj, if this prayer is not sought, Maharaj, in that read petition,
Allah, that is your ground for challenge.
please, there is a ground, Maharaj.
That is your, we can't direct them. They are
No,
not
Maharaj, my
reservation.
prayer is only with, allow me, permitting me by this court, seeking permission from this court to make that as a ground. Because Maharaj,
You don't need to ask our permission. You can make any grounds that you want.
otherwise, Maharaj, this petition becomes survive.
That's
But
what you observe that that would be a ground. We can't give you permission like that. Naman ಕೇಳ್ಬಿಟ್ಟು ಎಲ್ಲ grounds raise ಮಾಡಿದ್ರೆ ಹೆಂಗೆ?
Done 8-9 of things.
The order of dismissal.
This matter. Question for gas go down. That has given permission from 2015 to 19.
Hmm.
And page number 89. Cancer, is that there is a number of restrictions also within the locality.
The order date 19/9/2016 is cancelled.
Cancel by election army. That is under challenge in this petition. Now the license expired. If they are not constructed, they can make an fresh application for that.
Mr. Raju,
Page 39 is the license issue.
your contention is it is rendered infructuous.
Yes, 22/6/2019 is expired.
None appears for the petitioner. The Ashok and Naik learned counsel for respond number 1. Who accepts notice for respond number 2 to 3 also. Submit that the above petition has been rendered infructuous. For the say of the petitioner, released on 4th October. Despite the order dated 14/8/2023 and 7/9/2023, none has been appearing for the petitioner. It appears that the petitioner is not interested in prosecuting the above matter. Petition is dismissed and non-prosecution.
I appear for the petitioner in serial number 4 and 5, my lord. I seek to withdraw the petitions as they have become infructuous.
Which name? Learned counsel for the petitioner has filed a memo dated 5/9/2023, seeking permission to withdraw the above petition as it has been rendered infructuous. Registry has raised an objection that the petitioners have not signed the above memo of withdrawal. The D. Banu Pradeep, learned counsel for the petitioner, submits that said memo has been filed at the instructions of the petitioners.
Yes.
And authorized to withdraw the said petition, the above petition. Accepting the said submission, office objection is overruled. Accepting the submission of the counsel for the petitioner and the memo, the petition is dismissed as withdrawn.
ಇಲ್ಲ ಹೈಕೋರ್ಟ್ ಅಲ್ಲಿ ಮ್ಯಾಟರ್ ಒಂದಿದೆ ಆನ್ಲೈನ್ ಅಲ್ಲಿ ಇದ್ದೀನಿ ಆದ್ರೆ ಒಂದು ಶಾರ್ಟ್ ಡೇಟ್ ತಗೋ ಇಲ್ಲಾಂದ್ರೆ ಪಾಸ್ ಓವರ್ ಆಗ್ಲಿ ಆಮೇಲೆ ನೋಡೋಣ. ಓಕೆ
Same. Grateful.
Here, let me put the rating. The respond is 1 to 3. Okay.
40 feet. And road measure ಮಾಡಕ್ಕೆ 40 feet we cannot.
It's not the main road.
Main road ಅಂತಾರೆ. Submission of Mr. Reddy is it is Belandur Sarjapur main road. Yav produce ಮಾಡ್ತೀರಾ? Inspection has been done. The counsel for response submit that inspection has been done and the sketch prepared. She seeks for sketch is being prepared. She seeks for
ಅವ್ರು 11.50 ಅಂತ ಕೊಡಕ್ಕಾಗಲ್ಲ ಅಂತ ಎಲ್ಲ ತಿರುಗಿನು they have given for the 12.
She seeks for and is granted 2 weeks time to produce the same. She is also directed to make submissions as to whether any other permissions have been granted to the neighbors of the petitioner for construction, and if so, what is the road measurement taken into consideration for such construction? New place ಮಾಡಬೇಕು ಅವರಲ್ಲ. Released on 3rd October.
Number 7, EWPS.
Yes, madam.
May I please your lordship? Lordship, all the objection has been complied with except for the three submissions may be taken on record. With regards to annexure A and B, an IA for dispensation has been filed. With regards to annexure H, the petitioner is not in possession of the document. Rather, the document is in custody of the respondent.
Annexure H is at page number.
H is in page number 70 to 82.
Annexure H is a sale deed. You can always get a certified copy.
And with regards to annexure B, my lord,
It is as regards illegal construction or unauthorized construction. How is your construction? Have you put up any construction?
not aware of. Yes. With regards to annexure B, I would like to submit a memo because it could not be stitched with the main petition. These are the plans, so we will be taken on the.
And counsel for the petitioner has filed a memo along with copies of annexure B. The same is taken on record. Office objection in respect of annexure H is overruled. Shri Pawan Kumar accepts notice for respond number 2, 3, and 4. Issue notice to respond number 1, 5 to 12. You modified the plan, reducing the undivided interest. You modified the plan, reducing the undivided, which you can't do. The operation of the plans at annexure A and B are stayed till the next date of hearing.
For annexure A and B, my lord, IA for dispensation as well.
Released on 10th October. Issue notice of returnable by 30th October. Counsel for the petitioner to furnish 2 sets of the petition along with annexures, including copy of the memo.
Number 8, Chandra.
1,333 rupees, you are wasting a lot of time. Seems to be something amiss. The counsel for respond number 1 to 4 seeks for and is granted 2 weeks day and finally to make a submission released on 4th October. If submissions are not made and affidavit not filed, adverse inference would have to be drawn.
Number 9, Gautam here.
Why? You will also have to give us if there is another inspection done by authorities. In that writ petition, there's been a direction. And you issued the circular. Have you been carrying out the inspection of the buildings under construction? What has happened to that? We have passed that order in another matter, so we'll pass the same. The B.S. Karthikeyan Learned Counsel for Respond number 2 submits that on account of the transfer of the incumbent official, the inspection could not be conducted. He seeks for and is granted. He seeks for a fresh date to be fixed for such inspection. In that view of the matter, the fresh inspection shall be conducted on commencing at 10:30 a.m. on 20th September. A report to be filed on or before 29th September, released on 5th October. The report to contain following. Amendment. ಮಾಡಿದೀರಾ ಅಮೆಂಡ್ಮೆಂಟ್ ಮಾಡಿದೀರಾ ಇವಾಗಲೇ ಮಾಡಿ Yes, madam, what happened?
Hello. Help us. Hmm.
65. We'll take it up along with 65, pass over. You carry out the amendment.
Okay, right. ಅಲೋ ಮಾಡ್ತಾರೆ ಅಲ್ಲೇ ಇದ್ಬಿಟ್ಟು ನೋಡಿ.
The second time you are coming before us. ಎಲ್ಲ ಇದು ಪ್ರೋಸೆಸ್ ಫೀ ಕೊಡೋದೇ ಪ್ರಾಬ್ಲಮ್ ಆಗುತ್ತೆ. We'll impose cost. Otherwise we'll dismiss it. Which one? You are the counsel on record. You have to pay the process fee. If you don't pay the process fee within the time given, then you are, for lack of you not doing it, you pay cost. No andre dismissal ಮಾಡಬೇಕಾ ಕಾಸ್ಟ್ ಕೊಡ್ತೀರಾ ಹೇಳಿ. ನಾಲ್ಕನೇ ಸತಿ ಬರ್ತಾರೆ ನೀವು. First 3 times we did not say anything. The 4th time you are coming. Every time you don't pay. No. First time ಈ ಮ್ಯಾಟರ್ ಅಲ್ಲ, ಬೇರೆ ಮ್ಯಾಟರ್ಸ್. Constant trial history. That counsel for the petitioner submits that by inadvertence the process fee could not be paid within the time fixed. Though there is no excuse for the same, the same is accepted on the condition of making payment of cost of rupees 500 to the advocates clerks benevolent fund. Registry is directed to issue notice to respond number 4, returnable by 25th October. Inspection ಏನಾಯ್ತು Mr. Reddy? File ಮಾಡಿದ್ದೀರಾ? When was it filed? So what have you done after this? Two 248 1 17/7. 248.3 is also done. Now what? 248.3 was 38. 38 ಆಗಿದೆ. Then what is to be done now? ADTP has done it. The counsel for respond number 1 to 3 has filed a compliance report dated 10/9/2023 enclosing the field inspection report, sketch of the property, as also notices issued under section 313, section 248(1), 248(2), and 248(3) of the BBMP Act 2020. A perusal of the said notices under 248(1), 2, and 3 indicates that the said notices have been issued by the ADTP and not by the zonal commissioner. Learned counsel for respondent number 1 to 3 seeks for and is granted 2 weeks time to learned counsel for respondent number 1 to 3 submit that they will redo the proceedings by issuance of proper notices through the zonal commissioner. This submission is placed on record. Issue notice to respondent number 4, returnable by 26th October. And what is your submission on office report? This objection will have a new amendment submit. Pass over.
Yesterday, 8 hours I have board. Whether I have dispensation application is ready, and also state after financial year, I will put it.
Learned counsel for the petitioner. Good. As filed an application for dispensation of production of
Mr. gave us
certified copy of annexure A.
subject number 7. The relevant portion of the
Since the same could not be obtained in time for filing of the above petition. 4 weeks time is granted to the petitioner to apply for, obtain and produced the certified copy of annexure A. Once office objection at sale number 1 is kept in abeyance. A memo has been filed enclosing the typed copy of annexure A. Since hence office objection at sale number 2 stands overruled. In view of the order passed in WP number
20342
203
after
2023, the resolution on subject number 7 in the meeting held on 28/8/2023 by the 4th respondent Ram Panchayat at annexure A is stayed till the next date of hearing. Connect the above matter with WP so and so. Sorry, notice. That AGA accept notice for respondent number 1. MS Devraj for respondent number 2 to 5. Counsel for the petition serve 2 sets of the petition on the said councils
where they are going to.
and delivery.
There is a IS number 14. Yes, sir.
Yes, Mr. Shekhar. Paso, Madhyana Bhatt.
My lords, I appear for petitioners in both the matters. We have to seek instructions. The petitioner is unwell. She's been in the hospital, my lords. Therefore, 2 weeks time may be granted.
Counsel for the petitioner submits that the petitioner is unwell and as such he seeks for 2 weeks time to obtain instructions and make a submission. Released on 6th October.
Much of.
I filed 2 applications to get completed. The petitioner, the impeding applicants are the document.
What about the impeding application, Mr. Sridhar? Any objections?
My lords, we haven't filed any objections so far, my lords, because the instructions came. They are also one of the co-owners in the property.
So we'll allow them to come on record.
Please.
IA 1 of 2022 has been filed by certain co-owners of the property to come on record. Joint owners of the property, joint owners are co-owners are
Co-owners.
in your family members, joint owners of the property, subject matter of the above dispute. Our subject matter of the above writ petition. In that view of the matter, they being necessary parties, IA 1 of 2022 is allowed. The person named therein are brought on record as petition number 3 and 4. 15.1 only.
Same.
3 and 4, right? 15.1 only, 3 and 4. IA 1 of 22 is allowed.
Much of. We'll carry out necessary amendments.
Also for the petition, carry out necessary amendment, file number first.
Much of.
Regard to dispute between two persons, removal of the action 3. Last time.
Jackfruit injection.
That last time I did a copy of main ground is forest department had issued notice to us that it is dilapidated condition. When of that we have issued notice under section 34. Other than section 34, we have no other problem. Now we have filed an IA stating that they are sent to some chemical examination. They have given a report that
It is live and.
but that report, nothing is there, only there it is a good condition. Keep it.
Good condition as a sakala, Indian weapon.
Good condition andre, it is there, they can regenerate it. So let them re-examine the matter at this forest department or notice.
So forest department had told you to issue the notice.
They have accepted this court and send a letter to.
Forest department is not a party to this proceeding.
No, not for a letter difficulty.
Acharya,
Well, forest department, my lord, it is they themselves, my lord, they approach the forest officer without notifying me, without informing me, they themselves got the report. Just to see that, my lord, they want to.
recommendation has been made by the forest department, on which basis the panchayat
No,
is
because
acted.
this, my lord, the respondent number 2 has simply approached the forest department. I don't mind, my lord, making them as a party. But my forest department has neither issued a notice nor called upon me to say anything.
Basis do
Because,
you
my
say
lord,
that? On what basis do you say respond number 2 is approached the forest department?
yes, my lord, respondent number 2, my lord, on this, my lord, the complaint, my lord, the forest department has, my lord, they visited the spot without
It is not
notifying.
the respond number 1, Allah, Mr. Acharya.
My lord, respondent
Respond
number
number
2,
1
my
is
lord.
the panchayat. Respond number 2 is a private party.
Yes, respondent number 2, who is the complainant before the panchayat.
So he filed a complaint, forest department directed the panchayat issued the notice.
Yes,
Now you got the report. So now on that basis, it will
report,
be
my lord,
have to examine.
my lord, report is in the sense, my lord, the tree has been poisoned, my lord. That is why, my lord, I was compelled to take the root example before the scientific
Are we
laboratory.
competent to decide on that? We are not
My lord,
competent to
the fact
decide on
remains is, my lord, if there is any role of the panchayat, my lord, to see that, my lord, the tree is to be saved, my lord, they again, my lord, they will slap upon me the notice, my lord.
Panchayat also is not competent. As we are incompetent, they are also incompetent in this matter. You'll have to go to the forest department. They will have to examine whether your report is proper or not, whether the tree survives and it's L and RT, all that the forest department will have to do.
My lord, may I make one submission, my lord. Let this matter be kept pending, my lord, because I will approach the forest authorities afresh by bringing to their notice about the subsequent developments
So
with
we'll
regard to
avoid-
the report, as well as, my lord, one more recommendation is not required, my lord. I will approach the forest authority, my lord, let the tree not be damaged or, my lord, demolished, removed, my lord.
Yeah, Ashok and Naik, 11
Because
council.
that tree has to be protected.
Yes, that is why we have granted the stay also.
Please, my lord.
Mr. Ashok and Naik, 11 council, respond number 1 submits that the report now produced by the petitioner would have to be examined by the forest department. Since it is on the instruction of the forest department, which was on the basis of a complaint filed by respond number 2, that respond number 1 panchayat had issued the notice dated 14/7/2022. Shri S.K. Acharya, faced with the above situations, submits that you would approach the forest department and furnish the copy of the report.
All the necessary documents. With regard to the life of the tree, my lord.
As regards the status of the tree in question for the
Please.
forest, for the concerned officials to consider. he seeks for and is granted 3 weeks time to report the outcome. Reserving such liberty.
Please, my lord.
Shri S.K. Acharya to produce the report and documents before the concerned authority, you shall consider the same.
My lord, please, my lord. Third week of my lord, second week of October.
30th of October. The interim order.
Please, my lord, grateful.
Continue till the next date of hearing.
Please, my lord, grateful.
17.
Mr. Rao?
Yes, Your Lordship.
Yes. What is this application you have filed?
Your Lordship, I have made a RTI before the BBMP jurisdiction officer where it says that the desilting has not happened of the rain drain from past 5 years, Your Lordship. That means that the Chapadikal, which is above the rainwater drain, serves the footpath and it's still unfit, Your Lordship.
You had filed a public interest litigation for this. What happened?
About
public interest litigation hakilwa ನೀವು?
ಇಲ್ಲ sir.
Yes, Mr. Reddy.
And this particular footpath is in a very bad state, Your Lordship.
All footpaths are in bad shape. Yes.
Our office ಮುಂದೆ ಸ್ವಚ್ಛವಾಗಿ ಇಟ್ಕೊಂಡಿದ್ದಾರೆ ಸಾಹೇಬ್ರೆ.
Produced an order in WP number 7363 of 2021 filed by you.
As well as 1375 of 2020. Page number 4.
Yes.
The bottom shows number 3. Parallel proceedings before this honorable court as well as the Supreme Court.
Yes.
Thirdly, if your lordship be next to happen.
Para number 7.
7, that is page number
Yes.
7.
Yes.
Imposing cost of 50,000 of the petition. And all this, my lord, is for a particular reason, which arises out of the judgment which are produced at page number 7. And the second order passed in WP number 13975 of 2020. And if your lordship may kindly see para 2 of the judgment.
Yes.
So the small shop of the cobbler. What inspection was carried out by the BBMP and the shop owner was directed to produce the document. Shop owner has produced documents issued by the Deputy Revenue Officer, Corporation Bangalore dated so. And the same reveals that the cobbler shelter was allotted to the so-and-so cobbler. The cobbler shelter is in existence for the past 40 years, and right now his grandson is there in the cobbler shelter. My lord, I may skip the remaining contents. Your lordship sees para number 4 of page number 14. The reply of the BBMP also reveals that the petitioner had filed one more writ petition bearing number so and so, where he prayed for an order of demolition and removal of road encroachment and the same was disposed of. The writ petition further reveals that another writ petition preferred number so and so for removal of mill food, and the same was dismissed by this court by an order dated so. Another writ petition was prepared by the petition number so and so for a direct the respondents there to stop and prohibit the skywalk in Narsimraj Colony, main bus stand at BBMP ward number so and so. Arrow number 5, my lord. The last line. The petitioner wants the sole source of livelihood of the cobbler and his family who is there for generations to be closed up. The petitioner has stated in open court that he is seeing the cobbler shop every day, every morning where he goes for a walk. This court really fails to understand as to how the cobbler shelter is affecting the petitioner's health merely by seeing it every morning. I skip the remaining portions.
Because that is something you have to answer. You have not taken care of upliftment of that
Yes,
person.
that is one.
Hmm.
Now, keeping aside that and coming to this petition at all. If you also may kindly see the prayer which is produced, it is at page number 14 of the petition. The prayer aim to make footpath fit with handrails in Tyagaraja Nagar Press Block, 1st May, DPP Ward number 154, as the same way which is done in Annexure A, A1 and F1. Now, if you also may kindly see what A1 and F1. Hello. These are the bollards which are placed on
Yes.
these bollards. Now, if at all the report, my lord, which I produced, shows the photographs of the footpath in front of this house. That is at page number 9 and 10.
Nine and 10.
9 and 10.
Yes.
Of my report.
Your Lordship, I haven't got a copy of the.
The Kotila copy. Yes, the photographs which have been produced by the petitioner, Mr.
My lord.
Photographs which have been produced by the petitioner indicating.
No, the photographs which are produced by the petitioner are not the photographs in respect of the footpath in front of his house. He wants the footpath in front of his house to be maintained in the same manner in which he has produced before this honorable court has annexed. If your lordship may kindly see Annexure A of his repetition.
So this is his house, 10 and 11 is what you're saying.
In my report, my lord, at page number 8 is his house. In my report.
Page number 9.
9 of my report.
9 and 10.
9 and 10, yes.
Hmm.
So he wants this footpath to be brought to the same standards as in Annexure A of his writ petition.
And the photographs which have been produced are not relating to his property, but are of other properties.
Please, yes, sir. Please submission, my lord.
This requires, there is merit in the matter.
My lord, there is-
Street vendors will have to be rehabilitated.
My lord,
The street vendors have to be rehabilitated.
please, my
Your Lordship, I pardon me if I'm intruding. Your Lordship, Ali Jaga is Swami, or the commercial property there where they can be relocated.
Mr. Prashant, the
Your Lordship.
relief that you have sought for is not only with respect to your property, but the entire area.
Your Lordship, but
It cannot
only,
be a private list, it has to be a public interest. We don't have jurisdiction, you'll have to go before the PIL bench.
Your Lordship, in that case, I would take directions and I would follow the PIL. I'll file this as a PIL, Your Lordship.
Direct the registry to place it before the roster bench. Where counsel for respond number 2 has filed a memo enclosing certain judgments. He is directed to furnish certain documents. He is directed to furnish a copy thereof to the petitioner party in person, which can be sent to the said party in person by way of email, as shown on the presentation sheet of the petition. Airline Men 1999. Nice email ID you have, Airline Men.
I used to be working for Jerevel, Your Lordship.
999@yahoo.com and to the The perusal of the release which have been sought for and the documents produced along with the petition indicates that the list is not strictly a private list, but a public list, As such, registry is directed to place the matter before the. As such, the petitioner, party in person petitioner undertakes to comply with the public interest litigation so-and-so rules. Once complied, registry is directed to place the same before the concerned roster bench.
Appreciate your logic.
Presentation sheet ಅಲ್ಲಿ ಇದೆ ನೋಡಿ. First sheet. A box ಮೇಲೆ ಇದೆ airline men 999. But email stroke post. Yes.
Serial number 18. First update.
Yes.
Today I have filed the amendment petition.
Non-filing of amendment.
Yeah, yeah. Kindly have it on.
File ಮಾಡಿದೀರಾ?
File ಮಾಡಿ.
Password. That's. Survey.
I will,
What is the amendment you are seeking for?
amendment to prayer regarding the directing the government to redo the rules, make sure they.
The objection doesn't survive.
Petitions have already been conducted.
Conducted.
Elections are already conducted, but I have challenged it, prayer mirrors, page number 19, I have challenged it.
Learned counsel for the petition submitted, she has filed an amendment application, copy thereof to be served on the council for response. Objections, if any, by 4th October, relist on 11th October.
For the serial number 19. This is Kumar Shetty.
Despite the order dated 18/8/2023, none appears for the petitioner today also. It appears that the petitioner is not interested in prosecuting the matter. Petition is dismissed for non-payment.
For the serial number 20. Amadesh Nayan, University.
I am for petitioner in case here, my lord.
Yes. Why
My
are
lords,
you sir?
my lords, ಟ್ರಯಲ್ ಕೋರ್ಟ್ ರೆಕಾರ್ಡ್ಸ್ ಬೇಕಾಗಿದೆ ಸ್ವಾಮಿ, ಅದನ್ನ ಇನ್ಸ್ಟ್ರಕ್ಟ್ ಮಾಡಿ ತಗೊಂಬಂದ್ ಕೊಡ್ತಾರೆ ಸ್ವಾಮಿ. ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಅಲ್ಲಿ ಇದ್ ಮಾಡ್ತೀವಿ, 2 weeks ಟೈಮ್.
ಅಪಿಯರೆನ್ಸ್ ಆಗ್ತಾ ಇಲ್ಲ ಇಲ್ಲಿ. Nobody is appearing in the matter. ಇವತ್ತು ಡಿಸ್ಮಿಸಲ್ ಅಂತ ಹೇಳಿದ್ಮೇಲೆ ಬಂದಿದ್ದೀರಾ?
ಇಲ್ಲ ಸ್ವಾಮಿ, NOC ವಕಾಲತ್ ನಂಗೆ ಬಂದಿದೆ, ಅವ್ರು ಸಿಗ್ನೇಚರ್ ಮಾಡ್ಕೊಟ್ಟಿರ್ಲಿಲ್ಲ ಆಕ್ಚುಲಿ, ಅದಕ್ಕೆ ಸಿಗ್ನೇಚರ್ ಗೆ ಕಳಿಸ್ಕೊಟ್ಟಿದ್ದೀನಿ. ಸೊ ದಟ್ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಅಲ್ಲಿ ಐ ಫೈಲ್ ವಕಾಲತ್ ಆಸ್ ವೆಲ್ as ಒಂದು 3 weeks ಟೈಮ್ ಇದ್ರೆ ಐ ವಿಲ್ ಕಂಪ್ಲೀಟ್ ಆಲ್ ದಿ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ my lord.
Counsel for the petitioner submits that certified copies have been applied for, and he seeks for 3 weeks time to comply with the office of petition. Released on 31st October.
Obliged my lord.
Serial number 21. Rudra Kapi.
ಸ್ವಲ್ಪ ಜೋರಾಗಿ ಹೇಳ್ಬೋದು.
The petitioner has made a representative to the respondent number 2 to consider for allotment of site. Why the annexure A?
ಕಾಪಿ ಕೊಟ್ಟಿದ್ದೀರಾ?
Copy has been served.
ಯಾರಿಗೆ?
In an identical matter, this honorable court was pleased to consider the representation.
ಗೌರ್ಮೆಂಟ್ ಅಲ್ಲ, ಯಾರು BBMP ತಾನೇ ಮಾಡ್ಬೇಕು.
Number 2 has allotted the site.
Swadhina Patra has been issued. We consider it. And AG accepts notice for respond number 1. The Pawan Kumar accepts notice for respond number 2 and 3. The petitioner is before this court seeking for the following reliefs. The petitioner claims that respondent 3 has allotted a vacant site to the petitioner on 17/11/2009. And a Swadhina Patra has been issued on 17/11/2005. Allotted in 2009, Swadhina Patra 2005 ಹೆಂಗಾಗುತ್ತೆ?
17/11/2009 ಅಲ್ಲ.
17/11/2009 typing mistake ಮಾಡಿದೆ. 17/11/2009 at Annexure A. The petitioner thereafter has approached respondent number 3 to hand over possession of the said property, which has not been done. As such, a representation has been submitted on 10/1/2019 at Annexure B, which was followed up with a legal notice dated 31/3/2019 at Annexure C, despite which no action has been taken. Whenever any representation is submitted to a statutory authority, the said authority is required to consider the same, either accept or reject the said representation. In the event of rejection, the rejection order to be accompanied by a reasoned order passed within a reasonable time. Neither having been done, I pass the following order. Petition is allowed. A mandamus issued directing respondent number 1 and 2 to consider the representations submitted by the petitioner on 10/1/2019 at Annexure B, legal notice dated 31/1/2019 at Annexure C, within a period of 60 days from the date of receipt of a copy of this one.
Provisional order has been passed. Then Lord, thereafter I sought for time to Lord to reply. Lord, without considering that Lord, now the show cause notice has been issued. And 248, there is no final confirmation order is not yet passed. There is a threat of demolition of the construction which is already been done.
You have to go before the KT, not come before this court. You don't reply there, you have time to come here, but you don't have the time to reply.
Since the final order is not passed.
You have time to prepare the writ petition and come here, but you don't have time to reply. You can't accept this, Mr. There is no, because of demolition and the pressure create madadalla. We'll extend time for you by 1 week to reply. Reply and let it be 248(1) notice elide.
Annexure K,
Page
41.
And we'll quash this, you issue a fresh notice. So you yourself issue a corrigendum, recall it and issue a fresh notice. ಇಲ್ಲ ರೂಲ್ಸ್ ಆದ್ರೂ ಮಾಡಿ, ಎರಡರಲ್ಲಿ ಏನಾದ್ರು ಮಾಡಿ. Shri Pawan Kumar accepts notice for respondent number 1 and 2. The petitioner is before this court seeking for the following leaves. Amongst other grounds, Learned Shri A.G. Shivana, Learned Senior Counsel appearing for the petitioner, would submit that the notice issued under section 248(1) of the BBMP Act 2022 has been signed by the Assistant Executive Engineer, Rajraj Nagara Subdivision, who has no authority to do so, inasmuch as in terms of section 248, it is the zonal commissioner who is required to issue the notice. Faced with the above situation, Shri Pawan Kumar, Learned Counsel for respondent number 1 and 2, submit that a fresh notice would be issued. Shri A.G. Shivana, Learned Senior Counsel for the petitioner, will submit that as and when the notice is issued, the petitioner would reply to the same without seeking for any further indulgence, since the grounds of the notice is already known to the petitioner. In that view of the matter, I pass the following order. Petition is allowed. A certiorari is issued. The provisional order number so and so dated 26/7/2023 issued by respondent number 2, Assistant Executive India at Annexure J is quashed. Consequently, a certiorari is issued. The show cause notice dated 26/7/2023, again issued by respondent number 2 at Annexure K is quashed. Liberty is reserved to the zonal commissioner to initiate such action as required under Section 248 of the BBMP Act 2020. Time limit will be statutory. We won't, we can't say anything on that time limit. Statutory. Only he is put now on notice that he has to reply.
Yes.
See number 23 for the petitioner, my lord.
Yes, Mr. Chandra Kumar.
My lord, I am seeking direction to the respondent number 1 and 2 to consider the representation made by the petitioner. That is annexure
What
B,
is
D,
your
and F.
representation?
My lord, the petitioner is the owner of the site number 58B. Respondent number 3 and 4 are adjacent owner. After demolishing the existing building, they are putting up construction without following the bylaws of the BBMP.
Plan idea, plan ilva.
Plan is Swami, but they are not
They are violated.
violated. Kindly peruse the annexure G, my lord, photos.
Your construction engage, how is your construction? Is it in accordance
My
with
lord,
law?
it was in the year 95.
No, we'll direct inspection of your property also.
Please kindly peruse the annexure G, my lord.
We'll direct inspection of your property also to see if you are constructed properly. Because all matters are like this, neighbor. Having
They
a.
are going with the construction, my lord. They are going with the construction without leaving setback.
We'll pass orders on that, but your property will also be inspected.
This one.
Shri Pawan Kumar accepts notice for respond number 1 and 2. Issue emergent notice to respond number 3 and 4 returnable by 12th October. Respond number 2 as also the ADTP. ADTP ಯಾವ branch ಯಾವ zone ಬರುತ್ತೆ ವಿಜಯನಗರ?
Vijayanagar.
The jurisdictional ADTP are directed to cause inspection of the property of the petitioner in house bearing number 58/B.
And
First Trust, First Main, Manuvana, HB Colony, Vijayanagara, Bangalore 560040. As also the property of the respond number
3 and 4.
4, bearing house number
58 bar A.
same address
58 bar A.
as regards so and so.
Until that direct the respondent number 1 and 2
Inspection to be carried out
to stop the construction work, my lord.
from 10:30 AM on 21st September. In the event of the construction being carried out without a plan sanction or contrary to the plan, respondent number 2 shall ensure that no such construction shall go on. Process fee and copies to be furnished by end of day by end of day 16, failing which the interim order will stand automatically vacated. Pay the process fee by tomorrow.
Please, ma'am. Please.
Number 24, dismiss, 25.
Lucky.
The petitioner is a student appearing for SSLC exam. He completed 15 years on July 21st. The school authorities asked him to include his name in the birth certificate on 30th of August.
When was he born?
21/7/2008.
It is within 15 years.
Yeah, they want wanted court or the property.
We have already held. He is instructor. We can't, for the mistake of a parent, a child cannot be. Petitioner, the AG accepts notice for respond number 1. The Pawan Kumar accepts notice for respond number 2 and 3. The petitioner is before this court seeking for the following reliefs. The grievance of the petitioner is that the petitioner's request for his name to be included in the birth certificate has been rejected on the ground that the said application has been submitted beyond the period prescribed under subsection 1 of section 10 of the births and so rules. The similar list has been decided by this court in WP number so and so, which would equally apply to the present matter. In view thereof, I pass the following order. The writ petition is allowed. The endorsement dated, a certiorari is issued. The endorsement dated 1/9/2023, issued by respondent number 3 at annexure E is quashed. Respondent number 3 is directed to consider the application of the petitioner bearing number 28544, dated 29/8/2023, and insert the name of the petitioner in the birth certificate of the petitioner within a period of 30 days from the date of receipt of a copy of this order.
The name of the parents to be reflected as in their Aadhaar card. There is some space and all that.
Adu problem area.
Yes,
Where have you said that?
as stated.
What is the discrepancy?
Paragraph 4. It is V. Vijay Kumar in the birth certificate, whereas the Aadhaar card is Vijay Kumar V. And
V. Vijay Kumar ko Vijay Kumar V. Again.
the school authorities are saying that the SSLC board requires activities in the Aadhaar card. Aadhaar card na lenge ange we are unable to explain.
V. Vijay Kumar ko Vijay Kumar V. Again difference. Madam, please tell us what is the difference between V. Vijay Kumar and Vijay Kumar V. But why are your offices? First name, middle name, last name. So V L feed ಮಾಡ್ತೀರಾ? So Vijay Kumar will be the first name. The other grievance of the petitioner is that the petitioner's father's name has been, father's and mother's name has been wrongly entered into the birth certificate in as much as wrongly entered. How do we say wrongly? The other grievance of the petitioner is that the name of the father and mother of the petitioner have been entered in the birth certificate are not in conformity with the Aadhaar card. And in that view of the matter, the authority, the SSLC, the education,
Karnataka Secondary Board exam.
Karnataka Secondary Education Examination Board is not going to accept the birth certificate showing a different name than that shown in the Aadhaar card. The petitioner's father's name is V. Vijay Kumar. However, in the Aadhaar card, his name is shown as Vijay Kumar V. Essentially, I do not find any difference in the said names. However, the learned AGA submit that the entry of the name and the format of entry of the name is important, since the same would continue for all records. In that view of the matter, ಇವಾಗ ಎಲ್ಲಿ ಚೇಂಜ್ ಮಾಡ ಅಲ್ಲಿ ಚೇಂಜ್ ಮಾಡ್ಬೇಕಾ ಇಲ್ಲಿ ಚೇಂಜ್ ಮಾಡ್ಬೇಕು ಬರ್ತ್ ಸರ್ಟಿಫಿಕೇಟ್ ಅಲ್ಲಿ ಚೇಂಜ್ ಮಾಡ್ಬೇಕಲ್ಲ ಒಂದು ಚೇಂಜ್ ಆದ್ರೆ ಸಾಕು ಡೋಂಟ್ ಮೇಕ್ ದೆಮ್ ಚೇಂಜ್ ಎವ್ರಿವನ್ in that view I do not find any difference in the said names the names essentially being one and the same. There was no embargo on part of the third respondent to make such changes as requested. insofar as the name of the respondent mother, petitioner's mother is concerned, in the birth certificate, her name is shown as V. Charulata. Whereas in the Aadhaar card, her name is shown as Charulata M. Really difference agidella. M
Yes, that is the maiden name. He always uses the maiden name. The M is the initial of the father, money. The father's.
Given the wrong name in the birth certificate at that time.
No, that is because the hospital people, they write, you know, when they find that the father name is Vijay Kumar, they themselves put the initials.
The counsel for the petitioner submit that at the time of giving the name of the mother for the birth certificate, her married name was given. However, she goes by her maiden name, namely Charulata M.
Charulata with a space in between.
Yes, as well. There is no particular requirement for a woman after marriage to use the name of. She is always entitled to use her maiden name, showing the name of her father. In that view of the matter, so long as necessary documents were furnished to the concerned authorities to indicate the identity, indicate and establish the identity, the authorities would have to consider the same and make such corrections as may be required and or requested. Hence, I pass the following order. The first one. Insofar as the correction of the name of the father and mother in the birth certificate, respondent number 3 shall examine the documents furnished in support of the said request, and upon examination, if the identity is established, carry out such correction as requested within a period of 30 days. Ramesh Kumar.
My Lordship, I am for the petition, my Lordship. I am challenging the annexures C and D, my Lordship, provisional orders, confirmation order, my Lordship, issued by the AE and ADTP, my Lordship, without having a statutory power, my Lordship. The issued, my Lordship.
Pandora's box would open. The petitioner is before this court seeking for the following leaves. Shri Pawan Kumar accept notice for respondent number 1 to 3. Petitioner is before this court seeking for the following. The grievance of the petitioner is that the notices, the provisional orders under section 241, 248(1) and 248(2), as also the confirmatory order under 248(3), have been issued by the Assistant Executive Engineer and Assistant Director of Town Planning respectively, who do not have any authority to do so under section 248. This court has dealt with the above matter in so and so in view thereof, and has come to a conclusion that it is the zonal commissioner alone who is entitled to issue notices under section 248. Notices stroke orders under section 248. Hence, I pass the following on. If petition is allowed, a certiorari is issued. The provisional order at Annexure C dated 21/7/2023, passed in so and so, and confirmatory order at Annexure D dated 2/8/2023, passed in so and so, are hereby called. Liberty is reserved to the zonal commissioner to issue such, to take such action under section 248 as he may deem fit.
Grateful, my Lordship.
Next, sure by the demolition. The petitioner constructed a residential building near up to 22 by timing the plan.
Same.
Ground and.
AWE. Where is the 248 one?
Annexure K, page number 35.
Page number?
Page number 35.
Provisional order 31 AWE.
Building annexure. Annexure. Page number 31.
Both of them are again the same. 31 and 35. And 31 does not even have what are the violations.
Already KM Act notice issued KM Act under section 321 and 22 and 23. The set order challenge before the Karnataka Appellate Tribunal. The set appeal is also pending. Page number 29. Pending. Even pendency of the above proceeding they are issued. And more.
Don't you have a database? E-property, e-notice put to the week. We have asked them to do this.
Reply notice,
Once you have issued a notice, why do you need to issue? Already violation is there. You don't need to issue another notice. The confirmatory order has been passed on 321(3). Find out. The Pawan Kumar accepts notice for respond number 1 and 2. One of the conditions of the counsel for the petitioner is that once earlier provisional order had been passed under subsection 1 of section 321 of the Municipal Corporation Act, which has been confirmed under subsection 3 of section 321. Challenging the same, an appeal is pending before the Karnataka Appellate Tribunal in appeal number 455 of 2020, and as such, no fresh notice could have been issued under section 248(1) and 248(2), nor a confirmatory order passed under section 248(3) of the BBMP Act 2020. Pawan Kumar seeks for and is granted 10 days time to obtain instruction and make a submission as to how notices both under how when there's a appeal pending as regards the confirmatory order under subsection 3 of 321, fresh notices have been issued under section 248. And if there is any system in place in the offices of the BBMP to keep track of notices issued in respect of each of the properties. Released on 3rd October. Until then, the operation of Annexure K dated 8/9/2022, demolition order at Annexure K dated 8/9/2023 shall stand state. Prakash.
Annexure A is at page 94.
A at 94.
94 worded. Annexure AB.
AB.
Which is an endorsement directing me not to continue the bar and restaurant as there is no trade license. I have applied for trade license on 14/6/23 as per page 93. 14/6/2023, which is pending.
Are you running your business?
Yes, Lord. The trade license was granted. Kindly go to page 58, Lord.
Yes.
It was till 2020. Then it was extended by taking the fee. And last of the extension is at page 62, 22/23. I have paid the renewal fee. There was no problem. And liquor license was also there at page 61 up to 36/23, and that is extended up to 36/2024.
But despite you paying the renewal fee,
yes,
there's neither a rejection nor
no,
issuance.
this after the receipt of this one application, they have neither rejected nor accepted. Therefore, I am before this.
What is the time period under Sakala for this?
Sakala has been seen.
Ella Sakala nodi.
Yes, sir.
Everything there's a date fixed.
I think 30 days is the
ಕೊಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಏನು ಡೀಮ್ ಪ್ರಾವಿಷನ್ ಇಲ್ಲ.
ಇದ್ರಲ್ಲ ಆಕ್ಟರ್ ಇಲ್ಲ.
ಮೈಸೂರು ಮಹಾನಗರ ಪಾಲಿಕೆ ಯಾರು? ಮೈಸೂರು ಮಹಾನಗರ AG accepts notice for respond number 1 and 3. Ms. MP Geeta Devi accepts notice for respond number 2. The contention of the petitioner is that the trade license in favor of the petitioner was first granted in the year 2000.
But actually 2015-16 itself, Lord.
15-16 and has continued to be
They have
renewed
to continue.
from time to time. Insofar as the present financial year is concerned, the payment of the renewal fee was made on 25.
Lord, renewal application was made. They have to ask for payment of fees. 22-23 I have paid, Lord. For 23-24 I had to pay. That is why at page 93 I have submitted an application.
Page 93.
93. On 14/6/23 for Sima Hazarigar.
14-6 in Bharat. When was it renewed?
It was renewed by 22-23 up to March 23. It was renewed.
You applied in June.
June 23.
After 3 months.
I was continued, but now
How can you continue?
I know, I agree, Malad. But now what they are
Submitted your application in March. That is
Yes.
different. You submitted 3 months later.
3 months later, Malad, but I was continuing and now they have issued a notice without considering the application.
You are continuing without.
Well, I agree, Malad, but I have been doing the business for the last several years.
You will have to pay penalty for this.
Well, that maybe they can impose, Malad, while considering my application.
All your profits.
Something, Malad, if the act provides for it, Malad, I have to pay.
You bid all the profits. So you had no business to conduct the business.
But liquor license was already this one, Malad,
Trade license.
extended.
Submission of counsel for the petitioner is that an application has been made on 14/6/2023 for renewal of the trade license. Pending consideration of the above application, a notice has been issued on 13/9/2023, calling upon the petitioner to stop its business. An application being pending, it was required to be either accepted or rejected before the notice, impugn notice could be issued. And if rejected, to be accompanied by reasoned orders. In that view of the matter, the endorsement dated 13/9/2023, bearing number so and so, issued by respondent number 3 at annexure AB is stayed till the next date of hearing. Released on 11th October. Copy, 2 sets of copies, petitions along with annexures to be furnished to the opposite councils.
And delivered.
Yenagala.
Yes. Amen.
Ananda, you are there. AGA, ACGP, Srikanth, you are impleading. Mr. Somyaji. Ms. Sumana Baliga, you are appearing. Ready? Yes.
That before the summer court have an association where there are economically weaker and low income group persons, and there was daily pullings in the Chikkamandia village.
You have implemented the slum development board. As
Somewhat
respondent number nine.
Respond number 9.
You appear for the slum board. Your application is allowed. But the inner impleading application. Daily order. Yes, so everybody is here.
This is an association where to safeguard the interest of these persons who are all native of this Chikkamandia and they are all laborers in the village. But initially, this entire land of Chikkamandia, the total in extent of 430 acres. But a small snap earlier I given to
ಕೊಟ್ಟಿದ್ದೀರಾ ಎಲ್ಲಾರ್ಗು? Everybody has it?
ನಾನು 2-3 ಸತಿ ಸ್ನ್ಯಾಪ್ಸ್ ಕೊಟ್ಟೆ, ಇಲ್ಲ ಅಂದ್ರೆ ಬರೀಕೆ ಜಿರಾಕ್ಸ್ ಮಾಡಿ ಕೊಟ್ಟೆ.
ಇದೆಯೋ ಇಲ್ವೋ?
ಅದೇ
ಬೇಗ ಕೊಡಿ ಅವ್ರಿಗೆ.
ನಾನು ಕೊಡಿಸ್ತೀನಿ. ಯಾಕಂದ್ರೆ 5-6 ಸತಿ ಆಗಿದೆ ಅದ್ರ ಮಿಸ್ ಆಗಿ ಕೊಡಿಸ್ತೀನಿ. ಈಗ ಜಿರಾಕ್ಸ್ ಕೊಡಿಸ್ತೀನಿ. ಇಲ್ಲ ಕೊಡಿಸ್ತೀನಿ. ಇಂಪ್ರೆಸ್ ಆಗಲ್ಲ. ಮಧ್ಯದಲ್ಲಿ ಬಂದಿದ್ದ ನಾನು ನನ್ನ ಕೊಲಿಗೆ ಹೇಳ್ತೀನಿ.
5-6 ಸತಿನೂ ಬಂದಿಲ್ಲ ಅಂತ ಇದ್ದಾರೆ.
Malad, the extent, this is survey number 507. Total an extent of 430 acres. Malad, this was notified by the government for acquisition. The entire land has been acquired.
6-1 is done.
Yes, so far as acquisition is concerned, concluded.
Yes.
Malad, out of this 430 acres, 216 acres was given to this Mandya Urban Development Authority.
Yes.
And remaining about 200 acres, they have given it to this Karnataka Housing Board. There is no issue with these two authorities.
216 was given to Muda and 200 for Housing Board.
Housing Board.
So that makes it 416.
That was the figure they have given. I have mentioned that.
14 acres is the balance.
Malad, probably this balance, the Housing Board or Muda, they have to clarify. This was the figure they have given in their.
They even made them a party.
Their participation is not necessary because they have taken and they formed this site.
Even clarified.
The one time Chief Secretary has filed his update and another time Principal Secretary has also filed
But
update.
then you are saying 50 acres allotted to BD Workers Society. There is no such land available for that 50 acres. Bari 14 acres is ashte. 50 illa.
On 29/2017, then the Chief Secretary has filed an update. May I kindly request Malad to 29/2017.
Yes.
Malad, it's better to read from para 3, Malad. I further submit that the Deputy Commissioner of Mandya District, Mandya handed over 12 acres of land in Serve number 507 of Mandya village to the Commissioner City Municipal Council, Mandya on 14/7/2014 to distribute the sites to the eligible siteless beneficiaries as per the board directions dated 3/2/2014 in dictation 43561 of 13. Same was brought to the notice of Honorable High Court by the project director DUDC Mandya 28/7/14. I respectfully submit that in the meanwhile, Chikkamandia Villages Welfare Association had filed a contempt petition and so on so. Before the Honorable High Court with a plea to direct the authorities to distribute the sites to them. The contempt petition was dropped by the Honorable Court on the assurance that necessary action would be taken to distribute the sites to the siteless poor under the Ashra scheme. It is submitted that the Panchayat Development Officer Mandya Rural Grama Panchayat had prepared and submitted to the Tahsildar Mandya the list of siteless beneficiaries in the jurisdiction of Chikkamandia village of Mandya Rural Grama Panchayat on 26/11/2013. Office of the Deputy Commissioner Mandya has directed the Chief Executive Officer Jilla Panchayat Mandya through the letter dated 25/7/2014 to initiate action for verification and allotment of sites to the applicants
as per the orders of the Honorable High Court dated 3 to 14 in WPs also. In the meanwhile, in another petition, the Honorable High Court in its order dated 7/9/15 had directed the authorities to rehabilitate 524 families of Tamil colony in the Mandya CMC limits within 1 year from the date of order of the Honorable High Court. I further submit that to abide by the order dated 7/9/2015, High Court under WP so and so, the CMC Mandya has handed over 6 acres of land to the Karnataka Slum Development Board for rehabilitation of Tamil colony slum dwellers. Reserved 1 acre of land for the construction of houses to the urban houseless Pora Karmikas under Pora Karmika Gruha Bhagya Yojana as per the decision by the Ashaya Committee proceedings dated 21/11/2015. National authorities have notified 5 acres of land in finance survey number 507 for utilization for construction of bypass road to National Highway 275. It is respectfully submitted that the Chikkamandya Villagers Welfare Association have filed a fresh petition in the WP sponsor before the Honorable High Court to pass the official memorandum dated 14/7/2014 of the Deputy Commissioner Mandya, addressed to the Municipal Commissioner CNC Mandya, and to direct the authorities to allot 12 acres of land to the petitioner. Now the Deputy Commissioner Mandya through OM number so and so on 15/9/2017 has taken back 12 acres of land in survey number 507 from CMC Mandya. This 12 acres. I respectfully submit that the government of Karnataka, where the government order so and so on 31/10/2013 has constituted urban Ashraya committee which are headed by the concerned MLA, municipal commissioner of the concerned municipal council as member secretary. A copy of the aforesaid government order is annexed. I further submit that direction has been issued by the principal secretary to government housing department through DO letter 15 dated so and so to Deputy Commissioner Mandya with a copy to concerned member secretary of Urban Ashraya Committee Mandya, Municipal Commissioner CMC Mandya to verify the application of 120 applicants who have filed the WP so and so, Honorable High Court of Karnataka, and to prepare the list of eligible beneficiaries and further directed the member secretary Urban Ashraya Committee Mandya to verify the application strictly in accordance with the guidelines issued by the government of Karnataka. Accordingly, the representation of the petitioner Chikkamandya Village Welfare Authority is under verification to determine the eligibility of the beneficiaries for the distribution of sites under Urban Ashraya scheme as per the guidelines issued by the government. The process of verification and preparation of the list of eligible beneficiaries may require 2 months to complete the Deputy Commissioner Mandya has been directed to supervise this process. Hence, the indulgence of the Honorable Court is sought to grant 2 months time for the same. This was the picture. Now 12 acres, which was now almost identified for the grant of the allotment to this beneficiaries for all the natives of this Mandya, the Chikkamandya, and who are all eking out their livelihood out of Pulia or some small work in the field. To them it has been reserved. Now, in the year 2017, this was applied in pursuance of the order passed before the Honorable Court in the writ petition in PIL. Again, contempt also they have filed a memo, we have complied. Again, they have not complied. Again, one more that has been again recalled the order. Then this update was filed. Now, till date also, either one way or the other, they are evading and they are saying that this is to the Rajiv Gandhi housing scheme or housing to the corporation, it has to go. But basically, this when the writ petition was filed, this area and this Chikkamandya is under rural Mandya, rural part of the Mandya. This was under the control of Jilla Panchayat rural. Again, in the Jilla Panchayat rural, there is a rural Ashraya scheme, rural Ashraya implementation, wherein when this writ petition was filed, it was handed over to this rural Ashraya scheme authorities for distribution. Then again, the municipal commissioner, he said that he wants this land again to the municipality. When that was now under challenge, it has been now taken over by the municipality, CMC, urban district.
Now, where is this 12 acres? With whom is this 12 acres?
Now, 12 acres, as it is their vacant land.
With
And
who is the?
now the earlier direction given to by the sample court is rural Ashraya scheme. Rural Ashraya scheme is under the administrative control of this Jilla Panchayat Mandya.
Because the affidavit of the then Chief Secretary indicates that this is coming under the Urban Ashraya Committee. Para 8.
Para 8, it was stated, but in fact,
Para 9 also it is stated Urban Ashraya Committee. And they are examining the applications and trading it. Does it come under urban or rural firstly?
In my read petition at page number 31, annexure E, my lord.
So in 2017, it is urban and continues to be urban. How did you enter this 12 acres? It was not. When a chief secretary has filed an affidavit saying that their applications are being considered, then what is the sanctity of this affidavit? Madam SCGP, you will have to say that, Ms. Kulkarni. Mrs. Kulkarni.
Their land is created in the municipal area, municipal units. The petitioner who sought for the site, they are situated and residing within the limits of rural panchayat, Chikkamandya, Grama Panchayat. For that reason,
We are not concerned with all these stories. We are concerned with the affidavit filed by the chief secretary of the state.
thereafter that,
That cannot-
has been acquired.
He has said at para 9 that 120 applications of the petitioner association are being considered by the member secretary Urban Ashraya Committee Mandya to verify the application strictly in accordance with the guidelines. What has happened to that?
Thereafter that, status report. Status report before the son of report that they are identified.
Madam, you file one detailed synopsis as to what has happened. You file detailed synopsis as to what has happened, what your authorities have done. Not only the state government, all your neighbors and friends, what they have done. A detailed consolidated one without missing out anything. Because we find it a little surprising or shocking that when the chief secretary has filed a report, affidavit saying that their application are going to be considered, 6 acres goes to them, 3 acres goes to somebody else. How can that happen? How can it be when the chief secretary has filed this affidavit? Can you change this, the undertaking which has been given to this court by the chief secretary? It's not by anybody, it's by the chief secretary of the state. We'll accept a affidavit file by when we chief secretary files, we'll accept that. That is what has been accepted in the year 2017. But thereafter, if you make changes to the affidavit and act contrary to it, can you do that? You were not there at that time, we know. Now you make the detailed affidavit, detailed synopsis from the beginning till date, including what you are given to Mr. Srikanth, what you are given to Ms. Sumana Baliga, what you are given to Mr. Ananda, everybody. Our clients, our geno kotilla, our clients.
I'll punish a couple.
If you have no papers, we'll ask the registry to give you the copy. You make an application. We'll direct the office to. Once an affidavit has been filed by the chief secretary, you cannot make any change without an order being passed by this court. Because that has been accepted by this court. Otherwise, there won't be a value for any affidavit, and especially of that of the chief secretary. You can't deal with the chief secretary's affidavit like this. Because the next person will be somebody else. Whoever has filed it has to be adhered to. Learned CGP.
Land has been purchased by the state, and the beneficiaries are among the applicants are identified, and some of them are also issued. That
let them give the proposal what they want to do, because you have to comply with what the chief secretary has said. If not in that land, some other land. He has said 120 applications will be considered. If they are eligible, what happened to that? From 2017, for 6 years, it's waiting for that. The fact that an affidavit can be filed by chief secretary itself indicates the importance of it. This court has asked for that affidavit, so that the quietus could be brought about, because so many departments are there. Between your departments, you can't spread the land around and deprive poor people if they are entitled and eligible. Sarita Kulkarni, learned SCGP, is directed to file a detailed synopsis from commencing from 1987, when the land was originally acquired, till date, as to what the various departments of the state, municipal authorities, statutory corporations, and or companies created for implementation of different schemes have done with the land in survey number 507 of Chikmandia village, Mandya district, as also any other scheme proposal to address the grievance of the petitioner. They said synopsis to be filed on or before Agata. We'll give you time.
Only one, sir. 507. Only one.
They are the 430 acres. Lot of cooks are there, so do a proper job. Don't do it in a hurry, because what you file will be the basis. 4 weeks' time is granted to do the needful. Affidavit to be filed on or before 26th October. We list on 30th October. 26th October, after serving a copy thereof on all the other councils. We list on 30th October. If an application is made by any of the councils for furnishing of any of the pleadings and other documents which have been filed in the present petition, the registry to make available the said papers on payment of necessary fees.
Yes, I'm okay.
Except that on the application made by learned HCG.
Serial number 30.
Who shall not be required to make the application.
I am for the respondent, my lords.
Yes. You're giving it to Mr. Jagdishwara?
Yes, I received it, man. I received it. It's with me now.
Lot of difference in the survey by you and by this third party.
That's what, my lord, I wanted to get some information from my engineers, my lord. I told the concerned engineer to meet me. There is a lot of difference between the plan as well as the proposed given by the petitioner, my lords, and the notice. Lot of difference is there, my lords.
In proposal also is 30% difference.
How? ಜೊತೆಗೆ ಎನ್ಕ್ರೋಚ್ಮೆಂಟ್ ಆಗಿದೆ ಅಂತ ಹೇಳಿ ಇದು ಕೊಟ್ಟಿದ್ದಾರೆ ಅಷ್ಟೇ, because they are claiming that the neighbor has encroached their property. Based on that, they are claiming this.
Whatever proposal you give should be within 5%.
Yes.
The entire stretch, all the houses are built in the same manner.
Yen madadu, you are the first person.
The whole area, Stagras, complete after
You are the first. They will take action against everybody.
In fact, on the southern side, my property has been encroached by 30 to 30 feet, my lords. And the complaints that have given to the BBNB, they have not acted upon it at all at the time of.
There's an encroachment of your property, you have to file a suit.
Before this also. And my lords, the third page, it's as of today, the structure of the property. The second sheet clearly shows I'm removing all the violations on the setbacks, my lords.
Madam, you are permitted 5% violation. It's a violation, but you are permitted 5%. How your construction is?
The construction happened.
10 and 11, 10 and 11 minutes. 10 and 11.
10 and 11 andre prior to 2013.
How?
Adu akrama sakrama.
Akrama sakrama seized before the apex court, my lords.
What to do with these matters, Mr. Jagdishwara? We'll have to adjourn or what?
We don't know, my lord, what will be going to happen in the apex court, my lord, unless that matter is disposed before the apex court, my lord. We are not in a position to make a submission.
If that akrama sakrama is upheld, then what will happen to demolition?
That's a issue, my lord.
You cannot put them back.
Yes.
Anyway, you get your instruction and get your instruction from your chief commissioner as to what is to be done as regards constructions prior to 2013.
Please, my lord.
2013 admele it won't be applicable.
How?
But prior to 2013 ಏನ್ ಮಾಡಬೇಕು?
Yes, my lord.
You will have to take a stand on that.
Yes, my lords.
And memo. Counsel for the petitioner has filed a memo enclosing the proposal of the petitioner to bring the property in conformity with the building plan sanction and the building bylaws. She further submits that a portion of the property of the petitioner has been encroached, as regards which a suit is pending. In stage and then.
Okay, evidence.
Yeah, evidence.
Our side. It is concluded now. It's for process.
Suit of the year.
But 2016.
You have to
It was waiting for nearly 2 years because consent activity.
blame it on the court. A copy thereof has been furnished to Mr. Jagdishwara, who seeks for and is granted 2 weeks' time to obtain instructions from his concerned engineer, since there are differences shown between the survey carried out by the BBMP officers and that by a private party. Apart therefrom, he is also directed to make a submission as regards the pendency of the matter before the Honorable Apex Court relating to Akrama Sakrama, and what is the stand of the corporation relating to constructions carried out prior to the year 2013. We list on 4th October. Earlier granted is extended till next year. Records ಬೇಕಾ?
Records are necessary. Just as copy is also not for different copy. Available records. Not that one vote
Improved order is 2 pages. EP1 only it is running into 18 pages.
Counting happens. Rule 71 of the handbook.
Yes.
Says that after the counting of votes, I take to the relevant portion. In 2 minutes, I'm just telling the concise thing first. Within 2 minutes after being counted, if anybody has an objection to the counting process, they have to raise the objection. So the petitioner raises the objection through exhibit P5 method. It's a part of the writ petition. That is not considered. But what the trial court finds is that P5 is a doubt method. Because the candidate accepts that he was not present when the counting of the votes has happened. He says that he had assigned his person to be there on his behalf. So the letter is not only signed by the person who is representing the petitioner, but also the petitioner sign is there.
Was not there.
Was not there. In the cross-examination, when a question is posed to that effect, how his signature is there, he says that I have signed the same outside the court. Then he retracts and says, no, I have signed the same outside the polling booth. So such a thing is not permissible for recounting. If my lordship permits, I take to the portions of the.
We need the cross-examination. I will produce the cross-examination.
Cross-examination has been extracted in the English order. Second copy is my fight. Objections Akila from records.
Objection ಆಗ್ಬೇಕು ಅಂತ ಏನಿಲ್ಲ.
It was the direction of the docket of filing. I verified everything is on basis of the records.
Record that he doesn't want to file. That is not a problem. But the records required is what you.
Records, it may not say.
Exhibit P5 would be required.
P5 is there only annexed to the
Where is page?
Page number 17 is my objection raised for recounting. Annexed 3. That was not received by the returning officer. No mark is made whether it is
not received.
Received or not, nothing is mentioned in the.
Okay, see the two signatures. Vishwasi G and Basuraju. That is the agent who is present on behalf of the petitioner.
Yes.
Left side, if my lordship sees Jagdish, that is the petitioner signature. So, if impugned order, if my lord gives me 5 minutes, I take to the reader.
Has it been received?
This is a created document, is the binding one.
So it's not been received and created.
Yes. Page 31, paragraph 10 of the impugned order, my lords. Discussion with regard to the P5. This is what the exhibit P5.
Yes.
It is most relevant to take into account that the petitioner has mainly pressed his reliance on exhibit P5 and argued that his agent has placed the same before the returning officer and the said authority has illegally refused to consider. but there is no any significant mark available on the P5 to show that the said document really placed before the returning officer on the relevant time for consideration by following the norms as contemplated in Rule 71 of the handbooks for returning officer of village panchayat election. For the present context, it is necessary to extract exact direction of the said provision, and the said provision speaks guidelines for prayer of recounting data. I'll read the question. ಎಣಿಕೆ ಕಾರ್ಯವು ಸಂಪೂರ್ಣವಾಗಿ ಮುಗಿದ ನಂತರ ಪ್ರತಿಯೊಬ್ಬ ಅಭ್ಯರ್ಥಿಗೆ ಬಿದ್ದ ಮತಗಳ ಒಟ್ಟು ಸಂಖ್ಯೆಯನ್ನು ಪ್ರಪತ್ರ 31ರ ಫಲಿತಾಂಶದ ಅಡಿಯಲ್ಲಿ ನೀವು ದಾಖಲು ಮಾಡಿ ಅದನ್ನು ಪ್ರಕಟಿಸಬೇಕು. ನಂತರ ನೀವು 1 ಅಥವಾ 2 ನಿಮಿಷ ಕಾಯ್ದು ಈ ಅವಧಿಯಲ್ಲಿ ಯಾವುದೇ ಅಭ್ಯರ್ಥಿ ಅಥವಾ ಅವನ ಕೈ ರಾಜ್ಯದಲ್ಲಿ ಅವನ ಚುನಾವಣಾ ಏಜೆಂಟ್ ಚುನಾವಣಾ ಏಜೆಂಟ್ ಅಥವಾ ಅಭ್ಯರ್ಥಿಯ ಎಣಿಕೆ ಏಜೆಂಟರು ಮರು ಎಣಿಕೆ ಕೋರಿದರೆ ಮರು ಎಣಿಕೆಗಾಗಿ ಲಿಖಿತದಲ್ಲಿ ಒಂದು ಅರ್ಜಿಯನ್ನು ಕೂಡಲೇ ಸಲ್ಲಿಸುವುದಕ್ಕೆ ತಿಳಿಸುವುದು. ಮರು ಎಣಿಕೆಗಾಗಿ ಲಿಖಿತ ಅರ್ಜಿಯನ್ನು ಸ್ವೀಕರಿಸುವುದಕ್ಕೆ ನಿಮಗೆ ಸೂಕ್ತವೆನಿಸಿದೆ
ಅಲ್ಲಿ
ಅಲ್ಪ ಸಮಯಾವಕಾಶ ಬಂದು ಪ್ರಕಟಿಸಿ ಹಾಗೆ ಪ್ರಕಟಿಸಲಾದ ವೇಳೆಯೂ ಮುಗಿಯುವವರೆಗೂ ಪ್ರಪತ್ರ 31ರ ಫಲಿತಾಂಶದ ಹಾಳೆಯನ್ನು ತಕ್ಕದಲ್ಲ ಮತ್ತು ಅದಕ್ಕೆ ಸಹಿ ಮಾಡತಕ್ಕದಲ್ಲ. ಮರು ಎಣಿಕೆಗಾಗಿ ಒಂದು ಅರ್ಜಿಯನ್ನು ಸಲ್ಲಿಸಿದಾಗ ಅದರಲ್ಲಿ ಒತ್ತಾಯಿಸಲಾದ ಕಾರಣಗಳನ್ನು ನೀವು ಪರಿಗಣಿಸಿ ಆ ವಿಷಯದ ಬಗ್ಗೆ ನಿರ್ಣಯಿಸಿ ಅರ್ಜಿಯು ಸಮಂಜಸವಾದುದಾಗಿದ್ದರೆ ಅದನ್ನು ಇಡಿಯಾಗಿ ಅಥವಾ ಭಾಗಶಃ ಪುರಸ್ಕರಿಸತಕ್ಕದ್ದು ಅಥವಾ ಅಸಮಂಜಸವಾದದ್ದು ಎಂದು ಕಂಡು ಅಂದರೆ ಅದನ್ನು so only 1 to 2 minutes time is given for them to present the exhibit P5, my lords. Now if my lords come to page 34 paragraph 12, my lords. In page 34 paragraph 12 of the judgment. In order to make analysis on the credibility of exhibit P5, that is annexure P what's and consequently of the tenability of plea raised by the petitioner, based on the said document, it is necessary to look into the benching evidence forthcoming at the time of cross-examination of PW1. PW1 is the petitioner in this matter. In the way the respondent number 1 has attacked with evidence of PW1 and elicited during the hour of cross-examination that ಘಟ್ಟದಹಳ್ಳಿ ಗ್ರಾಮ ಪಂಚಾಯಿತಿ ಒಂದೇ ಮಠ ಕ್ಷೇತ್ರದ ನಾನು ಮತ್ತು ದಿನೇಶ್ ಮಾತ್ರ ಸ್ಪರ್ಧಿಸಿದ್ದೇವೆ. ಚುನಾವಣಾ ಪೂರ್ವದಲ್ಲಿ ನಡೆದ ಪ್ರಕ್ರಿಯೆ ಬಗ್ಗೆ ನಾನು ಯಾವುದೇ ತಕರಾರು ಎತ್ತಿರಲಿಲ್ಲ ಎಂದರೆ ಸರಿ. ಮತ ಎಣಿಕೆ ಕೇಂದ್ರದಲ್ಲಿ ನನ್ನ ಪರವಾಗಿ ನನ್ನ ಪರವಾಗಿ ನನ್ನ ಏಜೆಂಟ್ ಆಗಿ ನನ್ನ ಸಹೋದರ ಹೋಗಿದ್ದ. ಒಂದೇ ಎದುರುದಾರನ ಪರವಾಗಿ ಏಜೆಂಟ್ ಆಗಿ ಮತ ಎಣಿಕೆ ಕೇಂದ್ರಕ್ಕೆ ಶ್ರೀನಿವಾಸ್ ಮತ್ತು ಕುಮಾರ್ ಎಂಬುವರು ಹೋಗಿದ್ದರು. ಮತ ಎಣಿಕೆ ಕಾಲಕ್ಕೆ ಒಂದೇ ಎದುರುದಾರ ಮತ ಎಣಿಕೆ ಕೇಂದ್ರದಲ್ಲಿ ಎಂದರೆ ಸರಿ. ಮತ ಎಣಿಕೆ ಪ್ರಕ್ರಿಯೆ ಎಷ್ಟು ಗಂಟೆಗೆ ಮುಕ್ತಾಯ ಆಯಿತು ಎಂದು ನನಗೆ ಮಾಹಿತಿ ಇಲ್ಲ. ಮತ ಎಣಿಕೆ ಮುಗಿದ ವಿಚಾರ ನನಗೆ ಆ ದಿನ ಮಧ್ಯಾಹ್ನ 7:30 ಗಂಟೆಗೆ ತಿಳಿಯಿತು. ಮತ ಎಣಿಕೆ ಸೀಟಿಗೆ ನನ್ನ ಪರವಾಗಿ ಹಾಜರಾದ ನನ್ನ ಏಜೆಂಟ್ ಸಹಿ ಮಾಡಿದ್ದಾರೆ. On behalf of him, the agent assignment ಎಂದರೆ ಸಾಕ್ಷಿಯು ನನಗೆ ಗೊತ್ತಿಲ್ಲ ಎನ್ನುತ್ತಾರೆ. ಬೂತ್ ನಲ್ಲಿ ಚಲಾವಣೆಯಾದ ಒಟ್ಟು ಮತಗಳ ಪೈಕಿ ನನ್ನ ಪರವಾಗಿ 137 ಮತಗಳು ಚಲಾವಣೆ ಆಗಿದ್ದವು ಎಂದರೆ ಸರಿ. ಬೂತ್ ನಲ್ಲಿ ಚಲಾವಣೆಯಾದ ಮತಗಳ ಪೈಕಿ ಒಂದೇ ಎದುರುದಾರನ ಪರವಾಗಿ 135 ಮತಗಳು ಚಲಾವಣೆ ಆಗಿದ್ದವು ಎಂದರೆ ಸರಿ. ಸಾಕ್ಷಿಯು ಪುನಃ ನುಡಿಯುತ್ತಾ ಒಂದೇ ಎದುರುದಾರನಿಗೆ 133 ಮತಗಳು ಚಲಾವಣೆ ಆಗಿದ್ದವು ಎಂದರೆ ತಿರಸ್ಕೃತ ಮತಗಳು ಪೈಕಿ 2 ಮತಗಳನ್ನು ಆತನ ಪರವಾಗಿ ಸೇರಿಸಿ 135 ಮತಗಳು ಆತನ ಪರವಾಗಿ ಚಲಾವಣೆ ಆಗಿದೆ ಎಂದು ಚುನಾವಣಾ ಅಧಿಕಾರಿ ಸುಳ್ಳಾಗಿ ಘೋಷಣೆ ಮಾಡಿದ್ದಾರೆ ಎನ್ನುತ್ತಾರೆ. ಮಿತಿ 5ರ ಎಕ್ಸಿಬಿಟ್ P5 ಲಿಪಿ 5ರ ಅರ್ಜಿಯನ್ನು ನನ್ನ ಸಹೋದರ ಮತ್ತು ಎಣಿಕೆ ಕೇಂದ್ರದಲ್ಲಿ ಬರೆದು ಚುನಾವಣಾ ಅಧಿಕಾರಿ ಮುಂದೆ ಸಲ್ಲಿಸಿದ್ದಾರೆ. ಮತ ಎಣಿಕೆ ಕೇಂದ್ರದಲ್ಲಿ ಮತ ಎಣಿಕೆ ಅಧಿಕಾರಿ ಪ್ರತಿಯೊಂದು ಸಾಕ್ಷಮ ಮತವನ್ನು ಮತ್ತು ಗಣಕೆಟ್ಟ ಮತವನ್ನು ಹಾಜರಾದ ಅಭ್ಯರ್ಥಿ ಅಥವಾ ಏಜೆಂಟ್ ತೋರಿಸಿ ಖಚಿತಪಡಿಸಿಕೊಂಡು ಎಣಿಕೆ ಪ್ರಕ್ರಿಯೆ ಮಾಡಲಾಗುತ್ತದೆ ಎಂದರೆ ಸರಿ. ಫಲಿತಾಂಶ ಘೋಷಣೆ ಪತ್ರಕ್ಕೆ ನನ್ನ ಪರವಾಗಿ ಹಾಜರಿದ್ದ ಏಜೆಂಟ್ ಸಹಿ ಮಾಡಿದ್ದಾರೆ ಎಂದರೆ ಸರಿ. ಮೈ ಏಜೆಂಟ್ ಸೈನ್ ಎಕ್ಸಿಬಿಟ್ P5
ಫಲಿತಾಂಶ.
ಲಿಪಿ 5ರ ಅರ್ಜಿಯನ್ನು ದಾಖಲಿಸಿದ ಕಾಲಕ್ಕೆ ನಾನು ಹಾಜರಿಲ್ಲ ಎಂದರೆ ಸರಿ. ಐ ವಾಸ್ ನಾಟ್ ಪ್ರೆಸೆಂಟ್. ಲಿಪಿ 5ರ ಮೇಲೆ ಅರ್ಜಿಯ ಮೇಲೆ ನೀವು ಎಲ್ಲಿ ಸಹಿ ಮಾಡಿದ್ದೀರಾ ಎಂದರೆ ಸಾಕ್ಷಿ ನಾನು ನ್ಯಾಯಾಲಯದ ಬಳಿ ಸಹಿ ಮಾಡಿದ್ದೇನೆ ಎನ್ನುತ್ತಾರೆ. Because exhibit P5 not only contains the signature of his agent, but also
the original of exhibit P5 was produced by the petitioner.
Petitioner what we are
in the
completed ಸಾಕ್ಷಿ ಪುನಃ ನುಡಿಯುತ್ತಾ ಸದರಿ ಅರ್ಜಿಯ ಮೇಲೆ ನಾನು ಮತ ಎಣಿಕೆ ಕೇಂದ್ರದ ಹೊರಗಡೆ ಸಹಿ ಮಾಡಿದ್ದೇನೆ ಅನ್ನುತ್ತಾರೆ. So one thing is after everything's been declared, this document has been created and they have cited their value. As per rule 71, it was not filed within the stipulated time. Because that money is
the original of exhibit P5 was produced by the petitioner at the time of evidence in EP1.
His agent filed before the returning officer. The returning officer did not refuse to accept the request of the petitioner for recounting the votes. But in case is that there were 3 invalid votes. Have been taken into consideration and added to the.
That is a different thing. Your old question for recounting under Rule 71 is that you had submitted an application. So the application was refused by the returning officer.
Did not even mark anything on the exhibit P5.
Then what did you do after that if he refused?
Writing, we have not made any remark on the exhibit P5. Returning officer has not made any remark on the.
Where is your petition? What have you stated about exhibit P5 in your petition? Election petition?
Exhibit P5.
ಮುಖ್ಯ ಕಾರಣಗಳು.
It is filed by my agent, but may read P5. That is produced here.
Annexure C is your election. Annexure C is your election petition.
Yes, sir. Annexure C.
ಅದ್ರ ಬಗ್ಗೆ ಏನು ಹೇಳಿದ್ದೀರಾ?
Court has simply accepted the case of the returning candidate that my representative read the evidence of one and that it is created. He has signed before the court, and another bit he has said that he has signed the express letter for recounting at the outside the counting center.
Please come to page 20. ಈ ಅರ್ಜಿಗೆ ಮುಖ್ಯ ಕಾರಣಗಳು ಓದಿ.
ಮುಖ್ಯ ಕಾರಣಗಳು ಅರ್ಜಿದಾರರು ಸ್ಪರ್ಧಿಸಿದ್ದ ಚುನಾವಣೆಯಲ್ಲಿ ಎರಡನೇ ರೆಸ್ಪಾಂಡೆಂಟ್ ಮತಗಳ ಎಣಿಕೆ ವೇಳೆಯಲ್ಲಿ ಚಲಾವಣೆಯಾದ ಮತಗಳ ಪೈಕಿ ಅರ್ಜಿದಾರ ಕೆಲವು ಮತಗಳನ್ನು ಒಂದನೇ ರೆಸ್ಪಾಂಡೆಂಟ್ ಖಾತೆಗೆ ಸೇರಿಸಿ ಅರ್ಜಿದಾರರಿಗೆ ಮೋಸಗೊಳಿಸಿರುತ್ತಾರೆ. ಅರ್ಜಿದಾರರು ಚುನಾವಣೆಯ ನಂತರ ಎಣಿಕೆ ಕಾರ್ಯ ನಡೆಯುತ್ತಿದ್ದಾಗ ಅರ್ಜಿದಾರನ ಬೂತ್ ಏಜೆಂಟ್ CN ಬಸವರಾಜು ಲಿಂಗಯ್ಯ ಇವರು ಎರಡನೇ ರೆಸ್ಪಾಂಡೆಂಟ್ಗೆ ಅರ್ಜಿಯನ್ನು ಸಲ್ಲಿಸಲು ಮತ್ತು ಮನವಿಯನ್ನು ಮಾಡಿ ಕಾನೂನು ಅಡಿಯಲ್ಲಿ ಅವಕಾಶ ಇರುವಂತೆ ಮರು ಎಣಿಕೆಯನ್ನು ನಡೆಸುವಂತೆ ಕೂಡಲೇ ಕೋರಿಕೊಂಡರು ಸಹ ಎರಡನೇ ರೆಸ್ಪಾಂಡೆಂಟ್ ಅರ್ಜಿದಾರನ ಕೋರಿಕೆಯನ್ನು ತಿರಸ್ಕರಿಸಿ ಒಂದನೇ ರೆಸ್ಪಾಂಡೆಂಟ್ ಒಂದು ಮತದ ಅಂತರದಿಂದ ಚುನಾಯಿತರಾಗಿದ್ದಾರೆಂದು ಘೋಷಿಸಿರುವುದು ಕಾನೂನು ಬಾಹಿರ. ಅರ್ಜಿದಾರನಿಗೆ ಚಲಾವಣೆಯಾದ ಮತಗಳ ಹಾಗೂ ಒಂದನೇ ರೆಸ್ಪಾಂಡೆಂಟ್ಗೆ ಚಲಾವಣೆಯಾಗಿರುವ ಮತಗಳ ಮರು ಎಣಿಕೆ ಮಾಡಿದ್ದಲ್ಲಿ ಅರ್ಜಿದಾರನೇ ಗೆಲುವನ್ನು ಸಾಧಿಸುತ್ತಿದ್ದರು. ಅದಕ್ಕೆ ಎರಡನೇ ರೆಸ್ಪಾಂಡೆಂಟರು ಅವಕಾಶ ನೀಡದಿರುವುದು ಕಾನೂನು ಬಾಹಿರ ಕೃತ್ಯವಾಗಿರುತ್ತದೆ. ಘಟ್ಟದಲ್ಲಿ ಗ್ರಾಮ ಪಂಚಾಯತಿ ವ್ಯಾಪ್ತಿಯಲ್ಲಿ ಒಂದನೇ ಮತಕ್ಷೇತ್ರದಲ್ಲಿ 8ನೇ ಮತಗಟ್ಟೆಯಲ್ಲಿ ನಡೆಸಿದ ಚುನಾವಣೆಯ ಮತಗಳ ಎಣಿಕೆಯನ್ನು ಸಮಂಜಸವಾಗಿ ಹಾಗೂ ನ್ಯಾಯಸಮ್ಮತವಾಗಿ ಎಣಿಕೆ ಮಾಡದಿರುವುದು ಕಾನೂನು ಬಾಹಿರವಾಗಿರುತ್ತದೆ. ಘಟ್ಟದಲ್ಲಿ ಗ್ರಾಮ ಪಂಚಾಯಿತಿ 1ನೇ ಮತಕ್ಷೇತ್ರದ 8ನೇ ಮತಗಟ್ಟೆಯ ಚುನಾವಣೆಯು ಈ ಘನ ನ್ಯಾಯದ ತರಹದಿಗೆ ಒಳಪಡುತ್ತದೆ. ಈ ಚುನಾವಣಾ ಅರ್ಜಿಯು ಕಾಲಮಿತಿಯೊಳಗೆ ಇರುತ್ತದೆ. ಈ ಅರ್ಜಿದಾರನು ಈ ಚುನಾವಣೆಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ಯಾವುದೇ ಚುನಾವಣಾ ಅರ್ಜಿಯನ್ನು ಎಲ್ಲಿಯೂ ಸಹ ದಾಖಲು ಮಾಡುವುದಿಲ್ಲ. ನ್ಯಾಯದ ಶುಲ್ಕವನ್ನು ಈ ಅರ್ಜಿಗೆ ಪಾವತಿಸಬೇಕು.
What is the response of respondent number 2 to this petition?
That contention is that
Respondent number 2 file objections.
Before this court is
Against him. The allegation is made against him. He should have answered.
He should have answered. There is the
Golden minutes. Our reliable.
That's for rules. It was the case that only voting agent that was given the representation. There was not anything. Now there is a signature of the candidate also.
Who was not?
Candidate undisputedly admits that he was not there during the turning of votes. He says he denies, I do not know the knowledge.
So it is after the
But when
announcement.
it comes to his cross-examination, when he cites the exhibit T5, which is their interest for recounting, he says, firstly he says outside the program. Then he takes back that statement and says, outside the.
We got that, but what is the response of respondent number 2?
These are my.
the person is arguing on his behalf also.
I am now on the returning officer from
He has not come here. He has those services.
Then the state is not.
That's not that he admits the allegation made with the
Returning officer is the officer of.
Returning candidate. ಅಲ್ಲಿ ರಿಟರ್ನಿಂಗ್ ಆಫೀಸರ್ ಹೋಗ್ಲಿಲ್ಲ. ಇಲ್ಲಿ ರಿಟರ್ನಿಂಗ್ ಕ್ಯಾಂಡಿಡೇಟ್ ಬಂದಿಲ್ಲ. ಅಷ್ಟೇ. But should not he have answered that?
records are also necessary.
You are also speaking on the basis of this.
Records may be secured so that
Registry that secure the trial court records forthwith. Relist on 12th October. If he has denied this allegation, then yes. There should be a response from the returning officer when allegation is made by against the returning officer. Sidmalappa.
Please, my lord.
32.
Lord, the party, Lord, I wrote a letter to the petitioner. Lord, his family members are not, Lord, interested in prosecuting the case. Lord, the writ petition may be closed by abated on recording as that abated.
You are for the respondent. (32) Michael Matador, yes.
Question in the executive officer order passed by the executive officer page number 15. 87. Yes.
Page?
Additionally, subject to outcome of the suit.
Page number. Page number.
87.
87.
Subject to outcome of the suit of the order. Suit to dismiss and RF also dismiss. Last occasion I dismiss.
So on that basis, you will have to consider.
Order has to be restored in the name of the.
You will have to produce it for them to consider and pass orders and orders. Your munde allappa, chief officer. He is not a postman for you. You will have to face it there. Sidmalappa, you are on mute. Mute alidila.
Please, my lord, I'm sorry.
Lord,
respondent number 3 died, Lord.
You are anyway the suit and the appeal have been dismissed, filed by your client.
That's what I could not get any information because my attempt not in reaching not the LR.
So
They are
what
not-
we'll do is, we'll
Please.
direct the petitioner, we'll allow the petition, we'll direct the petitioner, not allow the petition, partly allow the petition. Direct them to place the orders before the respondent number 1 to consider said orders and pass necessary order.
Not on merit only.
On merit, on judgments, subject to judgment and judgment ಏನಿದೆ ಅದು implement ಮಾಡ್ಬೇಕು ಅವ್ರು ಅಷ್ಟೇ.
Other than you should not consider the judgment itself is the creative title to Lord the petitioner.
He cannot go beyond the judgment, Mr. Dubala. Judgment is there, judgment is what he has to consider and pass order.
The judgment, he says, my lord, is a suit for permanent injunction.
He cannot sit on appeal on the judgment. Lord. Petitioner is before this court, seeking for the following reasons. By way of the impugned order, annexure, yes, the first respondent, by way of the impugned order dated 24/4/2014 at annexure, yes, the first respondent had ಏನ್ ಮಾಡಿದ್ರದು? Rejected the application filed by the petitioner for transfer of Tata in the name of the petitioner on account of a suit in OS number 195 of 2012 being pending relating to the said suit between the parties. The counsel for the petitioner has filed a memo dated 7/9/2023 enclosing the judgment passed in OS number 195 dated 7 September 2018, by virtue of which the suit filed by respondent number 3 against the petitioner had been dismissed. On respondent number 3's legal representatives having challenged the said judgment in regular appeal number 118 of 2020, the first appellate court, while the judgment dated 1st December 2022, dismissed the appeal. In that thereafter, the counsel submitted there is no further appeal filed challenging the judgment of the first appellate court. In that view of the matter, the annexure S, having rejected the application of the petitioner only due to the pendency of the suit in OS number 195, the said suit has been dismissed and the appeal also has been dismissed. The reserving liberty to the petitioner to place the said judgments before respondent number 1, the petition is disposed. Respondent number 1 shall consider the said judgment and pass necessary orders within a period of 30 days of receipt of the copies of the judgment. After 30 days, Tata, we can't give you more time.
Please, madam.
OD ಅದ್ವಸ್ತಿಗೆ ಸ್ವಲ್ಪ ಕೊಡ್ತೀವಿ. Tata ನಿಮ್ ಇದು ಸಕಲ ಇರೋದೇ 30 days. So the date that they furnish, or ಯಾವ್ದು furnish ಮಾಡ್ತಾರೋ 30 days. Yes, what happened 7/11?
Application filed, they have taken a time for filing the petition. We posted to 6th October.
6th October.
The order.
Lord Counsel for respondent, Shri T. Abdullah. Lord Counsel submits. But same thing will apply.
Same.
And Shri K. Prasad Hegde, the counsel for response submit that an application in order 7 Rule 11A read with 26 of CPC as has been filed in OS number 671 of 2016, which is numbered as IA number 9. The defendant, the plaintiff in the said suit, having sought for time, the matter is now adjourned to 6/10/2023. Shri Withdrawal and counsel, you are appearing for the respondent. Counsel who appears for the for respondent number 1, who is respondent number 1 who appears for the defendant in OS number 671 of 2016 before this court, submit that by that date necessary objections would be filed. The said application to be considered by the trial court in terms of the orders passed by this court in various matters. Relist on 31st October.
Dispose arbitrary suit, it will be.
And we can take. We have passed necessary orders in all those things. So civil court will not have jurisdiction for it.
Serial number 34, item 35.
Different number 8.
ಇಲ್ಲ 35 ಇದೆ running. 35 ಅಲ್ಲಿ ಇಲ್ಲ ಮಿಸ್.
ಅವ್ರ ಅಪ್ಪನ ಹೆಸರ ಮಾರಪ್ಪ ಅಂತ ಕೊಟ್ಟಿದ್ದೀರಿ.
ಅಲ್ಲ ನೀವು 35 ಇದು ಸಿಗ್ಮಲಪ್ಪ. Serial number 35. You are not there in this. Yes, Mr. Shankar Reddy. Why, Mr. Rajeev?
My only solution is the contesting respondent files a suit for relief of declaration against me. I filed a suit not for the relief of permanent injunction. When both the suits are pending consideration, Annexure B has been passed where the revenue record which stood in my name for more than 15 years have been struck down. That is challenged before this honorable court.
When the suits are pending.
He has filed a suit for declaration, and I had filed a suit for relief of permanent injunction. My suit cannot was for the relief of permanent injunction, dependent debt, therefore no cause of action. But this suit for declaration against me is pending disposal. Evidence is being recorded. During the pendency of the said suit, Kata entries, the revenue entries in the panchayat which stood in my name for over 15 years have been struck down, and his name is sought to be entered there.
It's the other way around. Existing Kata entries in my standing in my name, that is struck off and his names are entered. I therefore may
Who is the petitioner?
He is the petitioner. Therefore I file the appeal. It is now restored, against which he has now come to the court.
To us when it was in your name?
And how insertions are made in the records for a period of time. Your lordship could see the records that have been made available before this court. Same set of documents I applied for certificate copy in 2 different years. Earlier, what was given, it did not indicate his name. Subsequently, and applied again in the year 2017, insertions are made. Your lordship may kindly. If not for the insertions,
Somyaji, you have to answer all these allegations.
And more interesting is not this any change out of that will happen. It's any change made without resolution, it cannot be. Extent of land as per this
When was
40 feet to the 30 feet.
which is the oldest document before us now? Where whose name is shown?
The oldest document is of the year 1966-67. 1966.
You'll place it. It's not been placed. You need a.
Not in the suit, they are relying on this particular document, and evidence is being recorded.
ಅಲ್ಲಿ ಇರೋದಿಲ್ಲ ಇಲ್ಲಿ ಕೊಡಿ ಏನ್ ಕೊಡ್ತಿರೋ ಕೊಡಿ.
Annexure J, page 50.
That is the oldest.
Oldest, 1968-69.
It's already there, ante. Where counsel for respond number 6 to 11 seeks for and is granted 10 days time to get it and make a submission. released on 5th October. It is no further agreement to be granted on that.
In the meanwhile, those.
Add to Garo. Shri Soumya ji was entered up as for respond number 3 and 4, accepts notice for respond number 2 also. Registry is direct print his name as such.
In the meanwhile, not these very entries, disputed entries. The declarations.
To dispose the matter, Mr.
Serial number 36, 37.
Yes, Mr. Siddhabalappa. You have for respond number? 5. The tender coconut.
Tender coconut. It is a PDA land. Tax, regarding tax paid is concerned.
Self-assessment Allah is there.
Coconut vendor is seeking the.
What is the page number of the tax paid receipt?
Last time on the responsible argument BDO party model on the allotment party.
This page 10 it's not SAS. This is a collection that you have made. Several times you are closed on the page. You come to page 14. Is one name, Mr. Reddy. Bangalore 1 BWSSB water connection particular. Page 14 is one. Next year A5. Owner's name. Owner's name and property address. A column nodi. Holder C. Manjula. Then file your statement. File your statement as to what it is. They have produced this.
The tax conservation is for site number 2 for E. What they are now claiming in the information is 2.14 per S. The same bit of which has been executed in mind now by the committee.
Let them place their record.
I guess
You cannot say anything about it. The corporation has to say. They are the ones who have received the money.
what is mentioned in the
You are not the counsel for the corporation. It's for them to make their stand clear. Without them making their stand clear, it will be difficult to go ahead. Otherwise, if they don't make their stand, we'll have to go ahead.
assuming the tax paid which is site number 2.14 bar E. What they are now claiming in the writ petition is 2.14 bar S and T.
So what is there in 2514E?
Yes, he decided that has been posted in 91 video. Still it is extended. That may kindly see the prayer also. Now if they pay tax 2.14 per E, they have to claim 2.14 per E. They cannot be claiming 2.14 for S and T in the case of paying tax 2.14 for E. You have to kindly see prayer page 7. Therefore, the petition goes earlier to the case this one is to issue with the matter of that.
Where is your sale deed?
I say it my God is produced the value of the business by BDA. I have also got a completing application got completed. I say it. It is dated 14/9/2018. This small size measuring 54 square meters. Dated 14/9/2018. For this. Yes. Tax to for E, right according to petition. They come and claim 2.14 for S, with a prayer for allotment. Therefore, with respect to
Mr. Sirmalappa,
Please, Manoj, please, Manoj.
tax paid is with regard to 2514E.
That's right.
Your prayer is for S and T.
Lord, the S and T, Lord, now, Lord, they wanted to identify it as S and T.
You can't do that if you
Lord, your Lordship may kindly see, Lord, Annexure B, Lord, page 21.
There's already a sale deed executed for that.
Lord, the proceedings was pending before the Bangalore Development Authority. Lord, since Lord 2017, Lord, Annexure B, Lord, the proceedings initiated.
Sirmalappa, you are here before us asking for a mandamus to execute a sale deed in respect of 2514 S and T.
Lord,
There's already a sale deed executed.
my request, Lord, the portion of property which one now sale deed is executed is awaiting to my place. My place is very small portion.
Now you are before us on a mandamus when a sale deed is there. You're not challenged it.
Lord, I have not made known this sale deed at any point of time. Even now, Lord, they have not served copy to me.
They are registered documents.
Registered document, it was not made known to me, Lord, by anybody.
Now you are known about it. So
Please,
your mandamus cannot be granted.
No, just I will am, Lord, I can amend, Lord, if he provides me a copy.
They filed it. The BDA has filed the objections.
Sale deed copy was not furnished to me.
Sale deed copy is there. 22/4/2019 they filed. 4 years ago.
Lord, they served copy of the counter. I could not have.
Received advocate for petitioner antide.
The counter ಕೊಟ್ಟಿದ್ದಾರೆ sale deed copy ಕೊಡ್ಲಿಲ್ಲ.
Statement of objections ಜೊತೆ documents ಕೊಟ್ಟಿಲ್ವಾ?
Document ಕೊಟ್ಟಿಲ್ಲ.
Implementing application also ಹಾಕಿದ್ದೀವಿ. Application is served along with the
Implementing application ಜೊತೆ ಇದೆ ಅಂತಲ್ಲ. ನೋಡಿ ಹಾಗಾದ್ರೆ.
I'm not a small request. Let they furnish me sale deed copy. To know about the.
ಆಯ್ತಪ್ಪ ಒಂದು ಕೊಡಿ.
I will serve once again.
ಇನ್ನೊಂದು ಸತಿ
I
ಕೊಡಿ.
will serve some.
Learned counsel for respond number 5 submit that a sale deed in respect of site number 2514/S has been executed in favor of respond number 5 way back in the year 2018. And as such, the release cannot be granted. He is directed to furnish a copy of the said sale deed. He is directed to furnish a copy of the said sale deed to the counsel for the petitioner, who seeks for and is granted 10 days time to go through the same and get instructions and make a submission. Release on 3rd October.
Please, Manoj, please. Great as well.
ಅದು ಇನ್ನ ಒಂದು ಟೀಗೂನು ಇದೆ ಸೇಲ್ ಡೀಡ್ ಅದನ್ನು ಕೊಡ್ತಾರೆ.
ಅದೇ ಕೊಟ್ರೆ ನಾನು ಅದನ್ನು ಸರಿ ಮಾಡ್ತೀನಿ.
ವಿಡಿಯೋ ಅಬ್ಜೆಕ್ಷನ್ ಜೊತೆ ಇದೆಲ್ಲ ಕೊಡಿ. ವಿಡಿಯೋ ಅವ್ರು ಇಲ್ಲ ಇಲ್ಲಿ. ಯು ಓನ್ಲಿ ಗಿವ್.
Serial number 38.
Sudhakar,
Milord, in that, Milord, serial number 38, my
Yes.
name is shown for respondent number 1, Milord. But Milord, respondent number 1 is executive engineer, National Highway Division, so which comes under Milord PWD. So state government, Milord.
that is what we told them that day, but they are not. Good that you are here, Mr. Please explain to us this difference of National Highway Authority of India and National Highway Division.
Milord, National Highway Authority of India is a statutory body
Yes.
under state central government, Milord.
So you don't
Why-
have a National Highway Division under
Milord,
it.
National Highway Division, Milord, certain national highways under the Act, there is a provision that central government either can give it to state government for maintenance or it can give to any statutory body. So certain national highways are given to NHAI, National Highway Authority of India, and certain highways are given to particular state government. So when it is given to
when we
state
see
government
Executive India National Highways Division, it is the state government.
division, yes, Milord. It comes under PWD, Milord. National Highway Division comes under PWD, Milord. When it is National Highway Authority of India, it's
See, the problem with
It is the same like the Bangalore. Road pass in shops in
the problem ಏನಾಗುತ್ತೆ ಅಂದ್ರೆ the petitioner, because it's a national highway, they'll put it as national highway. Under whose jurisdiction it is, they don't know.
You will take it from the PWD.
Milord, but in fact, here, Milord, they have specifically stated that National Highway Division, Milord. That means it's a state government.
But then they say, they write it there and they say you have to accept notice.
Yes, Milord.
Now we'll direct the AG. Ms. Shilpa Shah, Lieutenant Counsel for Lieutenant Counsel, who was directed to accept notice for respondent number 1, submits that respondent number 1 is a division of the Public Works Department and not of the National Highway Authority of India. In that view of the matter, registry is direct delete her name as that appearing for respondent number 1. Learned AGA accepts notice for respondent number 1. He seeks for and is granted 3 weeks time to obtain instruction, make a submission. Released on 26th October.
I'm highly obliged.
List ಹೋಗಿಲ್ಲ ಅನ್ಸುತ್ತೆ spelling
38. Registry is directed to correct the name of the council appearing for respondent number 3 as Abhinav R. Registrar Judicial to look into. ನಾಲ್ಕು ಅಂಗಡಿಗಳಿದಾವ. It's basically a commercial building.
Your Lordship. One, page number 67, madam, in my petition. Annexure 2. Page number 50, annexure 2. 67, annexure. Second term, madam.
One ನಿಮಿಷ. There's 3 other floors also above. ಅದ್ರಲ್ಲಿ ಏನಿದೆ? First, second and third residential. ಇಲ್ಲಪ್ಪ. Who are you for, Mr. Anirudh?
Proposed respond number 4.
Proposed response. You are the complainant. What is there in the first, second, and third floor of this building? Residential. Now, this total extent of these 3 shops is 4 shops. 3 are working, 1 is not there. 68, 98, around 136 or 137 square meters. Total active. Total active land. Bakery, Miracle Touch and Rain, what is that? Dry cleaner. And you have 7 zonal regulations. C1 permits saloons, dry cleaners, and bakeries. Subject to 20% of total built-up area or 50 square meter, whichever is lower.
One last one, page number 67. Annex 2.
Ban. 67.
This is Annex 2. Paragraph number 2. 4th line is that. This is AC minute before retire.
Yes.
You are last time is Adipodi Sanchara Tanuru sector.
Annexure Q is not 67.
Attadi 40. Attadi 30.
When you are the owner of the building or you are a tenant of the building?
Tenant. I'm a bakery manager, vending bakery.
Bakery, you can be the owner.
Hello?
Owner or tenant? You dry cleaner owner or tenant?
No,
Saloon? See, you can't do more than 50 square meters. Nimdobburdu 37 ide. You will have to decide which one. Okay. Between you and the owners, you have to decide. Only one shop will continue. You can't do more than 50 square meters. ನಿಮ್ದು ಒಬ್ಬರದೇ ಕಮ್ಮಿ ಇರಬಹುದು. ಬಟ್ 3 ಸೇರಿದ್ರೆ ಕಷ್ಟ ಆಗುತ್ತೆ. 4.
Less than 2005.
Zonal regulations are there. Have you issued notice to the other shops and the owner? Why only target him? Have you issued notices to them? Signatures for the Mazaralla. You have to issue specific notices to all. You ಒಬ್ಬರಿಗೆ ಕೊಟ್ಟಿರೋದಲ್ಲ notice. Article 14 violation ಆಗುತ್ತೆ. But you issue them notices or verify. If not issued, issue them. A memo. ಯಾರೋ ಏನೋ ಕೊಡ್ತಾರೆ ಅಂತ ನೀವು ಅವ್ರದೇ ಮಾಡ್ತೀರಾ? ನಾವು ಒಂದು ಕಂಪ್ಲೇಂಟ್ ಕೊಡ್ತೀವಿ. ಹಡ್ಸನ್ ಸರ್ಕಲ್ ಒಂದು ಬಿಲ್ಡಿಂಗ್ ಇದೆ, ಅನ್ಆಥರೈಸ್ಡ್ ಬಿಲ್ಡಿಂಗು, ಡೆಮಾಲಿಷ್ ಮಾಡಿ ಅಂತ ಮಾಡ್ತೀರಾ? ನಗ್ತಾ ಇದ್ದಾರೆ. You have to verify. Complaints may come. Complaints may not be genuine. And you have given complaint only against the bakery. Trade license expired. Then what action have you taken?
Petitions allowed in cost order.
Cost order. So now trade license is there. After that, it was renewed.
After that, the submission was made across that the renewed application is fine, but it is not part of the record.
Page number 47, Annexure M.
Yes.
Petitions allowed and cost order and to direction to reconsider the matter.
Page number 15. The same thing.
There you have challenged 29/9/2016. Adರಲ್ಲಿ ಏನ್ ಚಾಲೆಂಜ್ ಮಾಡಿ 29/9/2016. ಇದರಲ್ಲಿ you are asking for 14/9/2017.
Annexure came in at date 29/9/2016. Issued stating that license has been cancelled. That already passed and remit the matter. And one more notice has been issued.
Because liberty was reserved. Para 9, page 53. You can run, we understand it's a livelihood, but you can't disturb other people in a residential. ನಿಮ್ಮ ಮನೆ ಮುಂದೆ ಬಂದ್ ಮಾಡಿದ್ರೆ ನಿಮ್ಮ ಮನೆ ಅಂದ್ರೆ ನಿಮ್ಮ ಕ್ಲೈಂಟ್ ಮನೆ, ನಿಮ್ಮ ಮನೆ ಬೇಡ. These are all residential areas which sanctity has to be preserved. ಎಲ್ಲ ಕೆಲಸ ಮುಗಿಸ್ಕೊಂಡು ಮನೆಗೆ ಹೋಗೋದು ಏನಕ್ಕೆ? ಅಲ್ಲೂ ಗಲಾಟೆ ಇರುತ್ತಲ್ಲ. ಏನ್ ಮಾಡ್ತೀರಾ? You want some time to vacate? Tell us. Get instructions.
Each time, meantime, I verify my client.
Get instructions and tell us when you will vacate. You have suffered all these orders. Now you can't be there. Shri Jagdishachari, learned counsel for the petition, seeks from is granted 10 days time to obtain instructions from his client as to when the petitioner would be vacating the premises in question. released on 27th.
Not obtained was in possession of site number 197. And the petitioner was in possession of site number.
Yes, then. Adelaru matadi illa ಸ್ವಲ್ಪ ಜೋರಾಗಿ.
The petitioner husband was was in possession of house number 197. And so far as petition is concerned, not the site number, house number 201 in possession of the property. But the kata was also affected. Not in fact, kindly look at page 30 annex D. Building license was also given in the name of the Munegoda. Page 40, page 30 annex D.
Yes.
And these document is coupled with not an endorsement issued at annex D. Page 29.
Yes.
Thank you.
$269 ಬರುತ್ತೆ. ಇದು ಎಕ್ಸಿಕ್ಯೂಟಿವ್ ಆಫೀಸರ್ ಅವರು.
EO
269 is EO. Section ಯಾವುದು? Which provision must be there? This is not appellate power, this is revisional power, so moto. So moto or baraku power difference. It's not appellate power.
In fact, they were kindly appreciate.
269 ಬರಲ್ಲಪ್ಪ EO order. EO has passed the order, so
EO has passed the order.
269 won't come. He cannot be appellate authority over himself. ಇಲ್ಲಿ ಯಾರು ಪಾಸ್ ಮಾಡಿದ್ರು order?
EO has passed the order.
So 269 can't come. ಸರಿಯಾಗಿ ನೋಡಿ, we'll come back. But we'll come back a little late. ಮಧ್ಯಾಹ್ನ 2 bench ಇದೆ. We'll finish that bench. In the meanwhile, you can have a long lunch. Next week.
Lordships kindly.
Learned counsel for respond number 4 seeks for and is granted 10 days time to assess, to verify and make a submission released on 3rd October. 49. Have you informed that? Ellargu madidira? 49 at the request of counsel for the petitioner released on 9th October. Madhuyalli, you are gate crashing this side. Yes, Mr. Naik. Where is the counsel for the petition? Copy code. 52 learned counsel for the petitioner undertakes to furnish 2 sets of the petition along with annexures on the counsel for respond number on the counsels for respondents who seek for and are granted 3 weeks time thereafter to file their statement of objections. Objections, if any, by 26th October, we list on 31st October. Yes, madam.
Worships kindly.
Just a moment. 42. Yes, ma'am. As Council said, I filed a memo dated 15/9/2023, seeking permission to signed by the council for the petitioner, seeking permission to withdraw the above matter, accepting the memo and submission of the council for the petitioner. Petition is dismissed as withdrawn. 77 interim order. Right.
78.
Line.
Number 45, my lord. Morning estimate ತಗೊಂಡಿದ್ದೇನೆ. ಅದರಲ್ಲಿ entry order ಕೂಡ extend ಆಗಿದೆ.
45 interim order, date change ಆಗಿದೆ.
29.
29.
78.
All the information that he is not given in the local
That's a research that has been given by Parliament.
78, it is stated that N.R. Jagdishwara would be appearing for respond number 1 and 2. Registry is directed to print his name as such. He seeks for and is granted 2 weeks' time to file a statement of objection. Objection, if any, by 6th, released on 13th. Interim order earlier granted is extended to next year. 55. Inform ಮಾಡಿದ್ದೀರಾ? ಎಷ್ಟು ದಿನ ಬೇಕು? Council for respond number 2 seeks for and is granted 10 days time to file a statement of objection. Objections, if any, by 29th, released on 5th.
80. Respond number 8. He's in the Lord. Responded to 9. He is not notice. For the respond number 9 is concerned.
80, issue notice to respond. Registries that correct the applicants, Sri Ashok and Naik, as that appearing for respond number 6 to 8.
7 and 8.
6 yaro.
6 to
6 to 8. Registry is directed to issue notice to respond number 9, returnable by 30th October. Interim order area. Interim order earlier granted is extended. Notice agorge eng madakagutte they have to come. We can only consider interim order without their appearance. We can't dispose. Extend. Yes, madam. Somebody made a
42, my lord.
42.
Take instruction. I'll make my submissions for next week, my lord.
42 dismissed as withdrawn.
Much obliged, my lord.
ಏನು submission ಮಾಡಬೇಡಿ ಓದಬೇಡಿ.
Lords 57, my lords.
Much obliged.
57.
Yes, my lords. 1 week's time may make for you.
Have you informed the respondents?
No, my lords. All the respondents are not represented.
No, andre illa.
Court officer 42.
Number
42. Court officer. Court officer? Court officer? Court officer? Court officer?
Madam, ಹೇಳಿ
42.
42 dismissed as withdrawn ಹೇಳಿದ್ರಲ್ಲ ಸಾಹೇಬ್ರ.
ಹೌದೌದು, ಅದನ್ನ ಹೇಳಕ್ಕೆ ಅಂತ ಬಂದೆ. Thank you, madam.
Hello, court officer? Court officer? Court officer?
Camera.
Camera ಇಲ್ದಂಗಿದೆ ಇದು.
No.
ಬಂತದೆ ಸೇಮ್ ಕೋಟ ಬೇರೆ ಕೋಟ್ ಬಂದಿರಬೇಕು. ಇಲ್ಲ ಬರ್ಸಿದ್ರು ಬಸ್ Court officer. Madam. Voice ಕೇಳಿಸ್ತಾ ಇದೆ ಮೇಡಮ್. ಸುಧೀರ್ ಸಿಂಗ್ ಒಬ್ಬರು ಇದ್ದಾರೆ ಮೇಡಮ್. ಕೋರ್ಟ್ ಆಫೀಸರ್. ಕೋರ್ಟ್ ಆಫೀಸರ್. Court officer. ಎಷ್ಟು ನಿಮ್ಮ ಕೋರ್ಟ್ ನಂಬರ್ ಎಷ್ಟು? 16.
ನಾಗಣ್ಣ ಸರ.
ಎಸ್ ಸರ್.
ನೀವು ಯಾವ ಕೋರ್ಟಿಗೆ ಇದು ಅಪೇರ್ ಆಗತ್ರಿ?
16 ಸರ್.
ಸುರೋಜ್ ಗೋವಿಂದರಾಜ್ ಸಾಹೇಬ್ರದು.
ಎಸ್ ಸರ್. ಸೀರಿಯಲ್ ನಂಬರ್ 3.
ಅದೇ ಹರ್ಷವರ್ಧನ್ ಜೊತೆ ಇದ್ದಿದ್ದು.
ಇನ್ನು ಸಂಜೀವ್ ಕುಮಾರ್ ಸಿ ಪಾಟೀಲ್ ಅಂತ ಹೇಳಿ ನೋಡಿ ಸರ್. ಫರ್ದರ್ ಹಿಯರಿಂಗ್ WP 201191/19 ಕಾವೇರಿ ನೀರಾವರಿ ನಿಗಮ ವರ್ಸಸ್ ಸ್ಟೇಟ್.
ಹಾ ಆಯ್ತಾಯ್ತು ಸರಿ.
The other person, 3.1. ಹಾಕಿದ್ದೀವಿ.
Sir, court officer, sir.
ಹೇಳಿ ಸರ್. ಹೇಳಿ.
ಅದೇ ಇನ್ನು ಪ್ರೊಸೀಡಿಂಗ್ ಸ್ಟಾರ್ಟ್ ಆಗಿಲ್ಲಲ್ರಿ?
ಇಲ್ಲ ಸರ್, ಡಿಬಿಗೆ ಹೋಗಿದ್ದಾರೆ, ಡಿವಿಷನ್ ಬೆಂಚ್ಗೆ ಬರ್ತಾರೆ.
ಓಕೆ ಥ್ಯಾಂಕ್ ಯು. Solution of bond. Pursue the multi-party control.
One vehicle man, 70% to one vehicle man, 30% this discussion ಮಾಡಿದ್ದಾರೆ ಆ ದೇಶದಲ್ಲಿ 70% ಬರೋದಕ್ಕೆ ಅಗ್ರಿಮೆಂಟ್ ಮಾಡಿದೆ ಬಟ್ ಅವ್ರ ನೋಡಿದ್ರೆ ಅದು 30 ಅದು ಡಿಸ್ಕಷನ್ ಮಾಡಿದ್ದಾರೆ ಬಟ್ ಅದು ರೆಗ್ಯುಲರ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ರೆಫರ್ ಮಾಡಿದ್ದಾರೆ ಲಾಸ್ಟ್ ಕನ್ಕ್ಲೂಷನ್ ಮತ್ತೆ ಅದು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ದಾರೆ
ಕೊಟ್ಟಿದ್ದಾರೆ.
Mr. Sudhir Singh. Mr. Shanti Bhushan. Any central government standing council? Pass on.
This Shashi Kiran is held up in other court, Madam.
Pass on. Yeah. Same. Pass on. The Advocate General is held up in other court. To ask for pass on. Hmm. 65. Hmm. Yes. Mangur Kartu. Mr. Bandari. We'll pass over and we'll ask him. So according to you have complied, it is the corporation which has to do. Hmm. 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 1 crore has been released. You released it.
Their requirement is 300 liter of supporting body.
300 plus 15 or 300 inclusive. So another 5 crores. Yaar kodtare? Neeve kodbo. Neeve kodbo. You are the only link between all of them. You make your submission on that. So we'll ask them. So minor irrigation is not required to pay and revenue department is not required to pay in place. We'll ask Mr. Bandari. Pass on. I'll band the organ now. There are 5 office objections. Some parties have not been made.
Some respondents, some non-contesting respondents who are co-respondents in the original proceedings, they have not been made as parties by us. Because we are not
seeing you to decide who to make. If they are parties earlier, you have to make them parties.
But they were not parties to be appealed for. In the sense, not.
Once they were parties and you did not make them in the appellate forum also.
They were not parties.
You filed the appeal.
They were a co-respondent along with me in the before the original.
You filed the appeal.
Yes, the petitioners have filed the appeal before the.
So at that time you did not make them a party. So you can't take advantage of your own wrongs.
They were co-respondents in my case.
We don't know what their stand
It
is.
says, some third party will not initiated proceeding for cancellation of cartas executed by the printed in army.
You have to make them parties, that's all.
But may I just put the crux of the matter, this is all.
Where the first parties money? Application act.
I will.
You cannot choose if who you will not make a party once they are parties earlier.
They did not choose to file an appeal. They were individual
So
property.
you should have made them respond. We don't know what their stand is. How will we get to know?
Very well, if you got it, pencil, then I can make it. Monday onwards, because there is some urgency.
Monday.
Because it is quorum launch.
Monday postmark. The counsel for the petitioner seeks for granted 2 days time to file the impleading application to implead the parties left out in these proceedings. Relist on 19th. So
20th or something, there could be a possibility of.
20th to 22nd, we are not sitting. So it'll go before another one, 21st. Then 20. 19th Raja. Just on 25th.
I take it or
19th. Written submissions file. Written submissions file.
ಇವತ್ತು ರೆಡಿ ಇಟ್ಕೊಂಡಿದ್ದಾರೆ ಅವ್ರನ್ನ ಸ್ವಲ್ಪ ಫೈಲ್ ಮಾಡಿಲ್ಲ ಕೇಸ್ ಕರೆದಾಗ ಕೊಡ್ತೀನಿ ಅಂತ. ಶೆಡ್ಯೂಲ್ ಗೆಜೆಟ್ ಬಂದಿದೆ ಇದೆ.
In the original Gazette, F is tax on advertisement and voting. Original Gazette only, tax on advertisement and voting. Illiде. Right side. Clause F. What happened to this clause F and when? ಈ ಬುಕ್ಕಲ್ಲಿ ಏನೂ ಇಲ್ಲ. ಈ ಕ್ಲಾಸ್ ಎಫ್ ಏನಾಯ್ತು, ಯಾವಾಗ ಹೋಯ್ತು? ಈ ಬುಕ್ಕಲ್ಲಂತೂ ಏನೂ ಇಲ್ಲ.
Holding. Is not something new conception. Advertisement holdings were there. Even when I started the practice in 1972.
They've been there from eternity. Other than problem illa. But illi problem iradu from when, what is to be taken into consideration.
Now, prior to the law being made,
Yes.
by the legislature, we were governed by the contract. Except to the extent that if the property of the panchayat is utilized for erection of the hoardings, ground rent has to be paid. And so far as erection of the hoarding and displaying advertisement is concerned, it will be a question of license.
Yes.
For permitting display of the articles, license being issued and license fee is required to be paid. Section 64 and section 7. Schedule 4 refers to the tax that is payable. There is a clear distinction between the tax and fees. In the Shirurma's case, reported in the LR 90.
ಏನ್ ರಿಲೈ ಮಾಡ್ತಿರೋ ಇಲ್ಲಿ ಕೊಡಿ, ಪ್ಯಾರಾ ನಂಬರ್ ಹೇಳಿ, ಅವ್ರಿಗೂ ಕಾಪಿ ಕೊಡಿ.
ಅದೇನಾಯ್ತು ರಾತ್ರಿ ನಾನು ವೆಬ್ಸೈಟ್ ಓಪನ್ ಮಾಡಿ ಟಾಪಿಕ್ ತಗೊಂಡೆ, ಇಲ್ಲಿ ನಮ್ಮ ಲೈಬ್ರರಿಗೆ ಹೋಗಿ ತೆಗಿಸಿದ್ರೆ ಅದಕ್ಕೂ ಇತ್ತು ವ್ಯತ್ಯಾಸ. ಓ ಪಾರ್ಟೀಸ್ ಆರ್ ಒಂದೊಂದು ದಿವಸ ದೇರ್ ಮೇ ಬಿ ಒನ್ ಮೋರ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಐ ಡೋಂಟ್ ನೋ.
Then shall we have it on Monday or Tuesday?
Subject to this,
Because we'll take it up subject to better, because again adjourning it for that purpose won't make any difference. So you get those whatever judgments you want, whatever you want to rely upon, we'll take it up on Tuesday and you can conclude. Adukosra idu madadu better. And Patil, when you are not here, we had called for the gazette, original gazette. Gazette ಅಲ್ಲಿ ನಿಮ್ದು F ಇದೆ.
It is under 44 of 2000.
44. F is there. We also require your assistance to find out, we try to find out what happened to that. Of course, there's one other amendment which came in immediately thereafter. ಈ 44 ಅಲ್ಲಿ ಅದು ಬಂದಿದೆ, but 44 again, the entire amendment is different in this book. So what happened to that clause F? Both of you will also have to assist us in that. And when did that clause F go and how did it get replaced by what we have now?
We'll try to get the gazette in that's called Nodi. Maybe the High Court library might have.
We'll also be instructing live because we act on the schedule 4 in a lot of matters. Schedule 4 is sari illa andre. It will be a mistake. Everything will.
We may have to lay our hands to all the amendment acts.
Ade tarsidive adella. Original gazettes we have got it. This has happened earlier, but not in as much as like this. You know, on the small here or there. In this one, we are having so many issues. or which are not covered or which went away. There's a timing from when to what. Because 2000, when section 178, huh?
72A.
72.
Section 70, subsection 2.
So that gives the license. Prior to that, it was taxed under section 199. So until then, until 72A came about, it could not have been licensed, it had to be taxed. Once 72A comes, then there could be a license. But it predicates that license fee on Schedule 4. However, you have come up with in 2013, prior to 72A coming into force, the model bylaws, which have been adopted.
Model bylaws were framed by
We are also, not to take the risk,
number of
we are making an application, seeking an additional prayer to strike down those 3 items. Last 3 items in that model bylaw. So that there need not be
So you're filing
an
an
elaborate
application.
argument that it should not be enforced, etc., etc.
So you're filing an application. Ready, yeah?
Counter file ಮಾಡಿದೆವು. We wanted to call it.
So we'll allow that at least. They're entitled to challenge.
I think government will have to pay the statement of.
ಅದು ಬರುತ್ತೆ ಆಮೇಲೆ. Now that you are there, you will have to explain to us what happened to that clause F.
That's one thing we will try to get the copies of all the cases so that some compilation ಮಾಡ್ಕೊಂಡು ಹೇಳ್ಬೋದು.
There is no compilation. ಎಲ್ಲೂ ಇಲ್ಲ. ಅದೇ problem ಆಗ್ತದೆ. Different publishers are having different.
ಅಲ್ಲ ಈ
applications. We have called that.
All the amendments being inserted.
Gazette notifications.
Gazette notifications are being inserted in the act itself, so that it will be easy to follow.
ಅದು ಆಕ್ಟ್ ರೀಪ್ಲೇಸ್ ಆಗುವವರೆಗೂ ಹಿಂಗ್ ಮಾಡ್ತಾರೆ. ಹೊಸ ಎಡಿಷನ್ ಬಂದ್ಮೇಲೆ ಅದು ಹೋಗುತ್ತೆ. So ಹೊಸ ಎಡಿಷನ್ is presumed to be.
Presumed to contain everything as amended.
The presumption has been wrong. You're pretty particular. They are application. Petitioner has filed an application in IA2 of 2023, seeking to place on record certain facts, as also seeking to challenge additional ground ಅಷ್ಟೇ ಇದೆ. Where the relief, Mr. There are no reliefs.
We'll make a separate.
We'll list it on Monday, Tuesday. We file the application, we'll allow the application. We'll give SCGP some time to file the objection, then take it up later. Tuesday. Relist on Tuesday at 2:30 PM.
ತೋರಿಸಿದ್ದಾರೆ ಪ್ರೊವಿಷನ್ ನಲ್ಲಿ ಸಿ ಡಿಲೀಟ್ ಮಾಡಿದ್ದೇವೆ ಅಂತ ಅಷ್ಟೇ ಬಂತು.
ಅದು F insert ಹೆಂಗಾಯ್ತು, who asked it to be inserted, how it came about is not there. ಆಮೇಲೆ F vanishes. How did it vanish ಅಂತ ಇಲ್ಲ.
Particular period, including the section.
Surprising. ಸ್ವಲ್ಪ investigation. Yes. Next.
Number 83. N. Manohar.
Classification continues.
Yes, Mr. Vivekanand.
Last occasion, I finished my arguments supporting that one. So better and that's to be indecent. You know, the petitioner made attempts under the provision of CITP 1, 2, 3. 3 attempts were made before the amendment of the MUDA. Thereafter, serial number 4 and 5, I have not applied since I was out of state as transferred to, because he was employed with the Candraman. He was not applied serial number 4 and 5.
There's no dispute about
There's no dispute. My tenant fund is
why are you producing this?
is disputing only the 5 attempts.
He is disputing 5 attempts on a different ground. He is disputing the 5 attempts, saying that
For that,
it has to be the same measurement.
Yes.
Then only it will be
For
taken.
that, I'm explaining that highly similar. Serial number 4 and 5, I have not applied because of that out of state. Highly similar, 6th attempt, 1994. 5080, I have applied. That is my first attempt. As per the my learned friend argument. That is 4th attempt as per mine, because of I calculated even if you consider the CITP first attempt 1985.
Mr. Manohar, why are you troubling yourself? Mr. Vivekananda has to answer.
Please.
Yes,
No,
Mr.
it is why you have changed the dimension. I have explained in this.
Regard to query on the application. But the rules doesn't say that the applicant would lose their seniority if they change the seniority dimension. But in the year 2004, when we notified, the notification itself, it is indicated that they will lose their.
You can't notify that without a statutory provision or something in support of it.
Let's say, so far as those aspects are not, rules are silent. We have evolved the procedure which has been commenced from the year 1991 onwards when the rules have come into force. In what fashion the notification is to be issued and what are the conditions to be stipulated, all those things are not stated in the rules. It is
what manner and all need not be stated.
Yes.
But if you are going to deprive a person who had earlier applied for a different measurement, merely on the ground that subsequent application is for a different measure, higher or lower, that the earlier ones will not be considered.
They change the seniority dimension.
That has to be supported by law because you are depriving somebody. Your administrative.
My respect to Commission is not a deprivation. They changed the dimension, and they are asking us to consider.
They put on notice by any law, Mr.
In the 2004 notification, they have been put on.
2004 is much after they changed in 94.
94, they changed the dimension. From 2004.
It should have been there in 1985. First time apply you change you lose the benefit. They should have been put on notice. Then they would have chosen.
That has not been done. I can't say what is not there in the result. That is not done. But I have other few submissions I will find out.
Yeah.
One aspect is that the very same contention of when approach the district consumer forum, actual R6 page 32. Statement of objection filed by
Yes.
on 9th January 2019.
R6 is the order.
Order passed in the
Consumer Court.
The complaint filed by the petitioner. That the relevant portion would be on page 42, paragraph number 8.
Yes.
Similarly, under rule number 14, the committee constitutes the consider the allotment of rights as per rule and regulations framed from time to time. The burden is on the complainant to prove that seniority was above the seniority of Ramlingegoda, who was allotted a site in the year 2004. The complainant has mentioned in paragraph 5 of the complaint that he submitted first application in the year 1985 and last application in the year 1984. contention, there were 6 attempts. He has further stated that there were 2 applications on file 15/7/85, another 2 applications on 21/93, third time application on 18/4/1989, and the last application, 3 applications on 6/4/94. Merely because the complainant has filed number of applications on the same day, seeking allotment of site cannot be treated as separate applications. The complainant has paid to get the site. As per this one contention,
It's not the same day, these are all different days. It's not merely because complainant has filed number of applications same day. Cannot be treated as separate attempts is a wrong finding.
But on the same notification, there were 3 layouts, not the applications for card park. He has filed applications not in respect of each of the layouts. Because of that reason, not the district forum observes.
That is, no, your first notification is 6/7/85.
Yes.
Second notification is 25/8/1986. Third notification is 1989. They're not on the same day. His finding is.
On 15/4/94, but there, appeal not has filed multiple applications.
Where is his object? Where is his claim petition?
The applications are not certain.
You have to produce it because this is an interpretation being drawn, which you are trying to interpret further. But that appears to be contrary to the records.
The copy of the complaint is not immediately available. Not to get the copy of
The complaint and
produce all the attempts.
where is the complaint copy? Complaint copy idea ನಿಮ್ಮ ಹತ್ರ?
It's produced. But I have.
ಅವ್ರು ಆರ್ಡರ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ, ಕಂಪ್ಲೇಂಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ. ನಿಮ್ಮ ಹತ್ರ ಕಂಪ್ಲೇಂಟ್ ಕಾಪಿ ಇದೆಯಾ? Because that is the interpretation that court has done, which appears to be ex facie incorrect.
Next paragraph, paragraph 21 and 22.
Yes.
The forum says that the earlier application cannot be considered. But this order became final. There, we have filed appeal against this order. But
We'll have to look at the laws. You can't go by the summary proceedings which have taken place. That too when there is a wrong appreciation that number of applications were filed on the same day.
Ultimately, substance of the order is the earlier 3 applications were filed for smaller dimension cannot be taken into consideration is the finding of the district court.
Yes.
It became final.
That does not impress us.
That one was attention which I have heard in the objection statement that is the petitioner is an allotee of the site by a operating cooperative society in Bangalore. And that has been suppressed. But I have produced the copy of the Tata certificate earlier. Now I am producing the copy of the possession certificate allotment later.
In Bangalore, not in Mysore.
So anywhere in Karnataka, it is an allotee of the site.
Where is that? Where is, show the statute.
The subsequent amendment is not printed in that. I am furnishing copy of the notification by which it is amended.
This is 2013. When was the allotment made?
2017. The allotment for made in 2017.
Now you told it.
Yes, the application which the site is not yet allotted. The allotment process was completed in 2017.
What they got from the Bank Officers Cooperative Housing Society was in 1998.
Yes.
Retrospectively, can you apply this?
No, that's on the date of allotment by the Urban Development Authority, he should not have a site. It's not that on that day he was not eligible. On the date when the application is considered by the Urban Development Authority, he should not have own a site or a house in any way.
Unable to understand. You make amendments to your way of working to suit your requirements, and you expect, and you want to make it applicable to a citizen, if he had known this, he might not have taken that site.
It was in 1998.
Either in 2013.
The object is, if he is a beneficiary of the allotment, either by the BDA or by a housing.
What was the law applicable in 1998? If he had known in 98 and he took that site, yes, you can say that.
The interpretation, not my respectful submission, that meant that cannot be applied.
A person cannot be deprived of something without knowing can he expect that you will come up with a law in 2013 that cooperative society in the Thondreno Nang Sigalla? So I should not take it until 1998 or future they can expect.
Already having a site or a house is not entitled for another house or a site under a subsidized scheme by the government in the object.
Maybe the object, but was that a law in place in 1998 when he took that sale?
It did not, for this reason, I submit like. In 1998, he is a beneficiary of a site. A beneficiary of a site, by way of allotment, by the Housing Cooperative Society or BDA or Development Authority or KHP, that cannot subsequently apply for another subsidized allotment under a subsidized scheme.
After this law comes in.
Please, friends.
This law came in 2013.
Please.
All the attempts here by the petitioner were till 2011. Prior to that.
On the date of consideration of the application, this law was not prevailing. Though the application was filed in 2011, because of the interim order passed by this honorable court in another matter, but the allotment process was not completed. The applications were taken up for consideration only in the year 2017. On the date of consideration of the application, that the petitioner, the claim for allotment cannot be considered because of this amendment in 2013.
Yes.
Because they cannot be true benefits under a subsidized scheme, right? Is the object of the amendment.
Yes.
That
We will consider your submission.
That the main object will not be.
ಅವ್ರಿಗೂ ಒಂದು ಕಾಪಿ ಕೊಡ್ಬೇಕು. This is the last submission and recording. Para number ಹೇಳ್ಬೇಕು. ಓದ್ಬಿಡಿ, ಅವ್ರಿಗೂ ಕೇಳಿಸ್ತದೆ ನಮಗೂ ಕೇಳಿಸ್ತದೆ.
The duty of to direct the policy that citizens, men and women, equally may be secured the right to an adequate means of livelihood and the ownership and resources of the community have to be distributed to observe the common good, and the economic system is not allowed to result in the concentration of wealth in one or two hands. It also applies to them when you do so provide, particularly such as the use of residential housing cooperative society or BDA would.
G category.
No,
Judgment on G category.
No, it is a regular allotment. Shall be eligible to apply for allotment of the site if he or any member of his family once a house or site or he or any member of his family has been allotted a site or a house either by the PDA or any other authority within the value metropolitan area. The legislators and others have to take note that this should be made utmost caution so that the same is not or does not stand violated knowingly or unknowingly. Here is the case in which the person who held the office of minister and was a member of legislature at the relevant time, I feel sorry to find has made a false affidavit for the authority in 1981 when he had applied for state number 113 project, wherein the false affidavit stated that neither he nor the members of the family will own any state or house allotted in the metropolitan area, either allotted by the PTA or any other authority. The legislature housing cooperative society has also been a government of cooperative society. It can be found to be an authority. When he had applied for allotment of site in 1981, he had already site number 133 allotted by PTA. But this petitioner, who was legislature, having ignored the letters in spirit of court and doctrine of social and economic despite a partial service in outfit, two and with an intention to get more than one site allotted, but contrary to the basic scheme of the concept, then of Bangalore Development Authority, allotment of site and the rule 10 of the legislature resulting in an attempt to bypass those rules. The person holding such office understanding that they will not go too far when people may completely lose the person holding public office need to be very cautious with their conduct and behavior in their private office and keeping faith in their court and information. Affirmation to value of life in train and but ultimately posted has been started for another site. Since he is already a beneficiary of allotment by the PTA.
Archana? Any other submission?
After the allotment process is completed in 2020, that the initial deposit made by the petitioner has been returned. After that, the receipt of the initial deposit, the petition is filed. And therefore, that the petition itself is not being demolished.
Only as per their own endorsement stating that there are 6 attempts and those who are annexed K have produced, that is the cutoff date as once issued, published final list. They are given a strict this one, and those who are attempt 6 attempts and aged 14/5/1945, those who are 45.
You already argued on this.
Yes, that is not the case.
You are in reply.
Other sites are there.
Manohar, you are in reply.
Yes, so therefore, that this judgment at all does not apply to my case is concerned, and there is no dispute regarding the attempt is concerned. I have placed before the court.
The Council for Respondent has filed a memo dated 15/9/2023 enclosing certain documents. The same is taken on record. Third, Shri Manohar N, learned counsel for the petitioner, Shri T.P. Vivekananda, insofar as the compliance with order dated 23/8/2023, learned Shri T.P. Vivekananda, learned counsel for respondent submits that there is no particular statute or rule which would indicate that once an applicant for a site changes the measurement, he would be deprived of the earlier attempts. But however, he submits that this is the methodology which has been evolved by the MUDA, and this methodology is, when was it evolved?
From 1991.
From 1991. And the same has been followed by MUDA. Third, Shri Manohar N, learned counsel for the petitioner, Shri T.P. Vivekananda, learned counsel for respondent, reserved. ಬೇರೆ ಏನು ಮಾಡಿ ಲಕ್ಷಣ
Given a set of judgments, serious starts, those judgments.
Let him complete and then we can come.
Right.
There are two judgments he said he wants to make a submission. Paso.
Yes.
But ಇವತ್ತು ಬಹಳ ಇದಾವೆ ಸ್ವಲ್ಪ ಕಷ್ಟನೇ ಅನ್ಸುತ್ತೆ ನೋಡೋಣ. It will be difficult for it to reach. Because there's another matter of the AG is to come, so that may take some time. We can have it on 19th or 20 after 25th. Any day. We won't be sitting from 20th to 22nd. 25th. We list on 25th at 2:30 PM for the year. Aditya. In the 25th in now, there's another part at 26th we'll have.
Yes.
Shekhar, there's one more matter. Adeno recall ಇದೆ. ಹೌದಾ? So we'll adjourn that. For ಕಾಯ್ತಾ ಇದ್ರು ಆಗಲ್ಲ 14 learned at the request of learned counsel for the petitioner we list on 9th October or ಹೇಳ್ಬಿಡಿ ಇರಮತ್ತೆ. ಅದಕ್ಕೆ ಫ್ರೈಡೆ ಬ್ಯಾಟ್ it is. We'll have it on Monday, Tuesday. 85. We list on 19th at 2:30 PM for the year. Any central government council? Sir, print ಆಗಿದೆಯಾ? Appears released on 26th September.
Madam, Telegraph Act, not whether we have that already, the pipeline, that was the issue.
Yes. We wanted to rely on some judgment today. Yes.
The stand of the NTPC is identical to that of the state opposite parties. According to them, NTPC is a government company dealing with generation of electricity and allied activities. It was interested to set up 2 into 800 megawatt super thermal power project at village Toronto in district of Toronto to meet the electricity requirement of eastern region of India, including states like Odisha, West Bengal, Jharkhand. Apart from coal, what is the major critical requirement for setting up the thermal power plant and for generation of electricity? The company is in possession of all requisite approved permission and everything sanctioned by the government. The project is being set up as per the joint decision arrived between the government of India, the government of Odisha. The total area is close to 1,000 crore. The laying of pipeline, the laying of pipeline is being done at 1.5 meters depth on the ground surface, and the surface would be available for the utilization of the respective landowners. The state government has authorized the collector to issue appropriate orders under section 16(1) of the Indian Telegraph Act 1885, read with section 164 of the Electricity Act 2003 for acquisition of the right of user in respect of private property with proper compensation subject to certain conditions. So far as payment of compensation is concerned, the stand was that the entire compensation amount for 198 acres of private has already been deposited with the authority. After going through the conditions raised by various parties, it is pertaining to consequence. As if madam, then para 10 is from page 14. Para 14 is next page, madam. Now, this para 13. Also, the Electricity Act came subsequent to the Indian Telegraph Act. While the Electricity Act was enacted, they have referred to the Indian Telegraph 1884 in section 164 of the Electricity Act, wherein it specifically stipulated that the Indian Telegraph will be made applicable for the purpose of implementing the government order for placing electrical lines or electrical plant for transmission of electricity for public interest. The reading of the said provision is crystal clear in respect of the scheme. A mode of implementation is followed by mandate of section 164 of the Electricity Act, read with section 10 and 16 of the Indian Telegraph Act. Section 16 of the Indian Telegraph Act provides the mechanism of compensation, and the petitioner can have no grievance on that. Section 10 of the Indian Telegraph Act clearly stipulates the Telegraph Authority may from time to time place and maintain telegraph lines under, over, along, or across, or post it on, upon, or removal property. Section 10 of the Indian Telegraph gives power to enter upon, and there is no restraint except for complying with section 16 of the Act. So, such power under section 10 is expressed in public interest. The intention of the legislation is very clear. There is no ambiguity in such power under section under this Act. It would not amount to an accusation, even if it is intention of the legislature. However, section 16 of the Indian Telegraph provides for mechanisms for compensation. Then, next page, just above paragraph 16, 3 lines on top. Necessary for proper coordination of work conferred upon the other person engaged in the said work for supply of electricity as stipulated in this law. Authorized concerned collector so for acquisition of right of user in respect of private property with proper acquisition compensation subject to certain conditions. Thus, the same is in accordance with the statutory provisions. Last is paragraph, just keep reading all that, paragraph 20. With regard to the consent of the landowner before laying any electricity head or underground water pipe, it has been settled in so and so. Such consent is not necessary since no damage or permanent nature could be caused and the land could be used for agricultural purpose. Going through the whole thing, they say that when we select this or underground pipe, because there is no acquisition as such. It's only right of way or right to use. Para 19, which makes in view of the such power under section 10 of the Indian Telegraph Act, authority while putting an electric line or a water line can carry out such action as stipulated under section 10 of the Telegraph Act. The person, if aggrieved of any action, may take recourse to section 16 for Telegraph Act for higher compensation. On perusal of the impugned order dated so it is revealed that the state government authorized the concerned collector to issue appropriate orders under section 1 of the Indian Telegraph Act, read with section 164. Since the power is vested with the collector, so immediately compensation. Here, on facts, totally involved is 178 acres, madam. Out of which, it runs 18 kilometers for 178 acres. And there are nearly petitioner land is 9 acres, there are 147 land owners. So out of 178 acres, 147, only 4 petitioners to the extent of 9 acres, which is for 900 meters. Is a subject matter of this petition. So therefore, reading the Telecast Act and the Electricity Act, it is in the same corridor of 40 meters. This is being run. Water from Almaty River is being taken because it is a thermal coal-based project. Which the water is used to heat up the coal for purpose of generation. Without this water, it is impossible to perform. So the only question is whether acquisition here is not a case where we are acquiring the land. We are paying compensation 5 times the value of the land without acquisition.
5 times the value
Of the land, of the guideline value. In fact, I have stated that also in the statement of obligation. Statement of obligation. So, including the crop cost, the Australian what has been stated. Australian turn to page 4.
Yes.
Paragraph 10. For the purpose of laying of the pipes and transmission lines, NTPC entered into an agreement with almost all the landowners and crop compensation has been paid to the landowners as per the guidelines. So out of 148 landowners, 125 landowners have agreed for laying the pipelines as well as transmission lines and executed agreement with NTPC which we and consent and receive the compensation as per the order of the deputy. Due to family dispute or another reason, 10 owners are yet to come forward to receive the compensation, but allow the NTPC to erect the pipeline and transmission lines in their respective patches of land. Further, if 3 owners have approached the civil court for declaration and the NTPC deposited the compensation as directed by the honorable court. Rest of the 5 owners of the land is present before this honorable court. It is important to note here that all the oaths of laying the pipeline.
Where have you said, Mr. Shetty, that you are going to give 5 times the value of the land without acquiring? If you have said that, Mr. Ashwathan will be very happy.
What what the this are not 66,000 is the published guideline value as of guideline value 2015-16 66,000. What has been paid is 1 lakh.
Apart from crop compensation for that extent of 40 meters corridor, if you are going to pay 5 times, then we'll ask Mr. Ashwathan why he should not accept it. Because it will be better than the 2013 Act, which is the maximum that we can get from us. Page 3. Yes.
According just after election, according to an aggregated petition 9/2014 was entered by NTPC with so the Tahsildar filed a report regarding what transpired in the meeting chaired by the Deputy Commissioner so the copy of the report regarding what transpired in the meeting dated based on what was agreed in the said meeting, the Deputy Commissioner has passed an order dated bearing number
just show us that step 5 times. Very important.
In fact, I got the variation report.
Guideline value into 5, you just show us 1 or you file.
Your Worship, what is this is over stage 5 times. 66,000 was the land value in 15-16. Crop valuation, what was given is 5 lakhs. 5 lakhs 80,000. As against the complete guideline value of 66,000.
What does the crop grown here? What is the crop grown here?
Crop road was.
Sugarcane was.
Sugarcane. So ultimately, sugarcane, what either land, if you take the land value 66,000, it comes to 5 times. If you crop value, we have taken 10 years and then given, assuming that they have grown, invested, everything. So therefore, ultimately, if you see either way, it is 5 times more than the.
So 66,000 is the guideline value. And you are given?
5 times 80,000.
Not 5 times, is nearly 10 times, 8 times.
And one more thing, we have presumed that they are going to grow sugarcane, even though they grow or don't grow, that is irrespective. We have taken that they are going to grow sugarcane because the land is less, and we have calculated and given on that basis.
So then if you have got 66 to 518, you'll have to return that. Please remember, you'll have to return the 518.
No, I'm not received 518. They have determined it at that rate. No, not contesting that amount as well.
You can file an appeal if you are not satisfied with that.
At the most, what can be direct here? 66 into 3 times.
66 into 3 is the valuation. 66 into 4 will be the valuation, not considering solution. That will be their assessment. If I do that, 66 was not the value. 10 lakhs was the value. It will be 10 into 4. Not 66 into 4. Can I request it is 5 lakhs. 5 lakhs is the value. Even as per
if on a principle, if we accept Mr. Shetty's submission, that it will be on 5. So in a 16 appeal, you can always demonstrate what the cost is, and they'll pay 5 without acquiring. The submission of Mr. Shetty is without acquiring, we are paying X amount of money. So
if the determination under 16.5 will be done in accordance with right to fair compensation act, then there is no issue.
Right to fair compensation act and guideline value is market value. If you are able to prove
the actual market value,
if you are able to,
is one of the bases. If I establish 66 is not the value, and 5 lakhs is the value, it will straight away become 20 lakhs.
Pay 5 times.
Our assessment, the one way of assessing market value is 10 years capitalization method of the crop. Their own assessment of per acre is 5 lakhs. So if I show that to the board, it will be straight away 4 times of that value.
Going actual numbers, let me show the previous years we are going strictly to numbers. What we have learned and say that this is the number, this is because these are all notional. We say that assuming this is grown, fully grown, we are not deducting anything, fully grown. They are for 10 years, we said 8 years, but the 8 years comes up to 5,80,000. We value the land value, if it is land value of 60,000 as per the guideline value. So therefore, if we take the guideline value.
But what Mr. Ashwath is saying is 66, you have said, but if he is able to show it is 10 lakhs, 5 lakhs, 4 lakhs, even 2 lakhs. Then what happens?
The question, that's why here is not a case of acquisition, is still enjoying the property, using the property. So therefore, the question is, we have gone, how we have gone, we have been very fair in that you enjoy the property, we will not disturb you on your enjoyment of the property below this line, because we have put it underground, as well as they put a thing, you cannot construct, you can do agricultural activity. We are paying you 8 times the crop value for next 8 years, which comes up to another term, guideline value for maybe 8 times or 5 times. So therefore, he cannot raise his argument as if we have acquired the land. So therefore, this argument saying that we acquire the land, give me the market value 4 times, that will not apply. That if you do that for acquisition, you become the owner of the land.
It will be. Once they become the owner, it will be cordoned off. You can't use it.
We are ready to go for it. In fact, not buying inspections are. This is a corridor. There is a provision for compensation for severance. If I am entitled, I will establish and I get it, or I don't get it. But I am on the question of authority. More on that, Lord. It's the authority of the state to take away and say we are doing it in a. No. Even if you want to dig, Lord, there has to be an authority to dig as well. Lord, if he shows, Lord, the authority to lay that pipeline, Lord, I am out. Lord, this judgment which he has referred to, Lord.
Yeah, we finished. Then we'll come back.
Which statement is that, page number 7.
We have got only one then.
Page number 634.
Page 6 alla
634 on top.
634, yes.
First question that arises is whether the nature of provisions contained in those delivering the substance of provisions do not provide for acquisition of any estate, but only for acquisition of extinguishment or modification of the right in the estate. The term estate is defined under Article 31A, subclause 2, to include all kinds of land referred to in subclause 3 and clause A. Then the term right has been defined to include any right vesting in the proprietorship, sub-proprietorship, etc. While clause B of sub-article 2, under the provisions of the Electricity Act 2003 and Indian Telegraph Act 1885, in the question, the authorities under the direction of the government acquire several rights in estates. Those rights are in the nature of opening up and breaking up of soil pavement, any streets, railway, tramway upon certain conditions, and power to lay over in line, and for that purpose do all such things necessary, including removal of tree structures and objects by section 67 and 68 of the Electricity Act and the Old Act 1910. The authority also acquire the right over estates such as users of property under, over, along, across, or across the telegraph authority to place any line or post 10D, the right to enter upon property in order to repair, remove lines, while 11, the power to alter positions of gas, water pipe or drains by section 14, further to apply for an order for removing resistance or obstruction to the exercise of such right by district magistrate. The effect of clause B of the proviso to section 10 of the Telegraph Act is that though the authority may place a line upon any immovable property, central government thereby do not acquire any right other than that of the user would only the property. Thus, the provisions in question must be construed as law providing for acquisition of right in the estate within the meaning of Article 31A, therefore cannot be deemed to be void or in the ground that inconsistent with or taking away any of the fundamental rights conferred under Article 14 or Constitution 19 of the Constitution. An executive act performed under the law in question, namely for declaring to entry upon and entering upon a property of owner, is also not vitiated on the ground that initial attempt to enter the property was for the purpose of placing lines was not proceeded by notice or hearing. As observed earlier, the scheme of the law is that the person offering resistance or obstruction is entitled to be heard when the transmission line company applies for removal of such resistance or obstruction under section 16. In our view, though not expressly provided, this is important. Though expressly provided for the requirement hearing, so we are informed that as a practice, that landowners are always served with applications are made by transmission company for removal of obstruction or resistance. The requirement to hear the owners or occupy at this stage, in our view, is sufficient compliance of the rules of management decision. Admittedly, in the present case, all the petitioners have been heard by the district manager. It was also contended by the basic validity of the law based on the schedule and based on social basic structure. Then next page, para 21 and 22. At this stage, we must record the fact that the suggestion of the court that the respondent offers to hear the petition on whether any adjustment could be made in the route and also to make such adjustment subject to petition request and feasibility to independent officers. The respondent also agreed to consider the petition case for higher compensation in certain cases to independent. However, the petitioner rejected the offer on the ground there is no force paid to the respondent in their offices. We do not see any merit in the contention of provision are violative of Article 21 on the ground they address affect the health of the person living in and around the high tension line. In the first place, the electricity line in question is high tension line is to be based on over agricultural fields and not over residential area. Secondly, there is no proof before the court to enable it or to draw inference of taking electrical oil and So ultimately, the contention of Article 14, 19 and 21 has been rejected in this case. Because only thing is right to use has been taken.
Yes.
Next is, then ultimately, I want to place on the judgment, on the basis of assuming, what problem is underground pipeline is not in so many words. Just suggesting that 2 feet meter to judgment, I'll not just the index propositions, I'll not paragraph page number I mentioned. When large extent of land is required for, here is not required for public purpose, the portion of the on our and other small pieces of land. Next is to the court pursue a public interest vis-a-vis private interest while exercising discretion under 22 Constitution. These are the two main provisions.
Relating to acquisition.
No, that's why I'm saying in a better position. Court have held where the irregularity, illegality also. Well, here we are not acquired also. I'm saying I'm going once. Here lands have been acquired and court have found fault with the acquisition. They said, okay, these are infrastructure projects, we will not interfere. This is not a case of acquisition.
Yes.
Therefore, even in the work, the only point my government is trying to answer is because underground pipe, the word pipes, underground pipe is not mentioned in the same corridor where the electric pipe is being done. I understand about where my which composition. So therefore, the compensation, whatever 40 feet for given compensation for the ground as well as the pipe, and almost as pointed out, all the 178 acres out of 178 acres, the question is only 9 acres, and only 3 of landowners. Therefore, no prejudice, no injustice, no hardship is possible. If it's the question of compensation, section 16 is always available in accordance with law, we can claim higher compensation.
Yes, Mr.
I'm firstly note on the issue of the authority of the state to enter and pay pipeline.
That you already argued.
Yes, my argument is that Indian Telegraph Act provides only for telegraph line. Section 3, subsection 4, telegraph line is a wire, not connected to, covered by, or not any apparatus attached to that. Pipeline not fitting under Telegraph Act. There has to be some other provision for laying of pipelines. To rebut this judgment, this issue is not dealt with. Orissa judgment does not deal with the issue of whether pipes, water line or the pipeline laid under the. It simply assumes that it is part of telegraph authority is having authority to lay the pipes. It is not neither urged, contested or answered regarding whether pipelines are also part of telegraph lines for which telegraph authority has jurisdiction to lay the same. Insofar as the compensation part is concerned, there will be I had contested this petition also on the count that it is the telegraph authority which has the jurisdiction, not the NTPC. I am subsequently informed that they have got necessary approval under. So that ground will not sustain. Insofar as towers and the wiring, the high tension lines are concerned. For that, that part of my land, my relief is under 16.4, 16.3 and 16.4 of the Telegraph Act, for which I will have to contest the compensation. That will be reserved. Insofar as laying of pipeline is concerned, they don't have authority. If they don't have authority to lay the pipeline, that has to go, and they cannot take shelter under Telegraph Act to protect their pipeline from my property. If they want to do that, they will either have to acquire my property or settle it with my clients, or make a provision that telegraph pipeline also includes
the second one did not happen.
Did not happen. The only was open.
Now, please also understand this. Even if you succeed on that, then the reservation will not arise. Reservation of the right under 16.5 will not arise.
Yes, sir.
Because both will merge together. So acquire agobitre mele kedage ella will be
Lord, my
covered.
parties are not very clear about, Lord, that they are ready to lose that land. Lord, what my parties not have instructed is, Lord, they are regularly visiting those sites and Lord, they are already Lord, twice, Lord, this court is notice is brought to this court that those pipelines are Lord damaged. And Lord, due to water seepage and other things, Lord, even adjacent lands are Lord affected because of that water pipeline. And Lord, they don't have that Lord access, and Lord, a picture is given to the court that Lord, we are cultivating and it's all well on that land. That is not this case. These corridors, Lord, we are supposed to keep open for them. Even if you grow, Lord, we don't know when they will come and Lord, when they will. We cannot restrict that.
If we break it, we compensate again.
That's what
No, I think, for example, the crop was, if they crop was 40 meters wide and we destroy, cause any destruction.
Everything is not money, Mr. Shukla. Go and.
Well, ultimately, they're selling the sugarcane. I mean, you also take it, we have been power, 50% of the power is coming from this project to the state. Rest of the 50% is going outside the state. 15,000 crores has been invested on this project. You also take analysis, what may the ultimately, this main way of the highway, what is trying to take advantage of one word underground pipe not being mentioned. Courts have with the Orissa court has interpreted to include underground pipe in that line. What he saying is without authority is the only point which is trying to read because the word is not there in under the Telegraph Act or the Electricity Act, which has been read into. Insofar as very same respondent, NTPC is concerned. That is in year 2019 itself. Respondent.
Yes, you agree.
I'm sorry, I'm just trying to just without authority.
Yes.
I'm sorry.
But a strange argument that the authorities will suffer burden of the payment. That is not a ground to do illegal act. The public interest is in protecting that any act of the state should be in accordance with the statute. It is not it has to change. It is not that they will suffer. They will have to pay whatever is the compensation.
You argued on any fresh argument.
The only judgment this judgment does not answer that.
Third Shri Ashwardhan. Ashwardhan R. Mandi Patil, Learned Counsel for the petitioner. Shri Teki Kiran Shetty, Learned Senior Counsel for the respondent. Reserve.
State has been made a party and the beneficiary in to whom the state has transferred the project in question by means of a government order in the year 1990. They will not be made a party. Challenging an order against them, the KNN respondent. The short question would be whether that order would be binding on KNN or not.
Yes.
Then, if it is binding, then the question is whether petition has to be filed or an immediate.
In the MFA, it would only be the question of quantum that they took care of. In the writ petition is the question of whether they are to be made a party or not. Even otherwise, being the beneficiary, being the person making out the payment, MFA will always be maintained. But to say that That order has to be set aside because I was not made a party. This is a different aspect. That is the distinction.
That is the distinction, absolutely. The question is whether they are ought to be made a party or not is a preliminary question.
Yes.
Whether the claim petition is maintainable without KNL being a party to the.
And to that MFA issue also, there is a subsidiary thing. That state has not filed an appeal.
State may not file an appeal, because, for example, they also said, if the assuming the writ petition goes on the point, then because it is only the KNL by virtue of various judgments reported, then only the KNL can file an appeal, not the state.
Yes. Yes. Because this the appeal will be filed after 9 years. Or 8 years, 7. Now,
delay not, but no delay.
Now we are not on that.
So
That is why we don't want to complicate the matter by expanding the whole thing. We are only on the issue in this matter as to when the state was represented and the SLO was represented in the matter. The state defended that matter, including limitation. Will that be binding on KNL? Because KNL was not the beneficiary of the acquisition, but is a transferee of the project.
That's correct. In that sense, the transfer of the project, by virtue of which all legal.
By being a transferee of the project, he won't be a beneficiary under the Land Acquisition Act.
No, because instead of the state, the KNL steps into the shoes of the state. Unlike
He steps into the shoe. They have furthermore, they don't have any other income of their own. Whatever money comes is from you. The money will go to them.
So they take loan independently, they take loan independent, they become independent corporation.
So once the state who acquired the land, again, let's rephrase it as to limiting. Once the state was a party to the proceedings before the reference court and appellate court, and there was an order passed after contest.
I would not say it is contest, because
We are phrasing this question for you. Once an order has been passed after contest by this state representative having appeared, the state representative not informing the court that there is another person called KNL who is to be made a party, number one. The SLO who sits in the office of KNL being a party as respondent number 2 also is represented by the same person. Then thereafter, can they say that because I was not made a party, the order passed is non-est and is required to be set aside in toto? We are on that, number one. Number two, once you have accepted that and not challenged it, because you have transferred it, they can challenge it. What is the formality of it? That can be addressed. First one is whether it's non-est on account of them not being a party. Second one is the scope of the MFA that could be filed by KNL, which we are not going to consider here. That would be in the MFA wherever. We are only concerned with the WP. That is always available. That is always available. What KNL wants to do in this matter is to say that it is non-joinder. Therefore, the award which has been passed is non-est. It has to be set aside, matter remanded, permitting KNL to contest. So they want to turn the clock back to last 11 years. Most of the matters, the awards have been passed in 12, 13, 14. Though on one breath, there are a lot of allegations being made that the land losers have challenged it after 10 years, 11 years, 34 years. KNL also is challenging after 11 years.
34 years, the land losers.
That may be ground in the MFA.
No, it would have been maintainable provided delay was during Section 5 limitation action, unless.
That is not something that we can decide in this matter, Mr. Advocate. We are only on the scope of this petition is only limited to.
You also may consider this one other aspect, whether the issue judgment is without jurisdiction in view of the fact that the appeal has been taken without deciding the condemnation of delay first, then the appeal.
That is not subject matter of writ petition. That cannot be a matter of writ
So
petition.
you have to refer to pass the judgment. It is along with the appeal, the delay considered in one line.
That is not the ground which has been raised. The ground which has been raised in this petition.
That reading is, I think your question of
Only ground which has been raised.
is not proper and non-general of proper, and that is taken as a party to the case.
That's all. In that, where you made a submission that who has not filed, who was responsible, all those things were to be seen.
Nothing, there is another one objection has been filed, two-page objection. After that, nothing has been. In all, we are able to get 60 of this page, only that is available, nothing else.
No.
And there's all the 60.
You will have to take some action against those persons. What do we do with that? That is why we requested the additional advocate general's presence for that reason, that it should not be that this again goes the same route, because earlier it has happened that way.
Apart from this 262, another problem is financial burden. I mean, what has happened is huge, some of them 600.
That you can challenge them, MFA, and make out grounds for that. KNA could challenge or you could challenge. See, the issue is we are facing this authority in our other roster also. People are served. Your officers are served. They chose not to represent. They don't even come before this court. How many matters we have asked Mr. Chandrasekhar and everybody to get affidavits to be filed now? And we had another matter where the PDO comes and says, I'm not going to give a color, which you also are aware of. There's somebody responsible, you take action against them. But the court having gone through the entire proceedings, arguments being heard, judgment being passed.
KNN should be independently from the state. The moment KNN and state is looked as one and the same, then it is really a different aspect. So if KNN as an independent corporation to whom transfer rights and liabilities have been transferred, and they are the actual person as per the judgment of this court to prosecute the case or any litigation which this court has said is only their case has no road to place. Then they also have been made a party, irrespective of the fact, because it is for the petitioner to make the proper, and it is not for the respondent, it is for them.
But they're not the beneficiary.
No,
Please understand the difference.
No, I understand, like KDB Act, KDB is the beneficiary.
They're transferring of a project.
No, that's why I'm saying state was, I'm just putting another way, I'm not on the point of beneficiary. I'm saying the right has been transferred from the state to KNN. So once this is transferred, not as a beneficiary in the project, is transferred to KNN. KNN is the person, and state has no role to play after that. That's why the Yorkshire is not on the context of beneficiary. As the Yorkshire in this, the economic body and the beneficiary is the state, because the state project. Also, it means the state creates KNN as an independent body to take care of this, because the Kata, everything is changed in the name of KNN. KNN is the owner for all practical purpose, right, and everything. So therefore, state moves away from KNN as an independent body. So therefore, they presume that they are not going to handle the litigation. All this, it is a separate body which has to conduct this litigation.
If we test that submission, if an industrial area or industrial estate is made under the KITV Act, or a layout is formed under the BDA Act, if we accept that submission, then each of the allottees would have to be made a party.
No,
Each of the, as an industrial plot or as a site, because they have been transferred.
So that's a slight difference. Here,
The whole project is something here, for example, KDP acquisition is under 28 by the state government, the notification requirement beneficiary as KDP. They are only allottees. Allottees is different. If the beneficiary is the KDP, allotee is the site owner. BDA is the beneficiary, allottees are the site owners. Allottees need not be a party. Ultimately, the beneficiary is that. Here there is no concept of beneficiary at all in this case. It is only the transfer from the state to KNN. So therefore, actually, from 1998, it is only from A, it is gone to B. The whole project has been transferred. So it is only KNN who would be all rights and liabilities have been having transferred. They are only answerable. So, Your Lordship,
Their answerable is an internal arrangement between both of you.
no, yes, please, the person, so therefore I have made I'll put it that way, I go by what the law says, an arrangement where I have transferred everything here and there. If I have transferred, ultimately, whatever liabilities has to come, it has to come, or you will be contesting right and liabilities is on KNN.
When you were represented in the matter,
I'm nobody to be represented, that is what
you
I'm
should have said that. You did not say that.
Because tomorrow, for example, taking a person who does not have a right for a particular thing in contest and do it, he has nothing to. So therefore, the execution against the state in a matter where the state has no right.
But then why did you defend it? Your SLO was there.
Not defend the part. The ocean mechanism is like this. Tomorrow, in the High Court, they will make somebody appointed. The state government to consider the representation. It may be, they may not have a right to consider the representation. They say, okay, tomorrow they reject also. Or allow also. Reject or allow, they are nobody to do it.
So that is why what we are saying, the distinction is one between a beneficiary and a transferee.
Correct.
Second is as regards the remedy of an appeal already being available to KNN. Can we set aside an order which has been passed after hearing the state, merely because they were not a party, because they are your offshoot and you have transferred it to them, and they not being the beneficiary. Beneficiary, to some extent, we would understand that beneficiary has to be. But this entity was not in existence when the acquisition happened. It's an internal transfer that you have done.
Another beneficiary and owner is one and the same in this case. Your Worship, they are one, that is what I was saying. They are one and the same.
There's no beneficiary here.
Yeah, no beneficiary. That's what I'm saying. There's no beneficiary. The state, only thing what the state has done is that I am not able to manage it. I am transferring or creating an independent corporation, transferring everything with regard to these various litigation projects to KNN, Karnataka. So therefore, that is the body which will have to be responsible. Now, if they don't make the claimant responsibility to make a proper and necessary party rather.
How did you put the claimants on notice, Mr. Statutory General?
In fact, there's a list, I think.
If you
where they have claimants have, in other cases, during a similar period of time, they made KNN in the party and KNN has contested those.
They may be more intelligent people or they may be more knowledgeable people. Council.
Well, that is what I'm saying, around the all these matters.
That you may differentiate and give us those. That you cannot paint the whole thing in the same color or same brush, because some councils represent some people and they file differently. It was the obligation on part of your representative, a lawyer who appeared. The SLO is sitting in their office.
Not only this, what I verified is, he is not only by his perform from the every department, all other functions including.
There's only one SLO. There's only one SLO for that district.
Actually, the SLO, your Lordship knows, under the scheme of the Act, he is a quasi-judicial authority. He does not represent the state, he does not represent the beneficiary. He was impleaded as a pro forma party, as some lawyers implead a tribunal
in an appeal. So, whether he was made a party, whether he was assigned to us, that was an arrangement. I took instructions on that because your lots of pointed out. Why the SLO is being assigned by the state is so that the process of ascertainment of compensation, etc., should be there is a designated SLO for a particular corporation or a nigam. And sometimes one SLO is also assigned to look after acquisition of multiple organizations. So he is not, and the letter which my learned friend has placed on record, that it says nigam only because the SLO is basically saying, I have made this assessment with regard to this particular project. He is not doing it as an officer of the nigam.
Yes.
So that's another aspect that your lordship will be looking at, because does it make a difference that an SLO is a party here? Whom does he represent? Because his role has to be seen in the context of the Land Acquisition Act.
We are only saying this. Was not there a duty on part of the state who was represented in the matter? The state of Karnataka, the deputy commissioner being the parties, was there no duty on their part?
That also I think. Those questions are.
Special Land Acquisition Officer has made a party in the claim petition and the deputy commissioner. In that the state is also not a party. The Lordship may kindly see state represented by deputy commissioner would have been entirely a different. Here, SLO has nothing to do with it. As I said, the deputy commissioner. In the Hindu, as a deputy commissioner, so and so.
Which petition are you having?
So in all the petitions, the same should.
The deputy commissioner.
The DGP appeared and contended that on proper operation of both oral and documentary evidence and considering the capitalization method, taking proper yield and income, the learned reference judge agrees to the correct conclusion, same as in accordance with law, and there is no infirmity while appreciating the evidence. On these and among them, he prayed to dismiss.
The reply to the contradiction of is one page. It's a standard format, verbatim the same kind of reply to contradiction of applications. What do we do?
It's for you to set your house in order. We can't help you.
I must point out to your lordship.
State is not a party. State is not a party to this.
Your representative. Your representative appeared.
Not, you're not even
Yes.
In
In this matter.
It's identical in all the cases.
No. You can differentiate this.
Section 20A requires that is the deputy commissioner on behalf of the state who is supposed to be made party. Says that
The deputy commissioner is
required to be made party. Not if I were to make state to some other authority, my appeal would have petition would have been defective. 20C, 20A Karnataka amendment regarding who should be served notice in reference to.
Whether your lawyer conducted the matter properly or not is not something that we can look at.
I will go since the state is not a party to the issue.
That is, this is a conspectus of things.
Yeah.
So each one of them we can deal with. Central Act amended, Karnataka amendment.
Central Act what section 20 is there. Section 20 plus service of notice. Court shall thereupon cause a notice specifying the day on which the court will proceed to determine preference and directing their appearance before the court on that day to be served on the following persons, not A applicant and all persons. Not this is
Substituted.
and is Central Act. Karnataka amendment says A, the deputy commissioner. B, all persons interested in the reference. C, if the acquisition is not made for the government, the person or authority for whom it is made. Conjoint reading of Lot 20A and C is Lot. If it is acquisition for the government, it is only the deputy commissioner who is supposed to be made as a party. they cannot, if I make not state through secretary, my reference or they have been. And Lord, in fact, I have a judgment where Lord, Indian government came and said that Lord, we were not heard. It was only the deputy commissioner. Court said no. It is, if it is government, it is only deputy commissioner. Even if you're different government, you don't have right of authority.
Let the Advocate General complete his.
Your lordship have raised, in my compilation, I have dealt with exactly those judgments. Cases where.
Between both of you, decide who will start so that we'll follow some order.
Because I will squarely answer what your lordships have raised. So that's the real issue.
Yes.
And your lordships are absolutely right. If I'm able to satisfy your lordship that the rates are maintainable, then what? So that's another issue, whether it should be allowed and the orders to be set aside or to be remanded back, or if I am not able to satisfy your lordship on the maintainability, then consequences would follow. So where request your lordship to take up this compilation which I had filed, a convenience compilation. There were 2 volumes filed. I would request your lordship to take the volumes labeled as convenience compilation. It's a common compilation. It is in the writ petition 2000627.
Rest of the LB matters, I don't think we'll be able to take up. LB matters will get adjourned. The interim order review earlier will.
Lordship, serial number 41, your lordship. The interim order is that I sought for a direction, your lordship, wherein there is an
You won't be
direction.
able to take up those matters now, madam. It will be adjourned.
Please, date may be given, your lordship. Date may be given, your.
All dates will be fixed.
Please.
Wherever the
Obliged.
interim orders are there, they'll be extended.
Obliged.
Mood matter. Put to here. We'll just finish that matter. It's a mood matter. And then you can carry other courts. The AGA can give us when is convenient to you. We'll post that matter. Except next week after next anytime.
Dependent, respondent ballot number 2, 5. A suit ballot. Please come to ballot second volume.
Yes.
343 ballot. Is a suit filed by her. If your lordship come to ballot the prayer, 351 is the prayer. Grant an order mandatory injunction, sorry, 351 ballot. Grant a mandatory injunction.
Yes.
Direct the defendant claiming program rate, including the assessor, remove the structures that they have already come up in the encroached part of the suit scheduled property, put up by the plaintiff in the vacant land, etc. etc. And will declare that the plaintiff is the absolute owner of owner of 3 acres, 30 guntas of land.
Yes.
And will if you look at the schedule on the right side. This suit will please come to Mulad.
Yes.
She says that Mulad, there is a defective title. Anyway, Mulad, I will not trouble your lordships at this juncture. Please come to Mulad, the order sheet for the suit. It starts at 325. Please come to Mulad 340. 340, last paragraph. Last but one paragraph. In this suit, status quo order was already granted, but in the present suit, we see. But what happened was earlier, there was status order granted. That suit got transferred because they did not have jurisdiction. Therefore, not in our case. Oh, I'm sorry, my lord, it is in reference to my lord, the earlier order, judgment, 2004 ATSCC, my lord, Naval so and so held that under and until my lord, the previous paragraph.
Yes.
Irreparable damage is made out in the suit. The court should not permit a change of set status quo. In this suit, status quo was already granted, but in the present suit, as it is seen that from the photograph, defendant has already been already constructed 7-story building at least at the stage of completion. Further defendants have come up on record, etc., etc. Ultimately, my lord, the court says it is not necessary to give last paragraph. Till then, the discussed about status quo cannot be given, as it would cause irreparable.
Yes.
Please look at one of the photographs. Building has come up to. Please come to my lord, page 106, first volume. I'm sorry. 165. 165, 166, 168. We have taken the plan, etc. Now what she does is, please come to page 33. She lodges a complaint, matter is pending.
33.
33,
Yes.
At 35, the type copy is at 35. She lodges a complaint with the Commissioner Corporate, the trial court sees the matter. She says, there is an illegal construction. Therefore, stop it. And she refers to the suit, OS number, second paragraph only, OS number 781. Now, the trial, they asked us for the document, we produced every document. Please look at annexure A. Authority says now you shall not construct this. I have to decide whether there is encroachment.
Where is the order of notice?
Annexure A, page 31. Last paragraph, last but one paragraph. Durdar ಅರ್ಜಿಯನ್ನು ಹಾಗೂ ಸದರಿ ಕಚೇರಿ ಸಲ್ಲಿಸಿದ ನ್ಯಾಯಾಲಯದ ದಾಖಲೆಗಳನ್ನು ಲಗತ್ತಿಸಿ ಸದರಿ ದೂರ ಸುಪರ್ದಿಯಲ್ಲಿ 1 ಎಕರೆ ಒತ್ತುವರಿ ಮಾಡಿಕೊಂಡು ಕಟ್ಟಡವನ್ನು ನಿರ್ಮಿಸಿರುವ ಬಗ್ಗೆ ಸಮಜಾಯಿಸುವ ಸೂಕ್ತ ದಾಖಲಾತಿಯೊಂದೇ ಸಲ್ಲಿಸಲು ಸೂಚಿಸಲಾಗಿತ್ತು. ಅದರಂತೆ ದಿನಾಂಕದ ಸಮಜಾಯಿಸುವಂತೆಗೆ ಕೆಲವು ದಾಖಲಾತಿಗಳನ್ನು ಸಲ್ಲಿಸಿದ್ದೀರಿ. ಆದ್ದರಿಂದ ದೂರದಾರ ಅರ್ಜಿ ಹಾಗೂ ನಿಮ್ಮ ಸಲ್ಲಿಸುವ ದಾಖಲಾತಿಗಳು ಈ ಕಚೇರಿಯಿಂದ ನಿಯಮಾನುಸಾರ ಪರಿಶೀಲಿಸಿ ಅಂತಿಮಗೊಳಿಸುವವರೆಗೆ.
What basis are you putting up construction? Are you the owner or a joint developer?
I am the owner, my lord.
You are the owner.
Owner, my lord. And the question as to whether, my lord, I have encroached or not, my lord, is a matter that is seized by the Supreme Court trial court. Trial court says no interim order. I am putting up the construction.
What is the total extent of land under sale deed?
4 acres, my lord. My lords get the sale deed at running page 44, my lord.
Yes.
Please come to my lord, running page.
What is sold under this? Larger extent is 6 acres.
6 acres.
And what has been purchased is?
Purchased 6 acres.
The larger extent is 6 acres. 4 acres.
4 acres.
Plan sanction is for?
My lord, for 4 acres. My lords get that at running page, my lord, 125 building license. The matter, my lord, is seized over the
280 square meters.
Yes. Then, sorry. They have an additional my lord, area of 117 and 63 at the top of the And if your lodges come to the respondent sale which you are at 357. Totally different survey number.
You obtained a plan sanction for 24,280 square
Yes,
meters.
because 117 and 63 are also not part of my land. All that are included. Please come to page 125.
Yes.
117/1, 63 of Singasandra. Then 117/1, 63/2, 3, 4, 5, 6.
You purchased what?
Blood.
You purchased the 63.
Same deeds, sir. You should have put all the same deeds.
63, 1, 2, 3, 4, 5, 6. Composite boundary. On the north by survey of number 117 as per page 92.
Your lordship come to my lord the suit.
Did you purchase 117?
117 also my lord is purchased because my lord that is.
Where is sale date for
97? 97.
97 is the survey sketch.
That is my lord one portion my lord for the road. And then my lord the 63/6, 63/5, 63/2, 3, 4, 5.
But where is the this one? For your sale date for that?
Say deed my lord, please come to my lord running page.
Running page?
1 minute. 44.
Forty-four is 63. 63, 1, 2, 3, 4, 5, 6. 4 acres.
Yeah.
This is 65/2 anyway. What they're asking for is 65/2.
Her suit my lord if your lordship say, now please come to my lord her suit.
Is for 65/2.
Correct.
So this property and that property are not. But your extent is 24,000 square meters. That comes to 240 square feet. It should be around 6 acres.
That is 4 acres plus my lord that 117.
How much does 117 measure? Two acres, 2 guntas. Annexure F.
In
So
fact,
you have 6 acres.
the trial court my lord itself says, the commissioner says there is a suit pending. I am looking, my lord, it is now seized on the matter, but yet I my lord pass an order. Virtually my lord it will amount to my lord contempt. He refers to the suit. And her suit my lord it cannot now come to. It is only in respect to this very thing. How can my lord when the suit is pending?
Pawan Kumar accepts notice for 1 and 2, issue notice to respond number 3, returnable by 12th October 2023. The operation of the impugn notice dated 14/9/2023. At annexure A, he states till the next date of hearing. Construction, if any carried out, will be subject to the result of the present petition. Further construction.
When they have applied for sanction plan, the OS was not pending. Then they have subsequently applied for completion certificate. At that time, they have not disclosed about the pendency of the OS.
Construction going on, completion certificate, Elbara.
They have compromises, they have not said everything. So, and there's a clause in the sanction plan, material factors suppressed.
The suit is in respect of survey number 65/2. 65/2 is not the subject matter of your plan sanction.
What has happened is, my lordship, the order of the trial court, the contention of the private respondent there, the survey number is not.
Mr. Pawan Kumar, let us take it like this, if we test your hypothesis, if your submission. Suit, the plan sanction is for survey number 1, Singasandra. Suit is filed for survey number 1, Biddi, against the plaintiff who owns that also. Would that amount to violation of that? It has to be the same survey number.
The contention of the private respondent to the OS. If that survey number is not correct and she has applied for some survey.
Past orders, is still pending. You have not even come to a prima facie conclusion that there is suppression.
Suit is filed in the year 2023, plan is not of 2021. What we have said that for the time being in the.
Large projects where people are employed. On the basis of one small little complaint cannot be done. You don't take action against violation in the Israeli. Process fee and copies to be furnished by end of day 16th, end of day 16th, failing which the interim order will stand automatically vacated. The Pawan Kumar is directed to inform the concerned at respond number 1 and 2 about the above order and not to interfere with the construction being put on.
Time permission serial number 81.
Submission of written argument.
81. Yeah.
Jama.
Written submissions are taken on. Yeah, we served it on.
My lord.
Madam, who will be appearing in this?
Senior committee are among gratitude to the patience with which the matter was heard.
When do you want it? ಯಾವಾಗ ನಿಮ್ಮ ಅದು ಯಾವಾಗ ನೀವು ಡೇಟ್ ಕೇಳಿ ಆ ಡೇಟ್ AG will be appearing in this one. ಇನ್ನೊಂದು
Motion of petition to the property of respondent number 2. Respondent number 2 is purpose to have obtained license to put up lordship the telecommunication tower. Lordship, where the petitioner being the resident and neighbor, as lordship along with the villagers have filed objection. But lordship the respondent 1, without considering objection, lordship, without giving opportunity of hearing, as straight away lordship has purported to have given the permanent license.
What is your right to submit objections to a telecom tower?
Lordship, kindly see the lordship the regulation.
What is really the regulation?
But next it along with my petition. Next year, lordship.
Page?
Lordship, page number 28, section 4. Lordship, where it denotes general guidelines for location of telecommunication infrastructure tower. Location of telecommunication infrastructure towers is governed by radio frequency system adopted therefore, as far as possible, residential areas shall be avoided.
Where is it that your objection has to be considered? You have a right to, firstly, you have a right to object.
Yes.
Second, the right has to be, the objections have to be considered. There are various statutes and various rules where objections have to be, no objection has to be obtained from the neighbors for establishment of a bar.
But we have filed objection, lordship, regarding.
Just because you file an objection, do you have a right to file objections?
Lordship, lordship, actually, lordship, there was suit pending against lordship. This
Contention is your objection and not been considered. Is there a right under this particular rules or any particular statute in respect to a telecom tower entitling you to file objections which are required to be considered?
But lordship, extra section 4, lordship. It should not be in residential area.
Shall avoid it, shall not be.
Yes, lordship, shall be avoided.
If that is the case, Mr. Ajay Prabhu, there won't be a tower in Bangalore.
Not in Bangalore, existing lordship village.
If we accept your submission, there will not be a telecommunication tower in Bangalore at all. We will be without mobiles.
No, it doesn't lordship completely bar lordship of
the.
But lordship, kindly see, I'll read the question 4 fully, lordship. Location of telecommunication infrastructure towers is governed by radio frequency system adopted. Therefore, as far as possible, residential areas shall be avoided. However, where it is not possible to avoid residential areas, only when it is not possible to avoid residential areas, permission from sanctioning authority for installation on rooftop of a building shall be considered. Lordship, this is the area. Lordship, this is a lordship of the density of people is around.
You can't consider it now at this stage. You have to hear that. Shri Sharanjit Shetty accepts notice for respond number 1, issue notice to respond number 2, returnable emergent notice to respond number 2, returnable by 12th October. Proceeds to be paid by end of day tomorrow.
Until then, lordship, status quo. Proceeding with
If you have a right, you would have considered. You don't have a right for filing objection.
But lordship, he is obstructing lordship the way as well, lordship. By construction, kindly see the lordship.
It's a rooftop, Mr. Ajay Prabhu. Don't bring your ego issues of neighbors into all these things.
No, kindly see the photograph.
Submission we can't.
Kindly see the photograph.
Please pay the process.
Lordship. Until then,
No.
already there was rejection by the trial court.
Your request has been rejected. Notice has been ordered.
Thank you, lordship, because lordship is proceeding with the construction.
No. Yes.
Date.
Fix 12th. Emergent notice. Keep that.
Yes. I have given the broad things and the proposition and the judgment support. You not need not go through, I'll just take up selectively the judgments because many of them Lord are repeating what the lead judgment says, so I will not repeat your lordship. Number the first proposition to your lordship from the index is that KNL is an interested party. Number for this Lord, the lead judgment on the broad principles of who is an interested party. Because under section 18, Lord, interested party is not defined. It only says who could be an interested party and they have a right to seek reference, etc. So the first judgment, Lord, which I have only for the proposition of showing what is the test of a interested party. Well, that your lordship would see page 53. Page 53 of the compilation.
Himalayan tiles.
Yes. This is Himalayan tiles. It's a judgment
yes.
known and followed, my lord. And my lord, your lordship would see, my lord, here, my lord, this was a matter pertaining to acquisition for the benefit of a private company. So, my lord, that's a distinguishing feature. Then, my lord, please come to para 8 at page 56.
Yes.
Your lordship, page 56, para 8. It seems to us that the definition of a person interested given in section 18 is an inclusive definition and must be liberally construed so as to embrace all persons who may be directly or indirectly interested either in the title to the land or in the quantum of compensation. In the instant case, it is not disputed that the lands were actually acquired for the purposes of the company, and once the land vested in the government after acquisition, it's to transfer to the company under the agreement entered into between the company and the government. Thus, it cannot be said that the company has no claims or title to the land at all. Secondly, since under the agreement the company has to pay the compensation, it was most certainly interested in seeing that a proper quantum of compensation was fixed, so that the company may not have to pay a very heavy amount of money. For this purpose, the company could undoubtedly appear and reduce evidence on the question of quantum of compensation. Then, my lord, your lordship comes to para 14.
Yes.
Thus, the preponderance of judicial opinion seems to favor the view that the definition of a person interested must be liberally construed so as to include a body, local body, or a company for whose benefit the land is required and who is bound under an agreement to pay the compensation. In our opinion, this view accords with the principle of equity, justice, and good conscience. How can it be said that a person for whose benefit the land is required and who is to pay the compensation is not a person interested, even though its stake may be extremely vital? For instance, the land acquisition proceeding may be held to be invalid, and thus a person concerned is completely deprived of the benefit which is proposed to be given to him. Similarly, if such a person is not heard by the collector or a court, he may have to pay a very heavy compensation, which in case he is allowed to appear before the court, he would have satisfied that the compensation was far too heavy, having regard to the nature and extent of the land. We are therefore unable to agree with the view taken by the Odisha High Court or even the Calcutta High Court that a company, local authority, or a person for whose benefit the land is required is not an interested person. We are satisfied that such a person is vitally interested both in the title to the property as also in the compensation to be paid. Therefore, because both these factors concern its future course of action and if decided against him, seriously prejudice his rights. Moreover, in view of the decision of this court referred to above, we hold that the appellant was undoubtedly a person interested as contemplated by 18(1) of the Act. The High Court was therefore has committed an error in throwing out the appeal of the appellant on the ground that it has no locus to file an appeal before the bench. Now, Lord, this is on the proposition of who could be an interested party.
Relating to an appeal.
Yes. Now, Lord, your lordship, that comes to the next judgment, that is Nebeli Lignite. Lord, that is a significant judgment that will answer several of the issues that your lordships have been seeking answers for. That is at page 65. Lord, I am skipping the other judgment because I want to come straight to the point.
Yes.
Now, Lord,
you can take your time, you can refer to what is it, because this is a issue which there's a different issue than most of the matters which what we have seen coming across as regards beneficiary. You are in the position of a transferee.
That also I've got the
Most-
judgment. Yes,
that-
as an assignee. If it is assigned by the government, but I've got a direct judgment of the Supreme Court as well as one of the Bombay High Court. That at the time of acquisition, that entity was not in existence. Subsequently, the government assigns it by creating an executive order, an
You
independent.
can take your time and
Yes, so my lord, those are very pertinent questions. Your lordships have actually formulated that, but I'm so grateful that your lordship. Now, my lord, navally lignite, my lord, please see, my lord, para 2 at page 68. The judgment starts at page 65. How it was referred to a 3 judges bench. Para 2. When the appeals came up on such and such day before a bench of 2 judges, our learned brethren made a reference to a 3 judge bench thus. We think that it would be proper that the entire matter, including the right to seek reference to produce evidence or to claim to be impleaded as a party before the civil court, or its right to file an appeal before the High Court against the above orders, and all other allied questions are necessary to be considered by 3 judges. Thus, these appeals before this bench. It is not in dispute that the entire controversy hinges upon the interpretation of section 3B and section 52 of the Act. Whether the appellant is a person interested either to be impleaded as a party respondent to the pending references under section 18, to lead evidence, contest the reference, and if compensation is announced, to file an appeal in the High Court under section 54, or to get impleaded as a party respondent in the pending appeals filed by the land acquisition officer, or to file a writ petition under Article 226 of the Constitution of challenging the correctness of the award and the decree made by the civil court under section 26 of the Act. Now, let then come to, I'm skipping the, please come to para 5. The question therefore is, whether the appellant for whose benefit the land is acquired is a person interested within the meaning of section 3B of the Act. In Hindustan, which is the judgment which I just read, speaking for bench and that is extracted, then please come to para 6. It is true that in the case, the facts were that the owners of the land questioned the correctness of the legality of the acquisition proceedings and the notification issued under section 4 of the Act. The appellant thereupon was a company for whose benefit the land was sought to be acquired. Therein the company sought to be impleaded as a party respondent. Learned single judge quashed the notification of the section 4(1) when an LPA was filed. The division bench held that the appellant had no locus standi to file the appeal. Accordingly, it dismissed the appeals. When its correctness was questioned, this court laid down the law as extracted here and above. It is to be seen whether this court had not restricted the question for being impleaded in the proceedings under Article 226 when section 4(1) was quashed. The entire gamut of the controversy has been gone into and held that a person for whose benefit the land is to be acquired or was acquired was a person interested in the determination of the proper compensation and to acquire perfect title to the land. Therefore, such interested person is entitled to come on record to lead evidence for determination of proper compensation and also to secure valid title to the land acquired for its benefit. The decision is consistently being followed by this court. In Neelaganga Bai was a state of Karnataka. The facts were that the civil court on a reference under section 18, without notice to the corporation for whose benefit the land was acquired, recorded the evidence and announced the compensation. The state had filed the appeal. An attempt was made by the corporation to intervene in the appeals was rejected. Therefore, the corporation filed the writ petition under Article 226 of the Constitution questioning the award passed by the civil court. On those facts, this court held that since no notice was given to the respondent corporation and it was thus deprived of an opportunity to place its case before the court, the judgment rendered in the reference case was illegal and not binding on the corporation. It may be noted that the Karnataka legislature made local amendment to section 20 of the Act and inserted therein clause C that if the acquisition is not made for the government, the person or authority for whom it is made, the notice shall be served under section 20 of the Act. Taking that fact and also the general principle, this court held that the corporation was a person interested under section 3B of the Act. The writ petition was held to be maintainable and directed the High Court to consider the matter on merits. In Krishi Utpadan Mandi versus so-and-so, a similar fact on similar facts as Leela Kalkabai states, when reference court enhanced the market value without notice to subsidy and on appeal, this court set aside the judgment of the High Court and remitted it for fresh disposal. Then, your Lordship may see paragraph 12. It is true that section 50 subclause it is true that section 50 subclause 2 of the Act gives to the local authority or the company right to adduce evidence before collector or in reference under section 18 as it was specifically stated that in any proceedings held before the collector or the court, the local authority or the company may appear and adduce evidence for the purpose of determining the amount of compensation. However, it has no right to seek reference. Based thereon, the contention is that the limited right of reduction of evidence for the purpose of determining compensation does not carry with it the right to participate in the proceedings or the right to be heard or to file an appeal under section 54. We cannot limit the operation of section 3B in conjunction with subsection 2 of section 50 of the Act within a narrow compass. The right given under subsection 2 of section 50 is in addition to and not in substitution of or in derogation to all the incidental, logical and consequential rights flowing from the concept of free and just procedure consistent with the principles of natural justice. The consistent thread that runs through all the decisions of this court starting from Himalayan tiles is that the beneficiary, that is a local authority or a company, a cooperative society registered under the relevant state law, a statutory authority, is a person interested to determine just and proper compensation for the acquired land and is an aggrieved person. It flows from it that the beneficiary has the right to be heard by the collector or the court. If the compensation is enhanced, it is entitled to canvass its correctness by filing an appeal or defend the award of the collector. If it is not made a party, it is entitled to seek leave of the court to file the appeal against the enhanced award and the decree of the civil court under section 26 or the judgment and decree under section 54, or is entitled to file writ petition under 226 and assail the legality or correctness. When the award made under section 11 of the collector is vitiated by fraud, collusion or corruption, the beneficiary is entitled to challenge it in the writ court apart from the settled law that the conduct of the collector or a civil judge is amenable to disciplinary inquiry and appropriate action. These are very valuable and salutary rights. Moreover, in the language of Order 1 Rule 10, in the absence of the beneficiary who ultimately is to bear the higher compensation, no complete and effectual determination of finding just and proper compensation to the acquired land would be made. So it is concomitantly a proper party, if not a necessary party to the proceedings under Order 1 Rule 10. The denial of the right to a person interested is a negation of fair and just procedure offending Article 14 of the Constitution. The reasons are not far to seek. It is notorious that though the stakes involved are heavy, government, fleet or inspecting officer do not generally adduce, much less proper and relevant evidence to rebut the claim for higher compensation. Even the cross-examination will be formal, halting and ineffective. Generally, not invariably, the governmental agencies involved in the process take their own time and many a time in collusion file appeals after abnormal or inordinate delay. They remain insensitive even if the stakes involved run into several crores of public money. The courts must insist upon proper explanation for every day's delay. In this attitudinal situation, it would be difficult to meet strict standards to fulfill the unbridgeable gaps of delay in filing the appeals and generally entails dismissal of the appeals at the threshold without adverting to the merits of the hike in compensation. On the other hand, if the notice is to be issued to the local authority, they would participate in the award proceedings under section 11 and 18, adduce necessary and relevant evidence, and be heard before the collector and the court before determining compensation. For instance, that without considering the evidence in the proper perspective, the court determined the compensation. If there is no right of hearing or appeal given to the beneficiary and if the state does not file the appeal, or if filed with a delay and it was dismissed, is it not the beneficiary who undoubtedly bears the burden of the compensation who would be the affected person? Is it not interested to see that the appellate court would reassess the evidence and fix proper and just compensation as per law? For instance, the reference court determined the market value of ₹1 lakh while the prevailing market value of the land is only 10,000. Who is to bear the burden? Suppose a state appeal was dismissed due to refusal to condone the delay, is it not an unjust or illegal award? Many an instance can be multiplied, but suffice it to state that where the beneficiary for whose benefit the land is acquired is served with the notice and brought on record at the stage of inquiry by the collector and reference court under section 18 or in an appeal under section 54, it or they would be interested to defend the award under section 11 or section 26 or would file an appeal independently under section 54 against the enhanced compensation. As a necessary and proper party affected by the determination of higher compensation, the beneficiary must have a right to challenge the correctness of the award made by reference court under section 18 or an appeal under section 54, etc. Considered from this perspective, we are of the considered view that the appellant company is an interested person within the meaning of section 3B of the Act and is also a proper party, if not a necessary party under Order 1 Rule 10. The High Court has committed a manifest error of law in holding that the appellant is not an interested person. The orders of the High Court are accordingly set aside. Since the writ petitions filed by the appellants were dismissed, we set aside the orders and direct the High Court to treat them as appeals properly filed under section 54 of the Act, and we dealt with along with the appeals filed by the state pending disposal of the High Court. In the pending reference under section 18, the Court of Subordinate Judge is directed to that. So, your Lordship notices here that the writ petitions were converted into an appeal because of the fact of the reasons set out. And in para 13, of course, the court has made those observations why the beneficiary ultimately is required to be there because government has its own limitations. As I'm not suggesting that it was so in this case, but for whatever be the reason.
There may be that your officer, the state's officers and their representative did not perform their duties in the manner required for whatever reasons. Inquiry to be ordered, we'll order an inquiry order. Your contention in this matter is just because you are not made a party, the award which has been passed is non-est. Therefore, it has to be set aside, matter remanded, and you filing an appeal is completely different.
No, that's what the court says.
Even the court said writ petition to be treated as appeal.
Yes.
They did not set aside and send it back.
Lord, because if I am not that's why, am I an interested party? If I was an interested party and the appeals were filed at a point of time when there was already apart from the fact that we were in existence, and all these are appeals filed after huge delays. By which time
an appeal. It's not that
your question is right. Yes, I could have filed an appeal by seeking leave, or else that's what the court says. If you can also file a writ petition. If you had filed a writ petition, then the court will how the court will mold relief once the court is satisfied that yes, I was a party to require.
Para 15, the Apex Court has said that the writ petitions which have been dismissed,
yes,
will be restored and converted into an appeal. What we are only telling you is that your contention that the award has to be set aside is not that easily palatable and acceptable for us till now until you complete your arguments. You will have a right to file an appeal, which is for you to put the bar at that level to say that the award is non-est and it has to be set aside and matter be remanded is completely different from saying you can file an appeal.
Well, in the facts of this case, possibly I may be justified in saying so because of a judicial order. And that judicial order way back in 2014, your lordships have said that in these matters, the appeal at the instance of a state is not maintainable. It should not
appeal.
Because
nobody is coming in the way of your filing an appeal.
Yes. But then, I'll tell you, lordship, we are now challenging an order passed on our first appeal. Now, unless and until that order can be challenged, one way is your lordships are saying, well, I am giving you liberty, go and file an appeal. I give you liberty to file an appeal.
Nobody needs to give you that way. You have that.
But because your lordship will have to test whether this writ, a consequential order has to be passed for challenging, setting aside that order on the ground that I, being a necessary party, was not implemented there. So that's on that procedural error, and I think
we are exercising jurisdiction in the 227 and the
yes.
supervisory jurisdiction. The jurisdiction in a miscellaneous first appeal is completely different. Where the facts could be appreciated, reappreciated, all those things can be done.
Yes.
In a writ petition, we cannot do all that. We cannot extend the scope in a writ petition. Each jurisdiction has its own
Yes.
pluses and minuses.
Yes. Correct.
If we can put it that way.
No, bro, I'm not asking, my lord, I'm not seeking that your lordship will make a determination on merits. Because that's what para 12 says.
Without making that, can we say that you are required to be a party, we have set it aside, which is much more than what the MFA
No,
court
but
can
set
do?
aside on the ground that that's a nullity. Well, I'll show those judgments where we are still to cover that.
All these judgments so far are only on appeal.
Yes, sir. Now, my lord, what Navy Lignite says is that you have the option of either filing an appeal seeking leave of the court. You can also file a writ petition. In case a writ petition is filed, the High Court, my lord, of course, the Supreme Court has wider powers under 142, but even otherwise also when the court finds that a necessary party has not been included in the appeal, so that order, for whatever reason, ultimately, my lord, if you make me a party, give me the opportunity of filing an appeal or contesting the appeal that they have filed, I am not, my lord, in this petition, we are not even seeking that the appeal should be dismissed. All that we are seeking is, please send us back so that we can contest that appeal filed by the landowner. I am not seeking a dismissal of the appeal. The writ petition, the prayer is that, yes, send it back and let the first appellate court decide.
Why not file an appeal challenging that?
I can't, my lord, how can I file? Because, yes, I could have filed, but this option is also open to me. Lord, that option is also open to me. My lord, the court does not say that my only option is to file an appeal seeking leave of the court. The court's para 12 is very clear. It says, yes, you can have that option as well as this. And but this is not the only case. Well, I'll just proceed further. Your lordship may see that.
Yes.
Now, my lord, the next judgment is the Constitution bench. That is UP Awad at page 77.
Yes.
Please come to my lord, para 8.
Yes.
Para 8. Page 87.
Yes, please.
The question which needs to be determined is whether the Land Acquisition Act confers any right on the board to participate at the stage of determination of compensation for the land which is sought to be acquired under section 55 of the UP Act read with the provisions of the Land Acquisition Act as modified by the schedule to the UP Act and to assail such determination if the board feels agreed by the same. As indicated earlier, by virtue of section 314 that has been introduced in the Land Acquisition Act by the UP Act, the board is a local authority for the purpose of the Land Acquisition Act. The question aforementioned has therefore to be examined in the light of the provisions contained in the Land Acquisition Act. The Act relating to the acquisition of land for a local authority. Provisions which have a bearing on this question are contained in section 50 of the Act, which reads as under. Where the provision this followed, I'll skip and your lordship may come to it. Yes, I can. Yes, of course. Section 50. Where the provisions of this Act are put in force for the purpose of acquiring the land at the cost of any fund controlled or managed by a local authority or of a company, the charges of and the incidental to such acquisition shall be defrayed from or by such fund or company. 2. If any proceedings held before the collector or court, in such cases, the local authority or company concerned may appear and adduce evidence for the purpose of determining the amount of compensation, provided that no such local authority or company shall be entitled to demand a reference under section 18. Subsection 2 of section 50 enables a local authority to appear in any acquisition proceedings at the stage of determination of compensation before the collector or the reference court and adduce evidence for the purpose of determining the amount of compensation. The object underlying the aforesaid provision appears to be to safeguard the interests of the local authority, which would be required to pay the amount of compensation that would be determined by the collector or by the reference court by enabling it to adduce evidence having a bearing on the amount of compensation before the collector or the court, and thereby assist them in making a fair determination. Such protection was necessary because in the matter of acquisition under the Land Acquisition Act, the local authority for whom the land is required does not stand on the same footing as the government. While making the award, the collector acts as an agent of the government and functions under its administrative control. Prior to the insertion of some proviso to subsection 1 of section 11 of the Land Acquisition Act by the Land Acquisition Amendment, there were administrative instructions requiring preliminary evaluation by the collector of the land being acquired, and if the collector found the eventual award would be substantially exceeded the provisional evaluation, he was required to obtain further instruction from the higher authority. Now, the proviso inserted in section 1 of section 11 by the Amendment Act lays down a statutory requirement that no award shall be made by the collector without previous approval of the appropriate government or of such officer as the appropriate government may authorize on his behalf. There is no similar provision requiring the approval of local authority. Subsection 2 of section 50 is the only provision which affords a certain degree of protection to it, and in the matter of determination of the amount of compensation by the collector as well as by the reference code. Keeping these considerations, we are of the view of the opinion that subsection 2 of section 50 must be construed as conferring a right on the local authority for whom land is being acquired to participate in the acquisition proceedings at the stage of determination of the amount of compensation before the collector as well as the reference code. Then, my lord, your lordship will come to para 12. There is again a reference to the Neela Gangabai. I will take your lordship to that judgment, that has to be looked at. Para 12, Lord, we see in the state of Karnataka, section 20 of the Land Acquisition Act has been modified.
Basically a repetition of the earlier judgment or scale.
Yes, but Lord, that judgment will be, I will read separately because Lord, that is relevant for the state. Lord, please come to para 19. 19. We would now revert to the question regarding the legal remedies that are available to a local authority which feels aggrieved by the determination of the amount of compensation by the collector or by the reference code. In this context, it may be stated that the limitation placed by the proviso to the right conferred under section 52 of the Land Acquisition Act cannot be so construed as to deprive the local authority which feels aggrieved by the determination of amount of compensation by the collector or by the reference code to invoke the remedy under Article 226 of the Constitution, as well as the remedies available under the Land Acquisition Act. The proviso to section 52 only takes away the remedy of a reference under section 18 of the Land Acquisition Act. Examining this question in the context of proceedings before the collector, we can envisage the following situation. 1. No notice was given to the local authority under subsection 2 of section 50 of the Land Acquisition Act, and as a result, the local authority could not appear before the collector to adduce evidence. 2. Notice was served on the local authority, and in response to the said notice, the local authority appeared before the collector. And 3. Notice was served on the local authority, but in spite of service of such notice, local authority failed to appear and adduce evidence before the collector. In a case where no notice is given to the local authority, the position of the local authority is not different from the municipal corporation in Neela Gangabai versus the state of Karnataka. In that case, there was an express provision in section 20 of the Land Acquisition Act, as modified by the Land Acquisition in Mysore Amendment, providing for service of notice on the person or local authority for whom the acquisition is made. On a construction of section 52, we have found the service of such notice is implicit in the right conferred under section 52 of the Land Acquisition Act. Since the failure to give notice would result in denial of the right conferred on the local authority under section 52, it would be open to the local authority to invoke the jurisdiction of the High Court under 226 of the Constitution to challenge the award made by the collector, as was done in Neela Gangabai's case. In a case where a notice has been served on the local authority and it has appeared before the collector, the local authority may feel aggrieved on account of it being denied opportunity to adduce evidence, or the evidence adduced by it not having been considered by the collector while making the award, or the award being vitiated by malafide. Since the amount of compensation is to be paid by the local authority and it has an interest in the determination of the said amount, which has been given recognition under section 50, clause 2 of the Land Acquisition Act, the local authority would be a person aggrieved who can invoke the jurisdiction of the High Court under Article 226 of the Constitution to assail the award in spite of the proviso precluding the local authority from seeking a reference. Such a challenge will, however, be limited to the grounds on which judicial review is permissible under Article 226 of the Constitution. In a case where the local authority has failed to appear in spite of service of notice, the local authority shall have no cause for grievance. Even in such a case, it may be permissible for the local authority to invoke the jurisdiction of the High Court under Article 226 of the Constitution to assail the award if it is vitiated by malafide or is perverse. We may now come to the stage of proceeding before the court in a reference under Section 18 of the Act made at the instance of a person having an interest in the land acquired. At this stage also, Section 52 of the Land Acquisition Act envisages that the local authority has a right to appear and deduce evidence before the court. This right is independent of the right that is available to the local authority to appear and deduce evidence before the collector. Even though the local authority has failed to appear before the collector in spite of notice or has appeared in response to the notice and has deduced evidence, the local authority may consider it necessary to deduce evidence to rebut the evidence deduced by the person who has sought the reference and to defend the award made by the collector. Failure to give notice at this stage would result in denial of the said right of the local authority. Before we consider the remedy that is available for seeking redressal against the denial of this right, we may examine whether the local authority has a right to be impeached as a party in the proceeding before the reference court. That raises the question whether the local authority can be regarded as a necessary or a proper party. The law is well settled that a necessary party is one without whom no order can be made effectively, and a proper party is one in whose absence an effective order can be made, but whose presence is necessary for a complete and final decision of the question involved in the proceedings. A local authority for whom land is being acquired has a right to participate in the acquisition proceedings in the matter of determination of the amount of compensation while they are pending before the collector and to adduce evidence in the said proceedings. While it is precluded from seeking a reference against the award of the collector, it can defend the award and propose an announcement of amount of compensation sought before the reference court by the person interested in the land. Moreover, the local authority has a right to appear and deduce evidence before the reference court. Having regard to the aforesaid circumstances, we are of the opinion that the presence of the local authority is necessary for the decision on the question involved in the proceedings before the reference court and is a proper party in the proceedings. The local authority is therefore entitled to be impleaded as a party in the proceedings before the reference court. Then, in case the amount of compensation has been announced by the court and no appeal has been filed by the government, the local authority, if adversely affected by such announcement, may file an appeal with the leave of the court. This right of the local authority does not depend on it being impleaded as a party in the proceeding before the reference court. Even if the local authority is not impleaded as a party before the reference court, it can file an appeal against the award of the reference court in the High Court after obtaining leave if it is prejudicially affected by the award. In case the government files an appeal against the announcement of the award, the local authority is entitled to support the said appeal and get itself impleaded as a party. When the person having an interest in the land files an appeal in the High Court against the award of the reference court and seeks announcement of the amount of compensation, the local authority should be impleaded as a party in the said appeal and is entitled to be served with the notice of the said appeal so that it can defend the award of the reference court and oppose the announcement of amount of compensation before the High Court. The same will be the situation in case of an appeal to this court from the decision of the High Court. Then 23. Under Section 52 of the Land Acquisition Act, the company for whom the land is being acquired is entitled to appear and reduce evidence for the purpose of determining compensation. Since the company for whom the land stands acquired on the same footing as a local authority, whatever has been said with regard to a local authority would apply to a company. It is, however, made clear that the matters which stand finally concluded are not reopened. To sum up, our conclusions are: Section 52 of the Land Acquisition Act confers on a local authority for whom land is being acquired the right to appear in the acquisition proceedings before the collector and the reference court and deduce evidence for the purpose of determination of the amount of compensation. 2. The said right carries with it the right to be given adequate notice by the collector as well as the reference court before whom acquisition proceedings are pending on the date on which the matter of determination of compensation will be taken up. 3. Proviso to Section 52 only precludes an authority from seeking a reference, but it does not deprive the local authority which feels aggrieved by the determination of amount of compensation by the collector or the reference court to invoke the remedy of Article 226 of the Constitution as well as the remedies available under the Land Acquisition Act. In the event of denial of the right conferred by Section 52 on the account of failure of the collector to serve notice of the acquisition proceeding, the local authority can invoke the jurisdiction of the High Court under Article 26. Even when such a notice is been served on the local authority, the remedy under 226 of the Constitution would be available to the local authority on the grounds on which judicial review is permissible under Article 226. The local authority is a proper party in the proceedings before the reference court and is entitled to be pleaded as a party in those proceedings wherein it can defend the determination of the amount of compensation by the collector and oppose enhancement of the said amount and also reduce evidence in that regard. In the event the enhancement of the amount of compensation by the reference court, if the government does not file an appeal, the local authority can file an appeal against the award of the High Court after obtaining leave of the court. In an appeal by the person having an interest in the land seeking enhancement of the amount of compensation awarded by the reference court, the local authority shall be pleaded as a party and is entitled to be served notice of the said appeal. This would apply to an appeal in the High Court as well as this court. Since a company for whom the land is acquired has the same right as a local authority under section 52, whatever has been said with regard to local authority would apply to a company also. So, and then below the matters. So below that is a principle of law.
Yes.
And therefore, below your lordship will note here, the court even says that even though you have been put to notice, and then below, you still have a right to come and file a 226.
Yes.
So below, this is the reference to 226 is done for the purpose of for a curative purpose. The procedural flaw where fair hearing is not given, for to remedy that, my lord, the court has said the access to 226 remains open. And your lordship saw also that under 52 under the State Act, it was a local authority, but that has been interpreted to include even a company.
Yes.
So my lord, those broad principles, your lordship will bear in mind.
Yes.
Then my lord, your lordship will come to my lord, page 179. Well, this is, well, there are two judgments I'm going to cite here. This is for the proposition, your lordship, that query. You were not in existence at the time of acquisition. You were not there at the time of reference. You come in at a much later stage. So what is your locus? Locus for either, that would be a locus with regard to even filing an appeal or even for the purpose of a writ petition. Now, this is the proposition.
Yes.
Now, please see, this is the 2002-3 SCC 228. Please see, page 181, para 2. Under notification dated 19/7/1981, issued under section 4 of the Land Acquisition Act, the state of Kerala acquired land for the benefit of the Public Health Engineering Department of the state government. On 27/8/1982, possession was taken over the acquired land. Sometime in June 1983, a declaration under section 6 was made. The collector initiated proceedings for assessing the amount of compensation payable and made an award on 15/6/1986. The claimant sought for a reference to the civil court seeking enhancement of quantum of compensation which was made. These reference applications came to be decided by different awards made by the civil court between 1989 and 1991. With effect from 1/4/1984, the state of Kerala, through an executive order, constituted the Kerala Water Authority as a statutory corporation. The Kerala Water Supply and Sewage Act, which was given a retrospective operation with effect from the date of 1st of March 1984, declared Kerala Water Authority to have been constituted under the Act. The state of Kerala and the Kerala Water Authority preferred appeals, laying challenge to several awards made by the civil court and for enhancing the amount of compensation. During the pendency of the appeals before the High Court came the Constitution Bench judgment of this court in UP Awas Nigam, wherein it was held that the company for whose benefit the land was acquired was also entitled to appear and deduce evidence for the purpose of determining compensation. One of the grounds which persuaded the Constitution Bench for forming that opinion was that the amount shall have to be paid by the local authority and therefore it was a proper party entitled to contest the proceedings. We need not reproduce in extenso the law laid down by the Constitution Bench. For our purpose, it will be suffice to know that in the opinion of the Constitution Bench, the right conferred on the local authority under section 52 of the Act is in the light of the scheme of the Act carried with it the right to be given adequate notice by the collector as well as by the reference court before whom acquisition proceedings are pending of the date on which the matter of determination of compensation will be taken up. The local authority is a proper party to the proceeding before the reference court and is entitled to be implemented as a party in those proceedings wherein it can defend the determination of the amount of compensation by the collector and oppose announcement of the said amount and also adduce evidence with regard to in the event of announcement of amount of compensation by the reference court. If the government does not file an appeal, the local authority can file an appeal against the order of the High Court, order in the High Court after obtaining leave of the court. The Constitution Bench, however, added a rider to its judgment that the law laid down by it does not have the effect of reopening matters. Then it cannot be doubted that on 20/10/1994, the date on which the Constitution Bench delivered the judgment, matters relating to the compensation of the present case had not achieved the finality and had not stood finally concluded inasmuch as the same were pending in appeal in the High Court, and appeal is a continuation of the original proceeding. So far as the award given by the collector is concerned, that can be said to have become final before the date of decision by the Constitution Bench, but not the award given by the Civil Court on reference. The High Court in the review judgment formed an opinion that the law laid down by the Constitution Bench governed the cases at hand, and therefore the award given by the Civil Court on reference to vitiated for want of notice to KWA. The High Court allowed all the appeals pending before it and remanded the matters for decision afresh by the reference court after affording the parties an opportunity of adducing evidence in support of their respective contention. Feeling aggrieved by the order of remand, the claimants have filed these appeals by special leave. Shri P.L.B. Iyer, learned senior counsel for the claimants, has submitted that the Kerala Water Authority is a successor of the Public Engineering Department of the state government that is bound by the proceedings conducted by or against the state government, and therefore the Constitution Bench decision does not have any applicability onto the facts of the present case, and the High Court ought not to have set aside the awards and remanded the cases to the reference court. We find it difficult to subscribe to the view so forcefully canvassed by the learned senior counsel for the appellants. KWA came into existence as a statutory corporation on 1/4/1984. It may be said to be have succeeded as to the liability incurred by the state government so far as the quantum of compensation awarded by the collector is concerned. But so far as the enhancement of the compensation of the government is concerned, it will be the liability of KWA incurred by it after its coming into existence, and therefore, to the extent of enhancement, the authority was entitled to notice the right to participate in the proceeding before the reference court, leading to the enhancement of compensation. Learned counsel for the claimant appellants also submitted that superintendent engineer of KWA appeared as a witness in the proceedings before the civil court, and therefore it can be inferred that the authority was aware of the proceedings. If it did not promptly take steps for implement, it should not have been heard to complain before the court, High Court, that it did not have notice of the proceedings and that it was denied participation in the proceedings before the civil court. It has been held by this court in the Agra Development Authority that where the land was acquired at the cost of the local development authority, a notice to it was mandatory, and simply because the local authority was aware of the proceedings and had participated in the meeting where the matters were of compensation were discussed, was not a sufficient compliance with Section 50 of the Land Acquisition Act. In our opinion, the High Court has not erred in taking the view which has taken and directing the reference court to be remitted to the civil court consistently with the law laid down by the Constitution Bench, as KWA shall have to be implemented as a party to the proceedings before the civil court. From the very beginning, a retrial becomes unavoidable. And then, my lord, the directions are given at para 11. I will not read that. So, my lord, your lordship notices here, para 8, your lordship found that that was the case where the official stepped in as a witness, and there is a formal requirement. So, my lord, the SLAO or a particular officer does not represent the state or the corporation. So there is a requirement of formal notice. That's a square and simple. So in para 7, your lordship saw that this argument was made that you came into existence later on. Yes. Now, then the next judgment is a division bench that has persuasive value. That's at page 185. It's a division bench of the Bombay High Court. Here, I'll just just please see, my lord, page 187. Just people also do the facts. Para 2. The facts giving rise to the present appeal fall in a very narrow compass. Appropriate government issued notification under Section 4 of the Land Acquisition Act, which was published on 31st March 1983. In furtherance of this notification, declaration under Section 6 of the Act was issued on 31st of October 85. Lands were acquired from the landowners and the possession thereof was taken on the 10th of December 85. SLO made the award on 30th November 1987 under Section 11. The award of the collector was challenged by the claimants by filing petitions under Section 18 of the Act. These references were referred to the SLO by the SLO to the Court of Competent Jurisdiction. The Joint District Judge Nashik, by his judgment dated 7th April 95, passed the land reference number so-and-so, enhanced the compensation payable to the claimant at the rate of so-and-so to so-and-so. Some of the claimants who had not preferred references under Section 18 of the Act filed petitions before the SLO under Section 28 of the Act. These very claimants have even filed writ petitions before being writ petition so-and-so, which was decided by this court by order dated so-and-so, requiring the government to hear the petitions in accordance with law. Writ petition was disposed of the direction to decide the application under Section 28A within 6 months. Application filed by the petitioners under Section 28 of the Act was finally disposed of by the SLO by judgment dated 20th September 2003, enhancing the compensation and placing the claimants at parity with the judgment of the district judge dated 7th April 1995. Aggrieved by the award of the SLO dated 20th September 2003, the corporation preferred the writ petition before this court, which came to be dismissed by order dated 29th of November 2005, giving rise to the present appeals. The corporation had filed different writ petitions, 18 against different claimants. Separate appeals have been filed against the judgment of the learned single judge in those writ petitions. Thus, by this judgment, we will dispose of the 18 appeals preferred by the corporation, challenging the correctness and legality of the order of the learned single judge dated so-and-so. The writ petition filed by the corporation were primarily dismissed by the learned single judge on a very short ground. It is useful to refer to the relevant part of the impugned judgment, which reads as under. The possession of the land was taken by the government on 10/12/85, and an award was declared by the SLO on 30/10/1987. Thereafter, the reference was made by some of the affected persons under Section 18, and the same was decided by the Civil Court by passing an order and judgment on 7/4/1995. Admittedly, the petitioner came into existence only on 1st of October 1998, as mentioned in para 1 of the petition. Thus, the petitioner was not in existence till the entire acquisition proceedings was completed and till the enhanced compensation is awarded by the Civil Court under the provisions of Section 18 of the Land Acquisition Act. In that view of the matter, the contention of the learned counsel for the petitioner that the purpose of giving a similar benefit to other parties who are also affected by the same award under the provisions of Section 28A, petitioner ought not to be heard and has no merits. Petitioner is not concerned with the acquisition proceedings which have been completed prior to the incorporation of the petitioner. Therefore, contentions raised by the petitioner are without merits. In that view of the matter, there is no substance in the present petition. Petition is accordingly dismissed. In view of the dismissal, so and so. Now, as evident from the above recorded findings, it is clear that the genesis of the impugned order is that the corporation came into existence subsequent to the passing of the judgment on 7th of April 95. It has no locus standi or right to be heard by the SLO before whom the petitions were filed under Section 28A. The original award made by the SLO on 30th of November 1987, awarding compensation of 6,500 to 12,500 per hectare for acquisition of land of the claimants depending on the nature of the potential of land. As already referred, the said compensation was announced by the reference court by its judgment dated 7th April 95 to rupees 24,000 to rupees 40,000 per hectare. The present respondent number 2, 18 and all, have filed petitions under 28 of the Act between the period 7th of August 1995 to 21st September 95 after the pronouncement of the award by the Joint District Judge Nashik. SLO granted relief to the claimants, landowners, and awarded the compensation payable at the rate of 24,000 to 40,000 per hectare, depending on the nature or the potential of the land. Learned single judge has not touched on the merits of the case, but has only proceeded on the basis that the corporation was neither a necessary nor a proper party for the reason that they came into existence subsequent to the order passed by the Joint District Judge Nashik on 7th April 95. Thus, we have to examine whether the corporation could be a necessary or a proper party to such proceedings. The Supreme Court in the case of Neyveli Lignite explained the term person interested After some discussion and reference to law, the court held that the local authority or the company for whose benefit the land is acquired is a proper, if not a necessary party within the meaning of Order 1 Rule 10, and thus have a right to participate in the reference proceedings under Section 18 and held as under. I have skipped that portion, my lord. Then, my lord, para 8, Abbas Nigam. Yes, my lord, I'll skip this. Please come to para 11. But they have referred to the judgment which we already covered. From the above such legal principle of law, it is clear that the corporation or a company for whose benefit the public purpose of the land is acquired by the state would be a proper party entitled to participate in the proceedings at all relevant stages. Determination of compensation is not only confined to the proceeding before the collector and the reference court, but it extends to proceeding before the appellate court or any other forum in accordance with the provisions of the Land Acquisition Act, provided the issue relates to determination and or enhancement of compensation. Section 3B of the Act explains and defines the word person interested. The said expression is stated to be inclusive of all persons claiming an interest in compensation and compensation to be made on account of acquisition of the land under this Act. And the person shall be deemed to be interested in the land if he is interested even in the easement affecting the land. Section 9 of the Act also refers shall require all persons interested in the land to appear personally or by agents before the collector. Section 11 also refers to this expression in somewhat distinct distinction to the expression used earlier. Section 18 refers to any person interested, thus indicating the wide and liberal meaning of this expression is intended to be given by the legislature in different provisions of the Land Acquisition Act. The body, corporation or company for whose benefit the land is being acquired, being a proper party, would be entitled to the notice and implement in the proceeding before the authorities and reference court, even in the appellate court, the appeal being a continuation of the original proceedings. Merely because the corporation is a successor or is created legally or technically on a date subsequent to the pronouncement of the award by itself cannot be a ground for holding that the said corporation or a company would not be entitled to similar right and obligations as are contemplated in the acquisition laws. The proceedings before the SLAO under Section 28 of the Act are fresh proceedings for awarding of compensation, and the collector is under an obligation to give notice to all interested persons in terms of 28(2) of the Act. In the present case, right from the beginning, the land has been acquired for a public purpose, namely the Kadava project, and in continuation of the same public purpose, a corporation was established by the state, being the Godavari Marathwada Irrigation Development Corporation by a legislative act issued by the competent legislature. Merely because this corporation was established in the year 1998 and the award of the joint district judge was passed on 7th of April 95, per se cannot be a ground for rejecting the claim of the corporation or being heard before the SLAO or the proceedings under 28A or in the appeals if preferred against the judgment order of defense. Then, Lord, please come to para 14. Abdul Razak, Lord, which I have already cited, the first judgment that is taken note of. And then, Lord, come, please see para 16. This can also be examined from another point of view. Under Order 22, Rule 10 of the CPC, the party is entitled to assign its rights in a legal proceeding to a third party during the pendency of the original proceedings or even after passing of a decree in appellate proceedings. Of course, this has to be done with the leave of the court. Once the leave of the court is granted, the proceedings can be continued by an assignee. The stage of the proceedings is irrelevant insofar as other requirements of these provisions are satisfied and the leave of the court is obtained. The corporation has come into existence by virtue of a legislative act and not a contractual act. The corporation would be entitled to be implemented into the proceedings from the date of its existence and would be entitled to participate in the proceedings which are instituted thereafter or at the stage where they are pending. In the present case, petitions under 28A of the Act have been filed in the year 1995, while the corporation came into existence on or about 1st of October 1998, while the award has been made before the collector subsequent to the subsequent coming into effect on 20th September 2003. Thus, we are unable to accept the contention of the respondent that the corporation is neither necessary nor a proper party and cannot participate in the proceeding merely because it came into existence subsequently. As it has taken over all the rights and liabilities of the erstwhile department, it would be the exclusive responsibility of the corporation to pay enhanced compensation. It has every right to participate in the proceeding. For the reasons therefore stated, the appeals are accepted the judgment of the learned single judge as well as the award date shown. are set aside, matters are remanded to the special land acquisition officer for taking proceedings in terms of section 2080 of the Land Acquisition Act. After implement of the appeals are disposed of accordingly, no others does. So the Lordship notices that here in the writ jurisdiction, the court has set aside all those orders. So, my lord, this was an exercise of power under 226. So, my lord, this follows the principle of law that the Supreme Court has laid down, and the concept of assignment. My lord, your lordship, in this particular case, one pertinent question that your lordship can ask also is that while we were incorporated as an executive order of the state government in exercise of its executive power, established a government company. The question of a lifting of a veil does not apply because we are a government company. And under the Companies Act, it has a distinct entity, but it has all the trappings of a conventional company. And Lord, I'll take your lordship through those documents, the articles and memorandum. It gives me the right, Lord, first of all, the property is vest in me as the owner, and I have the right to even sell, lease, assign these properties for the purpose of raising revenue. Lord, this is, Lord, I noticed what your lordship, Lord, this is part of the policy of a receding state. Lord, he could not have imagined that Karnataka was way ahead of its time. Even on something like irrigation projects, the state realized that it could do very well by creating a corporate entity so that the government funding does not get diverted to these kind of projects. You innovate, and I will also show that the Irrigation Act was amended to enable us to collect levy, the water cess, etc. That was part of that process. So whether you are established by an act of the state legislature, whether you have incorporated a company under the government company under the Companies Act, these are methodologies that makes no difference. As long as the property is vested in me and the compensation is liable to be paid by me. If your lordship recollects, in the initial stages, I pointed out that when it comes to execution, they are at our doorstep. They attach our properties. So, the state may give us funding, they give us grant which are converted into equity. So, that is how this project, we function. It gets converted because the government is the majority, is the sole stakeholder in this company. And therefore, we need to take care of this funding. We also borrow from other financial institutions. That is how we raise funds. And a major part of our expense is land acquisition cost. So, therefore, if the answer to that is, sorry, we will not be proceeding against you. We have nothing to do with you. We will execute your orders against the government. Then I have nothing to worry about. I have no concern. But if it is admittedly so that I have to bear the compensation cost, then I have to be heard. I have a right to be heard. They should have made me a party. So that is a principle, and that's the entire thread of all these reasoning proceed on that basis. If you pay compensation, you have a right to be heard. Whether you are a proper or necessary party makes no difference. I have a right to be heard. I have a right to file an appeal. I may not have the right to seek a reference, but yes, I have a right to file and challenge the adjudication. I have a right to lead evidence. So all those rights are available to me, repeatedly, the reference to Neelagangabai's case is referred, that is the next step, but I'll read this. And I'm thinking, I'm sorry, it's already 6 o'clock,
How much more time will you take?
I need to.
You said 1 hour, so you thought we'll sit through and finish it.
I don't want to hold. What I can do is, 29 suits be subject to your lordship's convenience.
Already 74 matters posted on that day.
So I can come down for that.
Already 74 matters are posted on that day. But again, we can sit through a little later in the evening and take it up. How much longer will you take? I'm only addressing today on the maintainability and I'm not taking your lordship to the merits at all. So I will not on merits.
Not on the merits. So, what should be? So, what I can finish it another. I have to. I won't be able to finish today, even if your lordship. I post.
How long will it take?
I'll take about another hour.
An hour. An hour is an hour, hour and a half.
Oh, no, no, not more than an hour. I know, but make it a
Then
point.
we'll have it on 29th at 4 o'clock.
Yes.
You can come at
Very
4 o'clock.
well.
Then thereafter, we'll,
The learned AG can.
then learned AG.
Yes. Because we don't get parties. Lord, I'll produce that also. Lord, I'll give you, I'll show you a lot. My Lord,
Mr. Reddy, you can make the submissions after the learned Advocate General makes his submissions. All of you are entitled to make your submission. We'll hear all of you in turn. 29. You can come later. Till 29th, your colleague can make his notes. You don't need to respond on that day. After 29th, we'll have the Advocate General to make his submissions. Thereafter is your turn. So that may be a little while later. From 29th at 4 p.m.
ಇಲ್ಲಿ ಆಪ್ಷನ್ ಇಲ್ಲ. ये पृथ्वी शुक्रवार में